Just a quick announcement for everyone. It is 8:27. In 3 minutes, we are scheduled to restart. So just FYI, we are about 3 minutes away from starting. The time being 8:30, recess has expired. We are on the record. This is the evidentiary hearing in file number EO-2022-0061. This is Evergy, Missouri West, request for a special high load factor rate. At this point in the hearing, we are beginning the re-cross-examination of Mr. Darren Ives of Evergy, Missouri West. And Mr. Fisher was questioning him, and then I stated we are going to go back through re-cross-examination for the limited purpose of questioning about what has been called the EDR language. I believe that's all the introductions we need. Mr. Fisher, your witness, and Mr. Ives, I would remind you that you were sworn in yesterday, and that still applies.
Judge, just one question. I think you said Mr. Fisher was doing recross on Mr. Ives.
Redirect, thank you. I misspoke. Again, I'm much better in writing than I am live. Mr. Fisher will be finishing his redirect. Mr. Fisher, the floor is yours.
Thank you, Judge. Mr. Ives, when we left off last night, I believe I had a document marked as Exhibit 7. Do you have that exhibit in front of you?
I do.
Could you explain what this exhibit is?
Yeah, just briefly, because I know I talked about it a little bit earlier yesterday, but this exhibit is a response to what we saw come in the OPC, MECG, and staff stipulation around the position for EDR and having to be off of an EDR for 5 years before you could adopt Schedule MKT. I mentioned yesterday that it's a company and Velvet's position that it likely takes the combination of both the EDR availability and a rate like the Schedule MKT rate to work for these high load factor customers that experience a relatively long ramp of bringing their load online. So this schedule really says you could take the schedule PED in advance of moving to the market rate, but would be required to move to the MKT rate at the earlier of 2 years after being on the schedule PED, or when your average monthly peak load exceeded 50 megawatts, recognizing that's the average monthly peak load, but you're going to start at virtually zero on day one when you join that PED and ramp from there. But it sets it at 2 years, and then at the end of this language, it says, if a customer decides to stay on the PED past that trigger, that 2 years or the average peak load of 50, then if they wanted to move to schedule MKT, they would have to be on a regularly available rate and precluded from that MKT rate until they were off of the PED for the period of time that they extended. So let's just say, quick example, instead of doing 2 years, they went 5 years on the PED, so they would have extended by 3 years. This schedule would say they have to be on a regular embedded cost tariff rate for at least that 3 years that they extended before they could move to schedule MKT.
Are you suggesting that this language or something very similar would be included in a tariff? Is that where this would go? Or,
Yes.
okay. Judge, with that, I would move for the admission of Exhibit 7, and as I understand it, I could tender the witness for additional cross on this exhibit.
Yes, that's how we're going to proceed. I'll go ahead and deal with Exhibit 7 presently. Are there any objections to the admission of Exhibit 7 onto the hearing record? Hearing none, it is so admitted. Since we are dealing with the language that we discussed through last night on how to proceed, we're going to go back to recross on the Exhibit 7 language. So I will go to my handy cheat sheet, and on cross, first we come to Velvet Tech. Counselor Bell, did you have any questions?
This is Mark Ellinger. At the moment, we're having a slight technical issue. Could we pause for just a second to allow Ms. Bell to reconnect?
Absolutely, not a problem.
No questions, Your Honor.
All right, thank you. That was a little soft. Ms. Bell said no questions. We'll go to Mr. Mills with Google. Any recross from you?
Thank you, Judge. Just a few. Mr. Ives, in looking at the language that we're discussing here, where it says the economic development rider, is that referring to Schedule PED?
Mr. Lewis, you cut out on us. Could you repeat your question? I'm sorry for the interruption.
Yes, in the language that has been admitted into the record as Exhibit 7, it refers to economic development rider. Is that Schedule PED?
Yes, that's the intention.
Okay. Were you, I'm sorry, were you involved in the drafting and adoption of Schedule PED?
Yes, intimately.
Okay. So Schedule PED is effectively Evergy's attempt or Evergy's implementation of Section 393-1640. Is that correct?
That's correct.
Is there anything in Section 1640 that indicates that the legislature had an intention of limiting the use of other lawfully applicable tariffs once a customer had taken advantage of the provisions under Section 1640? I'm sorry, Section 393-1640.
No, not that I'm aware of. I think I mentioned that yesterday, maybe in response to you, Mr. Mills, but I'm not aware of any such limitation.
Okay. At the time that Section 393-1640 was promulgated and passed into law, was the statute that gave rise to Schedule SIL already in effect?
Well, there was the.
And perhaps
I would just say, go ahead, Mr. Mills.
perhaps to refresh your recollection, that's 393-355. It was initially passed with a limited time period and then reauthorized. Does that help?
Yeah, I believe that's right. I was pausing because there's really not a statute that gave rise to Schedule SIL. Certainly, some of the characteristics were similar, but we didn't file for Schedule SIL under 393.
Okay, that's a good point. Thank you. But nonetheless, there was at the time that the legislature passed 393-1640, other statutes that would offer customers significant discounts, and the legislature chose not to restrict the use of 393-1640 in any way.
That's correct, and we might have talked yesterday as well. I mean, there are also other special contract tariffs in place that would have been in place at that time as well.
Right. So there are any number of other discounted mechanisms that a customer could use once the ability to use something like Schedule PED under 393-1640 had expired.
That's correct.
And the legislature would have been aware of all of those.
That's correct.
Okay. No further questions.
Thank you, Mr. Mills, and I was remiss in a couple of announcements. We will be breaking at 10 o'clock until 11 o'clock, and that will accommodate today's agenda session. And also, speaking of the commissioners, we had all of the commissioners online for the hearing yesterday, and this morning we have three. We have Chair Sylvie, Commissioner Coleman, and Commissioner Kolkmeyer online. I do expect Commissioners Holzman and Root to be joining us shortly. Those were my forgotten announcements. Let's proceed.
Commissioner Holzman's on, Judge.
Oh, I'm sorry. Commissioner Holzman is on.
Thank you.
Thank you, Commissioner. Let's proceed then with our recross examination on Exhibit 7. Mr. Witzmal.
Good morning, sir. Can you hear me?
I can hear you.
Mr. Mills contemplated a couple of my questions. The first one, just to clarify, you mentioned economic development rider, and I believe through questioning, you mentioned that that was supposed to refer to Schedule PED, is that correct?
That's correct.
Okay, does Evergy West also have a tariff called economic development rider that's independent of PED?
We do have such a tariff. It's obviously, it operates at different thresholds than Schedule PED.
So would this provision apply both to the economic development rider as well as Schedule PED?
It was intended to, and not written as probably tightly as what is in the MECG, OPC and staff stipulation, but intended to address the 393 and the Schedule PED.
Okay, so it's not meant to address any situation where such a customer receives a discount under the independent economic development rider. Is that true?
That's true.
Okay. Would you intend to expand this to include both the EDR as well as PED?
I didn't intend that. I intended to find middle ground between the two stipulations and the OPC and party stipulation address the 393, which would
Okay.
be the PED.
Okay, that's clear. Now, just to run through an example, it is my understanding that in order to ever receive the PED, you must request it prior to taking service. Is that right?
Yeah, I believe that's correct.
Okay, so the PED would start on day one when they use their first kilowatt hour of electricity. Is that correct?
That's correct.
Okay. And
Married with, just to make sure that everybody understands, I know you do, Mr. Woodsmall, but applied to a standard available rate in this customer, in a customer's like this circumstance, it would be the large power rate.
right, but what I'm trying to get to is a customer couldn't take service under the large power rate without the discount for a couple years and then say, okay, now I want to kick in the economic development rider discount.
That's correct. And there's also language, and I know you didn't ask this, but just to be clear, there's also language that says they couldn't take it stacked with the MKT rate in the tariff proposals from both parties, or both competing stipulations.
Okay, so the customer, I guess I'll call them a potential MKT customer because they're not MKT yet. But the potential MKT customer comes in, day one, they start receiving service under the large power rate with the EDR discount. And that goes along for 2 years. Now, I assume that they could switch to MKT before 2 years. Is that their option?
Yeah, I believe that would be kind of a standard best fit option that the customer could do.
Okay, and so otherwise, they continue on LP with the EDR discount, and then at 2 years or hitting 50 megawatts, that's when they have to make a decision. It's the earlier of those two events. Is that correct?
Yes, sir. It's earlier of those two triggers.
Okay, and now getting some clarification to what Mr. Mills was talking about, this does not limit the customer's ability to receive the PED discount, does it? I noticed on the fourth line.
For the additional term, Mr. Westfall?
Right.
It does not. It says if they don't move to schedule MKT when they hit the earlier of those triggers, but they stay on the schedule PED, then there is a limitation on when they can begin on the schedule MKT.
Okay, and that's that fourth line, if the customer remains on the economic development rider, so they always have the option to keep the EDR discount for the maximum statutory 5 years, is that correct?
That is an option that they could avail themselves of, knowing that they can't immediately move to schedule MKT in that circumstance.
Okay, and just to kind of draw an analogy, are you familiar with the MIA statute?
I am familiar generally.
Well, let me ask more specifically with the MIA opt-out provision.
Yeah, I don't have that language in front of me, but I'm familiar with the opt-out generally, yes.
Okay, and just to analogize, if a customer, certain customers have a legal right to opt out, is that correct?
That's correct.
But if they take a MIA refund, they are not allowed to opt out right away, is that correct?
That's correct.
And so I see somewhat of an analogy here. If you take this discount for more than 2 years, then you can't immediately opt into the MKT tariff. Do you see some analogy there?
Yeah, I mean that's the way it's written, is to just ensure that if you overextend that past that trigger, that the customer recognizes that they can't immediately opt into MKT. They would have to go on to a generally available rate for at least the length of time that they overextended that trigger.
Okay, last question. On the third line, you talk about the second trigger, if you will. You talk about customers' average monthly peak load exceeding 50 megawatts. Do you see that?
Yes, sir.
Over what period of time would average monthly peak load be calculated?
Well, the intention and the way it's written is over that period that they're on. So it would, if you took the full 2 years, it would run to the full 2 years. And it's intended to tie back to that 50 megawatt threshold that's in the availability section of the tariff.
Okay, so it wouldn't be calculated over just a 12-month period. It would be calculated over a potentially rolling 2-year period?
Well, I wouldn't say rolling. It would just be that 2-year period, right? Because if they haven't hit the 50 by that 2-year period, the 2-year trigger would suggest they need to move.
Okay. While I don't like it, I understand what this means now, so I appreciate your clarification. Thank you, sir.
Thank you.
Thank you, Mr. Witz-Small. That takes us to staff. Mr. Keeble, any questions?
Yeah, very briefly, Mr. Ives, before you proposed this language yesterday afternoon, what other parties, if any, had you discussed this language with?
A form of this language at somewhere within the meetings that all parties had that got us as close on these two proposed tariffs as we are, discussed a form of this.
Yeah, that's not what I asked, Mr. I said this language, this specific language.
I think it's a specific language, to be honest.
You discussed this with Velvet prior to proposing it?
I think every party to this proceeding had a discussion on this language at some point. But Velvet certainly saw this language as well in advance of the proposal.
So are you talking about settlement discussions again, Mr. Ives?
I'm talking about technical conference meetings, just like what we heard yesterday when that was the only forum that parties heard that OPC staff and MECG had a concern in this area.
Well, Mr. Ives, let me ask, I don't know how to make this question any simpler, but you apparently don't want to answer it. This language, was this approved by Velvet prior to your proposal yesterday?
I would not say approved. It was discussed with them, and I think everybody has seen it at some point.
I'm not asking about everybody now, I'm asking about Velvet. Did you run this by Velvet before you proposed it yesterday?
I've answered
It
that.
answered.
What was the answer? That's a yes or no question, Mr. Ives. Is the answer yes or no?
Well, what specifically is your question?
Did you run this language by Velvet before you proposed it yesterday?
Yes.
Okay. Did you run this language by Google before you prepared it yesterday?
Judge, I'm going to object to that to the extent that the phrase "run this by" is unclear to me. Could we ask counsel to rephrase that?
I don't think it's unclear at all, Judge.
I have to say, I am also not confused. Did you show it to Google? Did you send it to them? Did you
Well,
wave it at them? Any of those?
Judge, if that's the question, then I'm going to object that it's asking about what happened during settlement discussions. And
Okay.
that is privileged and it's an improper question seeking to ask the witness to divulge privileged settlement discussions.
This is not settlement. He dropped this exhibit as an exhibit at the hearing. I agree this should have been covered in settlement, but it was not. Rather, Evergy has chosen to use the hearing process as their means of settlement. And this is not a settlement document. This is a hearing exhibit.
The document is, what Mr. Keevil is asking about is what discussions that Evergy had with other parties prior to the hearing about this language. And those are by definition settlement discussions, and they are privileged.
I'm not asking for what Google discussed. I'm asking if Mr. Ives showed this language to Google.
If
What
Google
settlement
is
offers
saying that
were
that's-
made are privileged. Whether or not the party accepted those offers is also privileged, but the fact that an offer was made is a privileged matter. And I'm sure Mr. Keevil understands that, and I don't know why we're still banging on this.
We're not, Mr. Bills. If you are claiming that this is part of settlement discussions, you are an officer of the court. I'm going to take that at face value.
If Mr. Mills is claiming this is a settlement discussion, then I assume that means it was discussed, but, so.
I would not have made that assumption, but I'm not a lawyer in the case.
All right. No further questions.
Okay, thank you, Mr. Keevil. Mr. Kleiser, witness is yours.
No questions. Thank you, Your Honor.
Excellent. Mr. Ives? Let me see if there are any commissioner questions. Are there any commissioner questions for Mr. Ives on the Exhibit 7 language? Okay, Mr. Ives, you are excused. Let us
Judge?
move. Yes, go ahead.
Judge, do I have an opportunity for just a very limited redirect on this line across? Or not?
We're this far in, Mr. Fisher, and if you say it's going to be very brief, I'll allow it.
Oh, thank you, Judge. I just have a very brief questions regarding that last exchange. Mr. Ives, when was the first time that you learned there was a, what I'll just call an EDR issue with the Staff Public Counsel and MECG?
Objection, Your Honor, because
Yeah.
if Mr. Mills is right about this being settlement discussions and privilege, so's this.
Mr. Fisher, can you tell me what relevance the timing would have? Because the only thing I would see is whether it comes into settlement or not.
Let me withdraw the question if it's controversial, Judge.
Thank you.
Mr. Ives, was the EDR issue filed in any testimony in this case?
No, to my recollection, it was not in any materials for this case until it came into the case docket in the non-unanimous stipulation of OPC, MECG, and staff.
So you had no opportunity to raise this language until now?
I had nothing to respond to in the record until it came in the stipulation.
Thank you, Judge. That's all the questions I have.
Okay, thank you. Mr. Ives, you are excused. Mr. Brubaker, if you would please speak up on WebEx, and I will swear you in.
Yes, good morning. Good morning, Judge. Am I coming through okay?
Yes, you are. The other two Evergy witnesses are tentatively scheduled for 10 a.m. This morning, which her first availability, which of course will be in recess. And then Ms. Hadaway, I believe we were told would probably be available afternoon. So I'm going to go ahead and go through the witnesses, and then we'll circle back to those two and kind of cross that bridge when we get there. Okay. Mr. Brubaker, do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Would you please state and spell your first and last name for the record?
Yes, my name is Morris Brubaker, Maurice Brubaker.
Thank you. And Velvet, your witness.
Mr. Brubaker, who are you employed by?
By the firm of Brubaker and Associates Incorporated.
And did you cause to be filed in this case what has been marked as Exhibit 300, the surrebuttal testimony of Morris Brubaker with 4 schedules attached?
I did.
Your Honor, I'd like to offer Exhibit 300. And there is a public and a confidential version.
Thank you. Exhibit 300, the confidential and public version has been offered for evidence into the record. Are there any objections? Hearing none, it is so admitted. Go ahead, Counselor.
I tender the witness for cross.
Thank you. And according to my list, this first cross will go to Evergy.
Thank you, Judge. I just had a couple questions here, a few. Mr. Brubaker, would you turn to your page 2 of your surrebuttal testimony?
Yes, I have it.
There on line 18 and 19, you mentioned that Velvet conducted a multi-state search for a suitable location for a new $800 million enterprise data center. Is that right?
Correct.
Would it be correct for me to conclude that Velvet looked in other states besides Missouri for the possibility of locating their $800 million facility?
Yes, it would.
Let's turn to page 3 of your testimony. And beginning on line 8 through about line 13, you mentioned that if the schedule MKT presented by Mr. Ives is approved by the commission, then Velvet can have confidence that the rate structure in place in Kansas City will provide competitively priced electricity. Is that correct?
Yes.
Why is that important to Velvet?
Well, electricity prices are a very important input. I'm sorry. Okay, important component of the cost of operating a data center. And so the price that the data centers pay for electricity is critical in the overall decision-making process as to where facilities will be placed. Also for Velvet, it's important to be able to access renewable energy in the market. And Velvet has pledged to acquire enough renewable energy in the SPP footprint to serve its entire energy needs. So the schedule MKT includes a mechanism by which that can be accomplished by pricing the power to Velvet from Evergy at the SPP hourly market price. And that allows Velvet to kind of mirror that against some independently acquired renewables.
That was my next area of question. On page 3 at the bottom of your page, on line 22, you mentioned that Velvet has a commitment to support 100% of the data center load with new renewable energy resources located in the Southwest Power Pool footprint. Do you see that?
I do.
Would you explain how that will be accomplished? At your understanding, at least?
Well, there is probably more than one way to do it, but one way that would typically be done would be for Velvet to enter into a renewable purchase power agreement with a third party, which would mirror the pricing from the SPP hourly market, so that effectively Velvet would receive the renewable energy and also would receive compensation for the output of those facilities at the hourly market price, which would offset the price that they're paying to Evergy for the power. That minimizes the risk of a spread on the locational marginal prices. So that's a very important feature to this contract. In order to be able to proceed forward, it's my understanding that sorry about that, that Velvet needs to have some confidence that that structure would be in place. And if the commission approves the MKT tariff, they are reasonably confident that that will allow them to move forward. They'll still be subject to the actual contract, contract signing and presentation to the commission for the commission review and approval. So there's some risk there still, but it's my understanding Velvet is willing to accept that risk based on having Schedule MKT approved so they can move forward, knowing that there's an umbrella out there under which they can operate.
Is it your understanding that Velvet intends to support 100% of its load in Missouri with renewables?
Yes, that's the commitment they've made, and that's in their support statement that's attached to Mr. Ives' testimony, that they are committing to supply 100% of the energy requirements for the facility with newly constructed renewable resources in the SPP footprint.
If Velvet is required to pay the RESRAM in addition to that 100% commitment, would you understand that they would be paying more than 100% of their load would be supported by renewables? And
Yeah.
well, let me restate that. That was not clear. If they have to pay the RESRAM on top of this commitment that they will have 100% of their load supported by renewables, would it be fair to say that they are actually paying more than 100% of their load will be supported by renewables, including that RESRAM charge?
Yes, it would be basically 115%. That would be, if I can make an analogy, it would be sort of like going to a bring your own party and then having to also pay for a part of somebody else's refreshments.
I would like to also ask you to turn to page 4 of your Sir rebuttal testimony on lines 9 through about 11.
Yes, I have it.
There you say, I'm aware that Velvet has proposed a charge per KW to further the expansion of renewable energy for Evergy retail customers. This renewable surcharge will decrease the cost of Evergy ratepayers. Would you explain what you're talking about there?
Yes, the numbers are confidential. However, Velvet was interested in showing its good faith and making a contribution to the benefit of the system over and above just bringing their own renewables, and that's been called forget exactly what the term is, it's an amount of money they will pay through their regular rates, which would be then used by Evergy to compensate them for purchasing renewables.
That would benefit other non-Velvet ratepayers. Is that your understanding?
It would, because Velvet will have its own resources, and so these funds can be used to purchase renewable resources to benefit others, the rest of the system.
I think my last area is on page 10 of your Sir rebuttal. Would you turn to page 10 and look at line 5 through 7?
Okay,
There you're talking about the all relevant factors test that's usually applied to situations in which proposals are made to change existing rates. Do you see that?
I do.
Are you talking about general rate cases there?
I am.
What's your understanding of what it means to consider all relevant factors in the context of a rate case?
It usually means that you look at all things that could impact on the structure of the proposal or the decision or the rate and take those into account. It's like in rate cases, you may look at the cost of service, but then the commission always has other considerations beyond that, which they sometimes describe as other relevant factors.
So would it be correct that, for example, if the commission was looking at a proposal to impute revenues in the context of a special contract case, it would look at all relevant factors and whether it was in the public interest to do that?
Yes, I would think so. That would be consistent with that concept. The tariff comes in under, I guess, the general umbrella of economic development. And so recognizing that that statute was created for the explicit purpose of creating and stimulating economic activity in the Missouri service territory of Evergy, would seem that those impacts that would occur because of the economic development of other enterprises would also be a relevant factor into that consideration.
Is the existence of what's been referred to as an economic development rider or a PED important to Velvet?
I think it is. If you look at the whole process, as we talked about earlier, the multi-state research and the importance of electricity in the overall operation of an enterprise, we know that Velvet spent a fair amount of time looking for places to be negotiating with Evergy for a structure that they could live with. Anytime you're building a new enterprise facility, particularly one that's $800 million, there are lots of pieces that have to be coordinated and come together to make a deal workable. And certainly the economic development rate and its availability to them, along with the ability to access renewables through the market, are also important. So all those pieces together make the deal viable. The absence of one or more of those pieces, I can't say. It just would I can say it would make it much less viable.
Well, your Sir rebuttal testimony did not really discuss the importance of the economic development rate, did it?
No.
Why was that the case if it's important to Velvet?
At that point in time, was not aware that there were any issues about the application and availability of the economic development rate.
Judge, that's all the questions I have. Thank you very much, Mr. Brubaker, for your patience.
Thank you.
Thank you, Mr. Fisher, and that takes us to Mr. Mills for Google.
Judge, I have no questions at this point. Thank you.
Thank you, sir, and that takes us to Mr. Woodsmall.
Good morning, sir. Can you hear me?
Good morning, I can.
Just to try to work through this, first off, you are not actually employed by Velvet. You are simply retained by them for this case. Is that correct?
Yes.
And at what point in time were you retained by them?
Objection. It's irrelevant.
I'm trying to get at how long he has been working on this case, what firsthand knowledge he may have. If he's been working on this for 5 years, he's likely to have a lot more knowledge than if he's been working on it for 3 months. So I'm trying to determine when he first was retained.
I'm going to sustain the objection as to when he was hired, because in my mind, that might get into when has the settlement issue begun, when has negotiations begun, and I think you can still ask the other questions as to his firsthand knowledge.
Without divulging any settlement information, with nothing more than a date, when were you first retained by Velvet?
I'm going to renew my objection, and I also want to object that this could potentially implicate. I'll just sustain my objection on relevance.
Well, if it begins to implicate something other than the simple question, when he was retained, we can deal with that then. All I want to know is a date.
I'm continuing to sustain the objection.
Okay.
The witness is instructed not to answer with a specific date. I would think that a question, do you have more than 1 year of experience dealing with Velvet, might get to your concern about how much time he's spent. But
Okay.
let's stay away from specific dates.
Okay, let's work back through that. You filed this testimony on January 14th, which is 2-3 weeks ago. Do you have more experience than 2 or 3 weeks with Velvet?
Yeah, if that was a question, the answer is yes.
You have more experience than 1 month with Velvet.
Yes.
You have more experience than 2 months with Velvet.
Can we maybe expand that? I have an objection from the bench.
I don't know how else to get it other. You have more experience.
Try 6 months.
Okay, you have more than 6 months of experience with Velvet. So prior to August of 2021.
I do not.
Okay, do you have more than 3 months? I'm just trying to get a ballpark within a month.
That seems like a pretty close calculation to a specific date, which I just said I don't want.
Okay, so let's try to do it this way. Evergy filed its testimony in this case on November 2nd, 2021. Do you have more experience with Velvet than November 2nd, 2021?
Well, that would get,
I'm going to object. It's just irrelevant, and it could potentially implicate attorney-client communications and settlement communication.
I'm not going to go into attorney-client. If I do, please stop me. I just want to know when he was brought aboard so I can understand later because I'm going to go into this, how much of this is firsthand knowledge versus how much was related to him by other people.
Your Honor, I'm still going to object. I don't know why that's relevant.
I'll show you if he gives you, just tells me if he was retained prior to November 2nd, 2021.
And we're back to the question of a specific date, which I believe Your Honor's already ruled on.
I'm not asking him for a specific date. I'm asking him for whether he was retained prior to testimony being filed in this case.
And where are we at? He's been consulting for Velvet for over 3 months, but less than 6?
No, you didn't allow the 3 months.
Okay,
You allowed me to ask if it's more than 6 months.
okay.
He said no, so now I'm just trying, this is the last question to see
So he's over a month, under 6.
and whether he was retained prior to testimony being filed. Last question on that.
Judge, I do think Mr. Fisher asked Mr. Brubaker when he first became aware of the EDR issue being involved. So I do think how long Mr. Brubaker has been involved in the process is relevant for no other reason than for that. Because if Mr. Fisher's already opened up the, when did you first become aware of questioning?
But that goes to Mr. Brubaker's testimony. Was talking about the PED issue in his testimony, why it wasn't in the SIR rebuttal and why he was addressing it today.
Well, I want to split a hair here. The commission routinely looks into the background of the experts and consultants and their familiarity with what they're testifying about. However, I am sensitive to the settlement issue that has been brought up as to when Mr. Brubaker might have been brought aboard and how that would relate to settlement issues. So,
Your Honor, we weren't having settlement discussions on November 2nd, 2021. So whether he was retained before that date couldn't be settlement because I wasn't even in the case yet. There were no interveners. So there couldn't have been settlement.
I have already allowed that reasoning to apply to discussions between Google and Evergy. So I believe that the objection is settlements, discussions between two parties. So here I would see a similar, go ahead.
I don't want to get into settlement. There were no parties yet, so there couldn't have been settlement. I'm just simply asking, was he retained prior to the date the case was filed? And that's it. That'll be done with this line.
I'll allow.
I would renew
Mr.
my
Ritter?
objection, but yes.
Noted and overruled.
I don't remember exactly. I believe I had an inquiry as to whether I would be interested or available to assist with the filing, and then it progressed from there to further discussions. Whether that was before or after the exact filing date, I'm not sure. I think the discussions extended until after the filing was accomplished, the tariff filing.
Okay. Can you tell me how much you're being compensated for your appearance here today?
I'm going to object. That's irrelevant.
Financial bias of the witness is always relevant, Your Honor.
I agree. Mr. Brubaker, go ahead.
Sure. For this case, I'm being compensated at my regular hourly rate, as well as the hourly rate of other members of the firm that may be involved in the case.
And do you know how much you billed to date for this case? Your firm, not just you.
I'm going to object. That's irrelevant.
Your Honor.
Go ahead.
And it gets into attorney-client privilege information.
If you can tell me how that's attorney-client privilege, Ms. Bell?
Yeah, the amount that's spent relates to attorney-client work. And it also,
Your Honor, if I may respond, Ms. Bell's client is Velvet, not Mr. Brubaker. Mr. Brubaker is an independent consultant hired to present his opinion. He is not the client of Velvet.
Your Honor, Mr. Brubaker is retained through my firm for this case.
That doesn't make him your client any more than if I hired someone to testify about blood alcohol, an expert witness is my client.
I'm sorry, Ms. Bell, you're overruled. Your objection is noted for the record.
Can you tell me how much your firm has billed to date, Mr. Brubaker?
We have billed through December. I think I don't have an exact figure. It's in the range of probably $15,000 to $20,000.
Do you know, over and above that, any estimate of how much you will bill through the completion of this case?
I have no idea, no way to predict that.
Okay, so moving on, Mr. Fisher's questioning raised some questions for me. First off, on page 4 of your testimony, do you have that?
You do, yes.
You talked there about Velvet providing a renewable surcharge. Do you see that?
Yes,
When you put that commentary there, that is only referring to Velvet, is that correct?
correct.
So you don't know if Google or anybody else will take a similar position, do you?
I do not.
And do you know if this provision is included in the tariff anywhere such that a future MKT customer will have to make a similar arrangement?
I do not believe that it is.
Okay,
I'm
so
sorry, what was that answer?
would you repeat the answer, sir?
I'm sorry, I do not believe that it is.
Okay. So, to your mind, there is nothing that prevents a future MKT customer from taking service under this tariff without providing this renewable surcharge.
I think that would follow.
It would follow that they could take service under the MKT without the renewable surcharge.
Yes.
Okay. Moving to the page before, page 3. Let me know when you're there.
Okay.
On line 11, you talk about competitively priced electric service. Do you see that?
Yes.
Okay, when I think of competitively priced electric service, in my mind, you have to know competitively priced with what competitors. Is that fair?
Well, no, it would be by competitors. It would just be by alternative resources that could be applied.
Okay, so let's ask it this way. Who do you consider to be a competitor of Velvet?
Objection.
On what grounds?
It's irrelevant, and I believe Mr. Woodsmall is trying to get it at the identity of Velvet, which is irrelevant, and the identity of Velvet could potentially, it's irrelevant, first of all.
Your Honor, how can you determine if this price is competitively priced unless first you know who the competitors are, and then secondly, what they're paying for electricity? You know, otherwise it's just a statement. They opened the door by saying this is necessary to provide competitively priced electricity. Now, if we find out the competitor ABC pays 10 cents a kilowatt hour, then this isn't competitively priced. So they opened the door by making this statement, and I need to be able to ask questions about it. Now, if they want to withdraw the testimony, I'm good with it.
Remind me your question, Mr. Woodsmall.
On line 11, he talks about competitively priced electric service. To get at whether it's competitively priced, I'm asking him, who does he consider to be a Velvet competitor?
Judge, I'm going to object also because it assumes facts, not in evidence. He's assuming that competitively priced refers to competitors of Velvet rather than competitors of Evergy, which I believe is the more accurate interpretation of the testimony.
Judge, this is Jim Fisher. I would join in that objection. Clearly, competitive priced electricity relates to competitors of Evergy, not competitors of Velvet.
The line right before it says, then Velvet can have confidence. I'm only asking for who he considers to be Velvet's competitors.
And again, Your Honor, a more reasonable interpretation of the testimony is not only what was raised by Mr. Fisher and Mr. Mills, but also competitively priced as compared to what's available in other states.
Well, let's get around it this way, Mr. Brubaker. Do you recall testifying on behalf of Noranda in a previous Ameren case?
Many times, not in any detail, but I vividly remember the experiences.
Okay, do you recall then Noranda saying they needed a competitively priced source of electricity?
I don't recall their specific contentions, how they phrased it.
You don't recall a man named Henry Fain filing testimony with you talking about the price of electricity for other aluminum smelters?
Yes, I'm sure that there were lots of testimony about that.
Okay, do you recall Mr. Fain on behalf of the same customer giving the electric price for the other domestic aluminum smelters?
Judge, I'm going to object. This is getting very far afield. We're talking about a different witness in a different case and a different set of situations to try to make the point that competitively priced means something about the user rather than the supplier of the commodity. If you're talking about the price of a commodity, it has to be the price set by the supplier, not the user.
Your Honor, if their competitors, A, B, and C, pay 10, 11, and 9 cents for electricity, how do we know then that this is competitively priced? They use the phrase in their testimony, and I'm allowed to just ask him, what does he mean by that?
Well, Judge, this is Mr. Mills again. He has not asked that question, and I think that would be a great place to start. Why don't we go there, and then I think he will explain what he meant by the phrase, and we can clear this all up.
Okay. What do you mean on lines 10 and 11? Then Velvet can have confidence that the rate structure in place in Kansas City will provide competitively priced electric service.
What I mean by that is that if you look around at the prices that other suppliers are offering, that the price available under the, at least expected to be available under the MKT tariff would be what Velvet would consider to be competitive from their perspective.
Okay, competitive from their perspective.
In light of what they could buy power for in other places, and what kind of arrangements they might have for power in other places.
Okay, so now we're comparing with other utilities. When you use that phrase competitively priced, what other utilities are you comparing to?
What? I didn't look at particular utilities. I'm aware that Velvet conducted a multi-state search to find out what was available in other states. And with electricity being a key input to their cost structure, certainly they would have considered all of those aspects, including the price of electricity elsewhere. And they made the decision from their own perspective as to whether or not that was expected to be competitive.
Okay, are you the only witness here for Velvet?
Yes.
Okay? You have not done any independent investigation to determine whether the rates under MKT are competitively priced. Is that correct?
No, but what is important is that Velvet believes that they are competitively priced. And given the structure that's offered to them, and they've negotiated for this transaction, they are satisfied that it is. And
Okay.
that's what will drive the decision making.
If Velvet came inside and said the sky is purple, are you taking their word for it, or are you going to go out and independently verify that?
Objection,
have
Your
it.
Honor, that's argumentative.
I think as a expert witness making statements about something being competitively priced, I'm allowed to determine whether it is solely someone else's position or whether he has done anything to verify that.
I'm fine with that. Let's ask that question.
Okay, did you hear that question, sir?
I did. I have not done a search to compare prices in other locations. I didn't think that, I wasn't asked to do that. I didn't think that was particularly important to whether or not this was competitive, because what matters at the end of the day is whether the people spending the money believe that it is.
And you would agree that the people spending the money obviously want the lowest price of electricity possible. Is that true?
Consistent with reliability and other factors.
Right, so whether they think 3 cents is competitively priced electricity, for economic reasons, they're going to want 2 cents, wouldn't they?
I think they want a viable price with a structure that gives them the ability to acquire renewable resources for all of their energy requirements.
But a viable price. All else being equal, if they pay less for electricity, they're gonna make more in profits. Isn't that true?
That's probably true of electricity and other inputs as well.
So Velvet has an inherent desire, in this case, to get the lowest price of electricity. Is that true?
The lowest reasonable price consistent with being able to acquire renewable resources and having a reliable supply of power.
All else being equal, Velvet has an incentive to get the lowest price of electricity as possible. Is that true?
With the caveats attached to my prior answer, that is correct.
Do you know, okay, let's start with this. Do you have any background or understanding of the market for data centers or the location of data centers?
Yes.
Do you know whether did I hear something? Oh, I'm sorry. Do you know whether data centers must locate in areas geographically? That is, when a data center looks to locate, they may need to place it in a certain part of the country to meet demand, you know, maybe the Midwest rather than California.
Yeah, those are considerations.
Okay, so Velvet may have a need, regardless of electric price, to have a data center in the Midwest. Is that true?
Oh, yes, that's true.
So in your testimony, you give examples, Schedule MEB 2. Yes. You give 6 examples. Do you see that?
I do, yes.
Let's look at the ones furthest away. If a data center has an element of needing to be placed where, for geographic reasons, Virginia Electric and Power, number 4, is quite a ways away. Is that correct?
It's probably the most geographically distant of these mentioned.
Okay, so the rate that Virginia provides may not be relevant, given that the data center might need to be placed in the Midwest. Is that true?
We can pause for just a second. The purpose of presenting these schedules was not for their price, it was for their price structure. There were questions raised, I think, by staff about having other utilities that priced electricity based on a market price measured by a power pole number or something else. And these are presented for that purpose, not for the fact of what the level of a price might be.
But you're not representing that these are potential competitors for the location of data centers then?
I didn't put it in for that purpose, but certainly there are other Midwest locations on here, including Omaha, Northern Indiana, Wisconsin for Alliant Energy. So half of them roughly are geographically similar.
Which three did you give?
Omaha Public Power District, Northern Indiana Public Service Company, Alliant Energy in Wisconsin.
Okay, let's go through that then. Northern Indiana, that is a publicly traded electric utility, is that correct?
It is.
And given the name, would you agree that it's located in Indiana?
That'd be a fair surmise, yes.
Okay, would you agree that given it's in Indiana, it is located in the MISO RTO?
Yes,
Okay, so they are not in the SPP RTO, is that correct?
yeah, that would be correct, yes.
Okay, and would you agree that renewable energy, Kansas, Oklahoma, is much more prevalent in SPP than in MISO?
Yes,
Okay. So they might not offer the same opportunities to a data center that a utility in SPP offers, is that correct?
that's true. And these tariffs were not presented for the purpose of demonstrating a level of electricity prices, but simply for the proposition that other utilities offer hourly pricing for large loads. That's
Okay.
all.
Omaha Public Power, that's in Nebraska, isn't it?
Yes,
In Nebraska, Omaha Public Power is not regulated by a Nebraska Public Utility Commission, is that correct?
yeah, they don't have a public utility commission statewide. They are subject to local regulation.
Okay. And would you agree that Nebraska or Omaha Public Power is not part of SPP?
I believe that's correct.
Okay. So as a utility then, since they're not part of SPP, they may not offer the same access to renewables that a utility in SPP offers, is that correct?
It may be different, but it may not be significantly different.
But
The
they
Omaha,
may,
well, the Omaha rates have been held up by several different data center providers as being an example of what kind of a rate they prefer to have.
but since Omaha is not located in SPP, to get renewable energy, they would have to pay a transmission fee that utilities in SPP don't have to pay, is that correct?
Let me just look a second here. Well, if you wanted to set the facility elsewhere, that would be true. If you wanted to put it in Omaha, that would not be true.
Okay, Alliant Energy, where are they located?
They're located in Wisconsin.
Okay, and given that they're located in Wisconsin, they're also not part of SPP, is that correct?
That's correct.
So of the 6 utilities that you've listed there as examples, none of those are located in SPP, is that correct?
Correct.
So none of those can offer the same access to the prevalent wind energy that you discussed that is located in SPP, is that correct?
Correct.
Okay. the examples that you gave on MEB2, you simply just gave the examples of a market-based tariff. Is that a fair generalization?
Yes,
Okay. Did you look at any of those utilities to see if those utilities also offer discount tariff similar to the PED?
I know that some do. I didn't particularly look at the utilities for that purpose.
So you don't know then how those utilities would treat service when trying to consider both an economic discount and a PED. You haven't made that analysis, have you?
No, I didn't look at that. That wasn't the purpose of presenting these schedules, as I've said before.
Okay, so you wouldn't know if those utilities simply say, the MKT tariff is out here, get on it, but we're not going to allow you to use a discount as well. You don't know that.
I don't know that, no.
Okay. You familiar with the Missouri Energy Efficiency Investment Act, known as MEA?
Yes,
And are you aware of the fact that certain industrial customers can opt out of MEA cost?
yes,
And those customers, I believe were you here when Mr. Ives testified?
I was.
Okay. And, excuse me, opt-out customers are only allowed to opt out to the extent they haven't taken an energy efficiency rebate in 3 years. Is that correct?
That's generally correct. I don't remember the specific details, but what you say is generally correct.
So there, if you take a rebate, a discount, you're not allowed to opt out for a period of time. Is that correct?
I
Yep.
want to object. I think he
That's in
wants,
his understanding of the opt-out process.
I'm
Go ahead,
trying
Ms.
to
Bell.
understand, I think we need clarity on Mr. Woodsmall's question. He said if you take a rebate, but I think he needs to clarify what rebate.
If you take something, a financial compensation from the utility and its customers, you're not allowed to opt out for a period of 3 years. Is that correct?
I'm going to object. I believe that calls for a legal conclusion.
I'm asking his understanding. He said he's familiar with it.
Ms. Bell, your objection is overruled. We've been allowing our consultants and expert witnesses to testify as to their understanding with the acknowledgement that the commissioners are the one who make that final determination. Go ahead with your question.
Do you recall this? Let me just ask it so the record's clear. Is it your understanding that under MEA, if a customer takes a rebate, that they are not allowed to opt out for 3 years?
There is a restriction on that. I don't know, I wouldn't, if you represent to me it's 3 years currently, I'll accept that. There have been some changes over the last 5 years, and I'm not totally up to speed on that, but in general,
Okay, so-
that is correct.
Just so the record's clear, you don't debate that if you take a rebate, you can't opt out for a certain period of time. You just don't know whether it's 3 years.
Correct.
Okay. Are you familiar with EDRs in other states?
Oh, some of them,
Okay. Would you agree with the notion that an EDR is designed to attract customers by giving them a discount for electric service?
yes,
Okay. And in general, after a certain period of time, that customer then goes back to paying the full tariff rate. Is that correct?
it may.
You're aware of EDRs where a customer could stay on perpetually?
Well, the EDRs they themselves may expire, or they may be alternative EDRs or alternative tariffs that the customer could migrate to.
Okay. you filed testimony on the issue of class cost of service many, many times in your career, haven't you?
I have.
And in general, it is your testimony across the board that customers should pay cost-based rates to send proper price signals for purposes of equity, those type of reasons. Is that
Yeah.
correct?
Yes.
Okay. When a customer receives an EDR, are they paying a cost-based rate?
They're temporarily paying a rate less than fully allocated embedded cost, generally under some program that the legislature has decided is an important thing to have for the state.
But given your past testimony, it is a rate that is below cost-based rate. Is that correct?
In the conventional sense of fully embedded costs, yes, but we have to recognize that economic discount rates have a purpose. They've been approved by the legislature typically and implemented by the commission, and as such are not things that I've ever opposed.
Okay, but given all that, you do acknowledge it is something that is less than a cost-based rate.
Can be.
What was that you cut out?
It can be.
It,
If the embedded rates are high enough, then even with the discount, you still may be above embedded cost and certainly will be above incremental cost.
okay, so you're saying if the current embedded rate is above cost of service, the discount may keep the rate still above cost of service.
It may, or it may not, but at least it would be less above cost of service. Less
What is
difference from, I'm sorry.
Have you done, excuse me,
I'm gonna stop. Go ahead.
have you done class cost of service studies in the Evergy West service area before?
I have.
Do you have any opinion on whether the large power rate is at, above, or below cost of service?
The last I looked, it was above cost of service.
Yeah, okay, so it is above cost of service, so that it is paying some degree of subsidy is what you're saying.
Yes.
Okay, do you have any opinion whether that rate, when reduced by 40% for the PED, would be at, above, or below cost of service?
It'd probably be below embedded cost of service, but likely above incremental cost.
Well, in fact, the PED statute says that it must be above incremental cost. Is that true?
Yes.
Okay. So, final question. When a customer receives a PED discount, who makes up for that discount?
My understanding of the process and under the statute is that the utility is permitted to recoup that from other customers.
Okay, and would you agree that as the size of the customer increases in terms of energy usage, the nominal value of the discount increases as well?
Depending on the structure of the rate and all of the things equal, that would be true.
Okay, and so if you have, the PED allows for use for customers as small as 300 kilowatts. So the nominal value the other customers have to absorb will be much, much more for a data center with usage of 100 megawatts than it would be for Joe's Pizza with a usage of 300 kW.
That would be true.
Okay.
And the data center may also bring a lot more economic benefit than a pizza parlor.
No question, but you don't know that, do you?
Yeah, I do. I never saw a pizza joint as big as a data center.
But you could have, well, let's just explore that. You say in your testimony that Velvet will hire or employ 50 individuals, is that correct?
Yes, that's what they've said.
And that is at an average salary of 80,000 a year, is that correct?
Yes,
Okay, so that's annual payroll of $4 million, is that correct?
I think that math would work, yeah.
Do you know whether the discounts under the PED could amount to more than $4 million annually?
They probably would, but there are a lot more economic benefits that could come than just payroll.
Do you know, given your familiarity with the Evergy West service area, whether there are other industrial customers that employ many more than 50 employees a year?
I'm sure that there are.
Okay, Triumph Foods, do you know if they employ more than 50?
Yes,
Boehringer in St. Joe?
yep,
Ag Processing in St. Joe?
yes.
Okay, so there are many, many customers that employ more than 50 employees a year that are served by Evergy, but they're not getting the PED, is that correct?
That's right, because they're not meeting the qualifications that have been set out to qualify to, the conditions
That is,
that are required to qualify.
but that is because they're a legacy customer, not a customer coming new into the service area.
Right, that's the decision that the legislature made, is the offering of PED.
Okay.
I can't understand you. You're just mumbling.
Mr. Brubaker, could you get a little closer to the microphone and give us that last answer once again, please?
I'll try. I think what I said, and I concluded the answer by saying that we're talking about the difference between legacy customers and new customers, and I simply said that the legislature had made the decision about the availability of the reductions, the credits under the EDR.
But just to tie this all up, there are Evergy West customers that employ many, many more employees per year than Velvet. They won't have access to the MKT and they don't have access to the PED discount, is that correct?
Not unless they meet the qualifications for the PED, that would be true.
And since they're legacy customers, they don't meet the qualifications for PED, is that correct?
They could if they added load or they added to their economic activity.
But for their legacy operations, they don't.
They do not.
Okay, no further questions, thank you.
Thank you, Mr. Woodsmall. I am noting the time is 9:55. We will be breaking at 10 o'clock for agenda. I had previously mentioned that we would break until 11. I noticed that the agenda schedule is fairly light, so let's make that 10 to 10:45. Mr. Keevil, that gives us 5 minutes. I'm going to go ahead and let you get started, and but we will be stopping just before 10.
I'm gonna try to get done by 10, Jim.
Excellent. Go ahead.
Depending on Mr. Brubaker's answers. Mr. Brubaker, Mr. Fisher and Mr. Woodsmall asked you some questions about your testimony on page 4, lines 9 and 10, where you're talking about Velvet proposing a charge per KW to further the expansion of renewable energy. You see that, sir?
I do.
Now, my understanding is that that charge will be contained in Velvet's contract with Evergy, assuming the tariff gets approved, that Velvet will enter into with Evergy. Is that your understanding? It will be in the contract?
Yes, in the contract.
That's okay. And each customer under the tariff that qualifies will have to enter into its own special contract with Evergy, correct?
That's correct.
And those contracts will vary from customer to customer regarding the charges contained therein, correct?
I would expect that to be the case, yes.
Thank you. One other line of questioning here is you attached several economic development impact studies to your testimony. Did you prepare any of those, impact studies?
I did not.
Did your, consulting firm prepare any of those impact studies?
We did not.
Thank you. No further questions.
Thank you. That brings us to Mr. Kleiser for cross-examination with 2 minutes to go. Let's go ahead and adjourn now. We will be at recess until 10:45 this morning. We're off the record. For everyone listening online on the WebEx, I will keep the WebEx open for these 45 minutes. Everyone will be typically going to the conference room for the commissioner's agenda meeting, and then we will reconvene here in the courtroom at 10:45. But again, for those on the WebEx, feel free to leave your WebEx open. I am going to mute the feed, but leave that open.
Morris, your camera is still on, just so you know.
Hey guys, FYI, somebody's mic is a little bit live and I can hear background conversation. In case anything somebody doesn't want to be on the record, just or on the webcast, I'll let you guys know.
This is just a friendly 5-minute warning. It is 10:42. We'll begin at just after 10:45. Let's go back on the record. The hour of recess having expired. Again, the commission has set this time aside to finish the evidentiary hearing in EO-2022-0061. This is Evergy, Missouri West request for a special high load rate. We were in the middle of examining Velvet Witness Brubaker, and it was OPC's cross-exam that we were at. Mr. Kleiser, you have the floor.
Thank you. Just real quick, Mr. Brubaker, you can hear me?
I can hear you, yes. A little bit faint, but I can hear you.
Sorry, I will try and speak up. Okay, I would like to start by discussing very briefly the res ramp concern. And I'm gonna start by attempting to fairly explain or identify Velvet Tech's concern. So, if you'll indulge me. As I understand it, Velvet Tech's concern is effectively this. Velvet Tech intends to meet its own energy needs with 100% renewable. And it feels that if it does that and is also required to pay RESRAM, it's paying twice. Is that a fairly accurate assessment?
At least more than once. I wouldn't say twice, but at least more than once.
Okay, fair enough. I just want to make sure that we're on the same page as to that. All right. Let's consider, for example, for a moment, a large auto manufacturer like Ford, who might build a plant in Evergy West service territory. This customer is going to take under the LP, or large power rate. All right? As it stands, taking energy on the large power rate, this customer, Ford, would be paying a RESRAM, correct?
Yes, basically.
And if this customer chose on its own to have a 100% renewable goal similar to Velvet, meaning this customer also strive to meet 100% of its load requirement with renewable resources, under your theory, this customer would also be paying more than once, as you phrase it.
With just a straight application of the RESRAM, that would be the case.
Correct. And that would be true if I exchanged Ford for any other large power customer who might operate in Evergy West service territory, like AG Power or others.
Absent some alternative arrangement, that would be true.
And we can even say a residential customer, for example. If I lived in Evergy West service territory, I would be paying the RESRAM for my residential rates, assuming that I receive power from Evergy West, correct?
You might be, but if you're on the SSP program, you would get to subtract your renewable purchases from your metered energy, so you would not be.
Fair enough. I'm going to move on. I want to discuss and make sure it's very clear on the record exactly how Velvet Tech intends to meet its renewable goals. So, to start with, 100% of the energy, the actual flow of electricity that Velvet Tech intends to use is going to be supplied by Evergy, correct?
Yes, correct.
Velvet Tech is not planning to go and build its own generating facility somewhere.
They
Correct.
could, or they could enter into a PPA with with third parties.
Well, let's talk about just building for a second. If Velvet Tech were to build its own generating facility, that would reduce the amount of retail sales it would need from Evergy, right?
It would depend on where the facilities are located.
Okay. Would you agree with me that for the most part, Velvet Tech intends to meet its renewable goals by purchasing and retiring renewable energy credits, also known as RECs?
My understanding is that they intend to support the construction of new renewable resources from which they'll be receiving the REC equivalents of the output.
Fair enough, but to make sure it's clear, Velvet Tech is going to support the building of new renewables, which will produce renewable energy credits that Velvet Tech will then acquire and retire in order to meet its goal of claiming that it is receiving 100% renewables. Is that accurate?
Correct.
Right. And again, just to be clear, if Velvet Tech receives and retires these renewable energy credits, Evergy will not be able to claim renewable energy based on those credits. Correct?
Right, because they will already have been claimed against the Velvet load.
I think that was all of my questions. Thank you.
Thank you.
Thank you, Mr. Kleiser. We'll now move to commissioner questions. Are there any questions from any of the commissioners? And again, if you're on the phone, to unmute, it is *6. All right, hearing none, the bench does have several questions. First, Mr. Brubaker, I would like to, as they say, rehabilitate your testimony on one point.
Always have that, happy to have that happen.
Well, thank you for allowing me to use the lawyerly phrase. But what I want to do is turn to your Schedule 2. And that was the one you were discussing earlier. The first page of it is the market-based rate schedules. And I want to turn to the second page.
Okay.
You were discussing with Councilor Woodsmall whether those examples of various energy companies were in the MISO or in the SPP RTO. I would refer you to, again, your Schedule 2, page 2, on the right-hand side, the third bullet down. And then I would re-ask Mr. Woodsmall's question, is the Omaha Public Power District in the Southwest Power Pool?
Thank you, Judge. They are in the Southwest Power Pool, and that kind of occurred to me over the break, so I was able to verify that, but I appreciate the opportunity to square that away.
Thank you, sir. I do have some other questions, though. And I apologize. This is probably a better question for Evergy, but it escaped me at the time. How would customers being served on the SIL tariff qualify to move to the MKT tariff, if that would be approved?
I've not looked at the SIL tariff in that regard, Judge, so I can't answer that.
No, that's okay. I was taking a gamble. I do have some other questions. We have been talking a lot about renewable energy. Could you clarify with what certainty the commission can rely on the statements made by Velvet and Evergy and yourself about the use of renewable energy by Velvet?
Velvet has made the representation that they intend to acquire new resources or acquire the output of new resources in SPP. I'm sure that could be put into a contract if necessary to ensure that that happens. I will say it's consistent with my understanding of Velvet's overall approach to the acquisition of electricity is to serve them all with renewables.
Okay. And going back to your testimony, in your testimony, you mentioned the Nucor case and discussed that. I would ask that you expand on that, and can you give the commission and the record a little bit more flavor about what Nucor is and what that case was about?
Okay. I will preface this by saying I was not a participant in that case, but I've read a lot of the documents. So my answer is based on that level of understanding. Nucor is basically we call a melt shop. They have electric arc furnaces and processing facilities to produce and produce steel, raw steel, and to produce finished steel products. My understanding is that they are customer of Evergy Metro, and the commission approved a contract for them about, I think, a little over a year ago. They have, and the arrangement I understand with Evergy is that Evergy will acquire resources, wind resources, I think, in order to supply that load, the energy portion of that load, and will acquire capacity resources as well. My memory is correct. Nucor is explicitly exempted from the RESRAM charges on the basis of them having renewable energy. Those are the highlights as I recall them, Judge. If there are other things you'd like me to comment on, I'd appreciate a question to respond to.
Thank you. I'd like to move on. I'm looking at page 8 of your SIR rebuttal testimony, and you state that the intent of the tariff is for the customer to pay all costs, including additional costs. My question is, what evidence or dialogue did you have with Evergy, or did Velvet have with Evergy to base that statement on? I'm looking at lines 19 through 21, page
Yes.
8.
I think that's part of Velvet's support statement, and certainly part of Evergy's testimony in this case was that they would be self-supporting in that respect. I can't immediately out of the air point you to a specific reference.
So you're basing your statement and your testimony on your reading of the submitted verbiage in the tariff, and also on Evergy's and Velvet's prior statements, their
Yes.
testimony?
Yes,
Okay.
sir.
All right. And then I want to then talk about voltage levels. Could you explain how do the costs differ at different voltage levels? And I'm referencing page 9 of your testimony, lines 18 through 20.
Certainly. The highest level on the system is what is called the transmission level. That's generally 161,000 volts or up. That's where the generating facilities and the interconnection points typically are. So if a customer takes service at the transmission level, then all of the downstream, the lower voltage facilities are not necessary to provide service. So if Velvet takes service at the transmission level, which is what they are set up to do, they will pay for the high voltage transmission of Evergy, and they will pay the contract cost or construction cost of whatever generation is deemed to be provided for their use. And going down from that, there's a sub-transmission level, which basically is after you transform the voltage, the power from transmission level to a lower level, I think generally 34 kV. And to get there, you have to have additional transformation facilities and probably some wires, we can call it that. And so that adds cost. And then if you go down again to primary or secondary level, you incur additional transformer costs, additional wires costs to get the power to customers at that lower level. So Velvet is constructing its own substation from 69 kV down to where they will receive service, and so all those costs are voided by Evergy.
Okay, thank you. I would like to note that Evergy witness Jill McCarthy has signed on to the WebEx. My intention is to take her testimony next after we finish with Mr. Brubaker, and I'm basing that on what I believe will be the offer of OPC and staff to go ahead and delay their witnesses to allow Ms. McCarthy to testify, as their witnesses do, of course, work in the Governor Office building. And I see nods of assent. Thank you both for assenting to that. Mr. Brubaker, we are down to the last couple questions for you. And these are going to be the same questions that I had asked of Evergy about the proposed Schedule 1 tariffs, the competing non-unanimous stipulations. Do you have those in front of you?
Yes, sir, I do.
I'm going to try and paraphrase those questions, but looking at the OPC staff and MECG Schedule 1, what portions does Velvet oppose? And would you explain why those aren't appropriate?
Thank you, Judge. I would preface it by saying I thought Mr. Lutz's testimony yesterday highlighted a lot of that. So I'll focus on the major items. First of all, there is a limitation on the use of the economic development rate, the PDR, which would preclude a customer from taking the MKT tariff if the customer had taken an economic development type discount in the prior 5 years. I would object to that. That's an integral part of the arrangement between Velvet and Evergy. That it's a major piece of the overall structure of the deal, so to speak. And so that's considered to be critical. In terms of the hold harmless provision, I think a couple of things. First of all, what it says is that non-participating customers will be held harmless, and that's fine, but it doesn't say who makes up the difference, whether it's the utility or the customer or a combination of the two. That's left open, and Velvet would prefer to see that tied down a little bit more, as is the case in the alternative, if I may, version of Schedule 1 or the tariff. And then the RESRAM provisions are another major item where we would wind up paying more than once for our renewable requirements. Those are the main items, the high points of that. There are other language things here and there that are just supportive, but not as critical.
Thank you. Thank you, Mr. Brubaker. I'm going to just list the other objections from Mr. Lutz and Mr. Ives, and I'm just going to ask at the end if you agree with those, just so that for the record, we have your objection.
Sure.
They also objected to, or I'm sorry, they requested the substation voltage offering. They suggested the change on page 3 under term to both be 90 days to correct the energy use and also to give notice to switch rates. The hold harmless objection language and substitution language, and also the last sentence on sub 5 regarding securitization and the RESRAM. Do you join with Mr. Lutz and Mr. Ives' objections to those items?
Yes, I do. And if I could take the liberty and go back and expand on my prior answer on the whole
Yes, please.
harmless, the other aspect of that is troublesome is that the OPC staff MECG version would not allow other factors to come into play to be evaluated in the commission's consideration of whether or not we had a hold harmless provision. So with that addition, I would generally agree with the expression of Mr. Lutz on the objections of Evergy to the job.
Thank you. And I know that was a summary question. Are there any other provisions that you think should be inserted that we haven't discussed, or that should be removed that we haven't discussed in either version, either the OPC staff version or the Evergy Velvet version?
We are comfortable and support the Evergy Velvet version of the tariff, Judge.
Okay, thank you.
Thank you.
That concludes my questions for Mr. Brubaker. That will then start us back to recross, and that will go Evergy, Google, MECG, staff, and OPC, the same order. So Evergy, your witness?
Yes, Judge, just very briefly, Mr. Brubaker, just to clarify one point, the judge asked you about the Nucor case. Is it your understanding that that facility is located in Sedalia, Missouri, and that would actually be in Evergy West territory?
That's my understanding, yes.
That's all I have, Judge. Thank you.
Thank you, sir. Thank you, sir. We'll move on to Google. Mr. Mills, your witness?
I have no questions, Your Honor. Thank you.
Thank you, and that will move us to Mr. Woodsmall, MECG, your witness?
Just briefly, going back to the question from Mr. Fisher, when you said previously that, Nucor was located in Evergy Metro service area, did you misspeak or did you truly believe it was in Evergy Metro?
I misspoke.
Okay.
They're in Evergy West.
Turning to your scheduled MEB2, do you still have that?
Nearby, yes.
Nearby, or you do?
I'm ready.
Okay. Would you turn to, I guess it says page 1 of 4. It is the part about OPPD. Do you see that?
Yes.
The judge pointed out the third bullet. Would you read the second bullet on that page 1 of 4?
Oh. The one right above the reference to SPP, is that what you're
Yes.
referencing? Says the
Yes.
customer must own or acquire their own substation.
So that is consistent with the provision in the OPC staff MEG provision that the customer own its own substation. Is that correct?
I think that's correct, yes.
Okay, and turning to the next page, page 2 of 4, the second paragraph, do you see also that third line? It says, second to third line, where the customer owns its own electric substation for the delivery. You see that?
Go ahead and just read it to me if you would. I can't see it right away.
It says, the second paragraph under applicability, it says applicability, blah, 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 where the
Yeah, okay.
customer owns its own electric substation for the delivery of service.
I got it.
And that's also consistent with the provision in the staff OPC MECG tariff, which would require the MKT customer to own its own substation. Is that correct?
Yes, that's correct.
Turning to the next page, page 3 of 4, the second to the last paragraph, it's under administrative, where it says OPPD assumes no liability for customer-owned facilities. Would you agree that since the customer is required to own its own substation under the staff OPC MECG tariff, that this provision would be consistent as well?
Probably, although contractually, you can always agree to pay a fee to have maintenance conducted by the utility or other replacement facilities. So those would just be subsequent things that probably would be in any contract.
But when a customer owns its own facilities, they're responsible for all operation and maintenance costs, aren't they?
They are, but they can contract with the local utility or a third party for some of those services.
Okay, and do you see anything in this tariff by which such a customer has contracted with OPPD to do the operation or maintenance costs?
No, and I wouldn't expect to see it in the tariff. Those are things that just happen as business arrangements among parties.
But the arrangements can't be contrary to the tariff, can they?
That wouldn't be contrary to the tariff.
Okay. I don't believe I have any other questions. Thank you.
Thank you, Mr. Woodsmall. That takes us to Mr. Keeble.
No questions, Judge.
Thank you, sir. That takes us to Mr. Kleiser.
Yes, Your Honor.
Good afternoon again, or good
Afternoon.
morning, sorry.
Well,
Mr.
yeah.
Baker. You received a question from the bench regarding the hold harmless agreement. You went back and clarified your response after the fact. Do you recall that?
I do, yes.
I want to walk through this to make sure I understand how this would work. As I understand the tariff, and this is for both proposals, the tariff would set out a fixed rate for service, except for the actual energy charge, which would be pegged to SPP prices. You concur with that assessment?
Yes.
I'm sorry, there was a bit of a technical difficulty. Can you repeat your answer?
I'm sorry, I'm shuffling my papers. Yes, I agree with that.
In the event that there was a shortfall in revenue, because the contract did not cover the full cost to serve Velvet Tech, how would Evergy recover that, any part of that shortfall from Velvet Tech, given the fact that it's a fixed rate contract?
Well, I think that's outside. I mean, that's part of it, but the provision that Evergy and Velvet have set forth has a provision for that. If the commission found that there was a deficiency, then that would be, I like to think the way ours is, it's a combination of the company and the customer.
Right, you're referring to what you have put forward, or sorry, what the Velvet Tech Evergy tariff has put forward. I'm asking,
Yes.
if we remove that line, right, and we have just a plain old hold harmless, how does Evergy collect any amount of revenue shortfall from Velvet Tech, given that Velvet Tech has a fixed rate contract?
I think the way we look at it, the commission has supervision over these contracts and would actually be making the determination about that.
Let me posit it this way.
The mechanism, go ahead.
I would submit to you that with a fixed rate contract, any revenue deficiency or shortfall that occurred with a true hold harmless provision would have to be borne exclusively by Evergy. Do you agree with that?
Yeah, I think I would agree with that.
And if that is the case, then the true hold harmless provision, as I'm referring to it, would have no ill effect on Velvet Tech, would it?
Not in the short run, at least.
What do you mean by not in the short run?
Well, sometime there will be renewals of the contract, and it's usually things that went awry in the first term of the contract tend to get addressed in the second term.
So your fear, effectively, is that without I don't want to use the term true hold harmless just because I feel like that's a little too argumentative. I'm trying to think of a better way to phrase it. Without the OPC MEC staff version of the hold harmless, your fear is that Velvet Tech would ultimately have to pay a higher price in contract negotiations if there was some kind of revenue deficiency. Is that accurate?
Yes.
So at the end of the day, Velvet Tech's opposition to the hold harmless agreement comes down to its fear of having to pay more money.
Well, I think if the commission found that there was a need for some compensation, that's why the version of the tariff that we've offered allows for that, for sharing between the two parties to hold other customers harmless.
No, I think I'm good there. Thank you very much. I have no further questions.
Thank you.
Thank you, Mr. Kleiser. That takes us to redirect. Counselor Bell, your witness.
Thank you, Your Honor. Let's start with the
Ms.
questioning.
Bell, you
Yes.
might have a speaker on in your office that you'll need to turn off. We're getting a little bit of an echo.
Is
I'm
it
sorry, go
better?
ahead.
Okay,
Miss?
so we're going to start with the questions of, of OPC. Regarding customer concerns with the OPC non-unanimous stipulation. If the commission were to take OPC's Schedule 1, would customers in general, customers, a future MKT customer, find the option more or less attractive?
I think it would find it less attractive.
So does no, or the elimination of the PED discount make Schedule MKT more or less attractive to a prospective MKT customer?
It certainly makes it less attractive. Oops, sorry. Yeah, it certainly makes it less attractive.
And to try to clarify that last conversation you were having with Mr. Kleiser, with respect to Velvet, they have a fixed rate contract. That's your understanding.
Correct.
But each contract would be unique to the customer, correct?
Correct.
So for future customers, would OPC's hold harmless provision make Schedule MKT more attractive or less attractive for future customers?
It would make it less attractive. In fact, Mr. Ives said that if that were adopted, they wouldn't offer the tariff.
And then with respect to the OPC provision on ResRam, would that make Schedule MKT more or less attractive to a prospective MKT customer?
I'm gonna object, Judge, because this all is calling for speculation. We're talking about some customer that Mr. Brubaker doesn't even know who the heck it is, and asking how that customer is going to view the various tariff provisions. It's just pure speculation.
I'm going to allow, go ahead.
In general, that would make the tariff less attractive.
And Mr. Brubaker, can you give the commission a brief understanding of who you typically have represented in your PSC history?
Well, we've represented a lot of customers, folks in the Kansas City area and Sedalia area, as well as St. Louis, customers of previously KCP&L, Ameren.
And you typically deal with large industrial or commercial customers?
We typically deal with large customers. Many of them are industrial, some are governmental, others may be commercial type customers.
You had mentioned the solar subscription program offered by Evergy.
Yes.
Can you explain how that SSP program works?
Yes, under the SSP program, the utility constructs or acquires somehow a solar facility, and then retail customers are allowed to contract for the output or shares of the output of that facility in return
I'm
for
sorry,
paying a price. And
Could-
then when it comes to the billing and accounting, the number of kilowatt hours from those solar facilities that are under contract to the customer gets subtracted from the customer's metered energy so that the solar energy is netted from the total energy requirements, which then exempts that part from ResRam.
Does that mechanism also allow the kilowatt hours for the customer covered by renewable energy to be exempted from the electric utilities sales?
Yes.
Okay. You were asked about Velvet's commitment on renewables? Do you recall that conversation?
I do.
Okay, will Velvet's need and renewable commitment result in the development of new renewable energy on SPP?
Yes, Velvet is committed to support the construction of new facilities in SPP.
And under the provision proposed in the Evergy and Velvet stipulation, will Velvet be required to document that that new renewable energy has been, will just document the renewable energy?
Yes, and to provide evidence that the renewable energy certificates associated with that generation have been retired on its behalf.
With the conversation you had about other customers like Ford, for example, with Mr. Kleiser, would they have any commitment to add new renewable energy to the grid?
Not under the construct that was embedded in the question. They would not.
Let's go back to the solar subscription program. Functionally, how is the application of SSP different from what Evergy and Velvet are asking for here?
It's essentially the same thing.
And are you aware if the commission has granted variances related to res compliance before?
I'm aware, yes, they have.
I want to turn to some of the questions that Mr. Woodsmall was asking you. Are you aware if any data centers operate in Iowa?
Many, yes.
And does Iowa have a large?
Your Honor, I object. When I tried to ask questions about data centers and competitors, I was shut down. And now, I mean, I don't have a problem with her asking these questions if I can go back and ask my questions. But she objected all those, and now she's coming back to it.
Your Honor, the only question I objected to was the identification of competitors. Mr. Brubaker testified that the availability of competitive options in other states was what his testimony was saying. And then Mr. Woodsmall suggested that Mr. Woodsmall suggested and Mr. Brubaker testified about certain options that were not in SPP.
But that was all he testified on. When I started to ask questions about competitors and data centers and those type of things, I was shut down. And so I even mentioned, to try and draw an analogy, when we did cases for aluminum smelters, we looked at competitive aluminum smelters. And I was shut down with any questions regarding the potential rates of data centers.
Judge, if I may, this is Mr. Mills. I believe that the premise of Mr. Woodsmall's question was the phrase competitively priced. And it was clear from Mr. Brubaker's answer that he was not, when he was using the term competitively, that term was modifying priced as in the price offered by suppliers, not the price obtained by competitors to data centers. So I believe that's the reason why the questions as to competitors of Velvet were not allowed, because it wasn't germane to Mr. Brubaker's testimony about competitive alternatives from suppliers.
But that's exactly where she's going now. He's asking about the rates of competitors in Iowa.
No, that's not
Let
where
her
I'm
get
going,
there.
Your Honor.
Ms. Bell,
If I may,
Ms.
if
Bell,
I-
Ms.
sure.
Bell, Ms. Bell. Let's let her get there, Mr. Woodsmall. Your objection is overruled. Ms. Bell, please continue.
Does Iowa have a large amount of wind generation?
It does, yes.
Would you agree that Iowa is a good location for wind development?
It is. It's very, very rich, very wind rich, if I can use that term. There's windmills all over the place. In fact, Mid-American Energy in its standard portfolio already can serve its retail load with a profile that is over 60% renewable energy and going to 100% if they continue their build out of wind facilities.
So if Velvet could not locate in Missouri, would you believe Iowa could be another site for their evaluation?
It certainly could be. Mid-American allows all of their customers to claim the renewable attributes of the energy facilities for their own account. And that's a very attractive proposition.
And if Velvet located in Iowa instead of Missouri, Missouri would lose out on the economic benefits provided by Velvet?
They would, yes.
Thank you. No more questions.
Thank you. Thank you, Mr. Brubaker. You are excused. You're free to continue participating by watching the hearing in the WebEx. As I stated earlier, we are going to take Ms. McCarthy as she is available on the WebEx. Ms. McCarthy, if you could go ahead and speak up, and I will swear you in.
Yes, this is Jill McCarthy.
Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
Yes.
Thank you, ma'am. Mr. Fisher, your witness.
Roger
Judge, I'll do
Roger
this one,
Steiner.
Judge. Hello. Would you state your name for the record?
Jill McCarthy.
And where do you work and what's your position there?
I work at the Kansas City Area Development Council. It's also known as KCADC. My position there is Senior Vice President of Corporate Attraction.
Did you cause to be filed direct testimony in this case, which has been pre-marked as Exhibit 4?
Yes.
Do you have any changes or corrections to that testimony?
I do actually. I have two. One is there's a typo on page 13, line 6. The word student should be study.
Okay.
And the other is on page 15, line 21. I'd like to change the word has to will have.
Okay. With those two corrections, is this Exhibit 4 true and correct to the best of your knowledge and belief?
Yes.
Judge would offer at this time Exhibit 4 into the record.
Thank you. Are there any objections to the admission of Exhibit 4, the testimony of Ms. Jill L. McCarthy? No objections. It is so admitted. Please go ahead.
And would tender the witness for cross-examination at this time.
Thank you, Mr. Steiner. We first go to Councilor Bell with Velvet, please.
No questions, Your Honor.
Thank you. Next we go to Mr. Mills with Google.
Just very briefly, at pages 12 to 14, roughly, of your testimony, you talk about some of the benefits that would accrue to Missouri and the area from Velvet's project. Are you familiar with that part of your testimony?
Yes.
Would similar benefits accrue to the state and to the region from another similar data center?
Are you talking about a future like data center? That would be, yes, yes.
That's all I have. Thank you.
Thank you.
Thank you. And that takes us to Mr. Woodsmall.
Good morning, can you hear me?
Yes, thank you.
Can you give me in just a couple sentences what the purpose of your testimony is?
I would say the purpose of my testimony is to speak in support of Velvet Technology Services and their hyperscale data center development in the Kansas City region. That may be too
And
few.
is that because you believe it will enhance economic development in the area?
I do believe it will enhance economic development in the area.
And you mentioned in your testimony that it will employ 50 jobs, is that correct?
I think that they have committed to, let me look at my paper.
Page 15,
70
line,
Okay, yes. So a minimum of 50, yes. I think they're more likely to be 75, but I would leave that to Velvet.
okay, let's use 75. In the area that your group represents, do you believe that 75 is a large number of customers? Or a large number of employees?
I would say every operation has a different job and capital investment impact. 75 jobs with 81,000 average wage is a great benefit to the area. That is 75 jobs that weren't there before. The other piece of this would be the construction jobs that are hired in the region and are kept active for multiple years. It takes a long time to build out a hyperscale campus.
Let me ask it this way. If this brought in 75 jobs at $80,000 a job, but in the process, you lost a customer that has 500 jobs at $80,000 a job, you would be more hesitant with your recommendation, is that true?
I'm going to object. It assumes facts that are not in evidence.
It's a hypothetical.
Yeah, I'm going to go ahead and allow it.
So if I understand what you're saying is that if I support a project with 75 jobs at 81,000 and we have another project for 500 jobs at 81,000, I see no reason why we wouldn't support both projects. One would not be a cause and effect to lose one. The projects that we work with, our competition is other markets, not other projects in our region. And so I would say they're not connected in any way.
You don't see any connection. Well, let's go through that. Do you, as part of your job, consider the importance of affordable electric rates to employers in the area?
Yes.
And how do you go about considering those rates? What documents, what do you consult in order to make that determination?
We engage with the business development team at Evergy to speak specifically to rates. Rates are also based on use, on load, all of the factors that come in. An office project has a different rate than a car manufacturer, an automotive supplier. So that's not my core business. We look to always engage the appropriate party to speak to their input on a project. It takes a lot of different players.
So your primary source is to go straight to the utility to ask them if their rates are affordable.
What we would be asking is what would the rate be based on the use, load, number of hours worked by a certain user.
But you don't know independently if Evergy's rates are competitive with other utilities in the Midwest.
I can only speak from my own experience on that in economic development, not as an Evergy employee, that over the years that I've worked in economic development and the projects that I've worked on, for those where Energy has been a big driver. We weren't where we needed to be. That was a factor in losing the project. And if we were where we needed to be, it was a factor in winning.
So do you know if the Kansas City area electric rates are competitive with those in Ameren service area?
I can't speak to that specifically. I
Do you
can
know
make an
whether the rates in the Evergy service area are competitive with those in Mid-American in Iowa?
again, I cannot speak to that specifically.
Are you aware whether the electric rates in Kansas City are competitive with those with Oklahoma Gas and Electric in Oklahoma?
I cannot comment specifically on that.
Does your organization ever get involved in Public Service Commission decisions like the current Evergy rate cases seeking to maintain competitive electric rates?
I can't say one way or another. I know I personally have not testified on behalf, but I cannot speak to whether or not another member of the team has in the past.
How long have you been with this group?
23 years.
So in 23 years, you're not aware of any instance where this group has intervened in a Public Service Commission case seeking to inquire about the competitiveness of Evergy rates?
I don't have one that comes to mind. That doesn't mean that it hasn't happened in the past. I just cannot.
Okay.
I'm sorry, I can't recall.
Do you believe that large customers would prefer lower electric rates than higher electric rates?
Yes, sir.
Would you agree that large employers may make decisions about moving their facility or relocating their production because they're seeking lower electric rates?
Yes, I believe that could be a factor.
Do you believe that, have you heard the statements in this case of customers, every customer in this case, saying they're worried about these costs being shifted to all other customers?
So let me just interrupt. What's the question, David?
Whether she's aware that all the customers in this case are sharing concerns that costs will be shifted from MKT customers to all other customers.
I can't speak to that. I have no knowledge of that.
You haven't been sitting in this hearing listening to those concerns?
I've just been on for about 35 minutes.
Would you be worried if large millions of dollars of costs are being shipped from NKT customers on all other customers?
I'm going to object. That question assumes facts, not in evidence.
I'm just asking if she would be worried if that happened.
I'll overrule the objection and allow this tentatively, and hopefully we're at the closing end of this. So go ahead, Ms. McCarthy, on the hypothetical.
On the hypothetical, if that was something that was happening, then yes, I would find that concerning. I'm not I have no knowledge or indication that that would happen in this case.
Did you make any inquiry, conduct any study, talk to anybody other than Evergy about that possibility?
I have not.
Did you read any of the testimony of any of the customer groups in this case?
I glanced through one testimony that was provided. I have to go look to see. I'm sorry, I don't remember what it was.
I think it was witness Mark.
That's correct. Mr. Mark,
So
thank you.
you received the testimony of witness Mark.
I did.
Did you understand that testimony?
In all honesty, I have been out with a client on another project the last 2 days, and so I glanced through it very rapidly. I did not read it in total.
Did you understand that you had the opportunity to file sur rebuttal to respond to his testimony?
I'm sorry, I don't really know what you're asking me.
Mr. Mark filed a round of testimony, and there was a subsequent round of testimony to address that. Were you aware you could file testimony to respond to Mr. Mark?
Not really.
Did you find anything in the testimony of his that you read that you had reason to question?
So I would say for the very little that I was able to read, because again, I've been out of town the last 2 days with a client. We likely disagree on the process of economic development and the impact of economic development.
But did you agree with Mr. Mark's concerns that MKT customers would cause a negative impact on other customers?
I'm going to object. I don't think she believes she read that.
Okay, if she didn't read that, then just tell me you didn't read that.
I didn't read that part.
Okay. Are you aware that in several recent Evergy rate cases, industrial customers have made the claim that Evergy's industrial rate is not competitive with other utilities?
I've heard that. I've heard it about electricity. I've heard it about water in different markets. Yes, I mean, we're never going to be competitive with every other market.
That's disconcerting. Does that bother you?
I think that what we like to do is to make sure that all our partners are as competitive as can be, and to really pull in new companies, capital investment, jobs, payroll that is good for the economy, good for the diversification of the economy, good for jobs that are being offered to our residents. And
So let's boil it down to a hypothetical. You know who Ford Motor Company is?
yes, sir.
Okay, let's just say they were in the Evergy West service area to clean this up. Would you agree that Ford Motor Company employs many more than 50 employees, 75 employees that Velvet will employ?
I do.
Would you agree that Ford Motor Company is always making decisions about where to increase or decrease production based upon cost?
Yes, sir.
And if I were to tell, and would you agree that Ford Motor Company is a very electric intensive industry?
I would.
And if I were to tell you, just as a hypothetical, that MKT customers were shifting costs on other customers like Ford, and if they respond to that by shifting production and jobs, would that concern you?
It
And
would.
this is hypothetical, right?
Yes,
Yes? It would concern you?
it would, but I have no knowledge of such an event occurring.
But you've never gone out to study it or consider it or talk to Ford or talk to industrial customers or talk to anybody but Evergy.
That's correct.
I have no further questions. If you need help with this, call me. I'm always around to help you with industrial concerns.
Mr. Woodsmall.
I'm done.
Is that a question, David?
It was an offer.
Let's move on. That brings us to Mr. Keevil with staff. Any questions?
Yeah, I'll keep this short. Thank you, Ms. McCarthy. First of all, what exactly, remind me with your agency name?
It's the Kansas City Area Development Council.
Okay, and is it a governmental agency? Is it a private agency? Is it a public-private partner? What exactly is it?
We are a private, not-for-profit agency. We focus on the economic interest of an 18-county, 50-city template for the core of our business. We are able to expand out of that area on select types of projects.
Okay. Where do you get your money, your funding to run your agency?
Yes, we're funded from corporate, primarily from corporate investors in our agency. We have 250 corporate investors, and then that's probably about 90% of our budget. And then the other 10% comes from agencies within that 18-county, 50-city footprint.
Okay. Is Evergy one of your corporate investors?
They are.
Okay. Approximately how much do they pay you each year?
I don't have a specific dollar amount. I can't answer that.
Okay, is it $1,000? More
Our-
than $1,000?
Our base is $10,000 per year. I think the average for our investors is closer to $17,000 or $18,000 per year.
17 or 18? And what's the maximum?
There is no maximum. That would be a great problem to have.
Okay, so you don't have levels of sponsorship.
I do not.
Okay. How is a company's contribution to your agency determined? I mean, you said the average is 17, the minimum is 10, I think you said. How do you determine who pays what?
That's really handled between the company and our CEO. It's something that is negotiated between the company and our CEO. You know, for some companies, they probably see more benefit financially. Other companies are invested because they feel that our agency does good for the region as a whole. It may not impact them in a financial way. Sometimes, you know, so a lot of what we do is to bring in new businesses. So that creates capital investment, payroll,
Well,
jobs.
I just asked how you determine who pays you what. And so I think we're getting way
Yep,
beyond.
sorry. My apology. It's a negotiation between the CEO and the company that is an investor.
Okay. Do you testify in a lot of administrative proceedings on behalf of your other sponsors?
I have not.
And have you testified in any administrative proceedings on behalf of your other sponsors?
I've testified before in Missouri to special committees and in Kansas relative to incentives that, you know,
You're
maybe,
talking about legislative hearings?
yes, sir.
Okay, I asked about administrative hearings, I'm sorry.
No, sir. My apology.
You've never testified, so this is the first time you've ever been called upon to testify in an administrative hearing on behalf of one of the companies that sponsors your agency?
That's correct.
Okay. You mentioned, well, I might ask you this, who asked you? How did Evergy ask you, or did Velvet Tech ask you?
That's a really good question. I cannot remember. It could have been either. I'm sorry. I just don't remember.
Okay. You talked a lot about the point of your agency, or the mission of your agency is to pull in new customers. And I understand that, but is part of your mission also to retain existing customers?
It is not. We have partnerships with local economic development agencies. They are really responsible for their own parochial borders. We can support them if they need it.
So if a new customer is hypothetically, if a new customer is going to shift costs onto existing customers, do you care about that?
I do. I can't say that I've ever been in an experience such as that.
Congratulations. Now you have. You also talked on the response to someone, I forget, I think it's Mr. Wood's phone. Page 15 of your testimony, talks about Velvet Tech, will support more than 50 employees with an average wage of $81,000. And then above that, you say Velvet Tech is committing over $800 million in investment. When you use the word committing, in regard to that, what sort of commitment, are you talking about?
So the scope of the project and the cost of the building and the equipment being placed in the building is over $800 million.
Okay. How about these employees and wages? What kind of commitments do you have on the number of employees, new employees, and wages?
The last paperwork that I saw indicated 75 employees at $81,000 average wage.
Yes, okay, 75. What kind of paperwork are we talking about? Is this some sort of guarantee, corporate guarantee from Velvet?
So basically, every project has a minimum threshold that they are saying that they will guarantee X number of jobs, X capital investment, and a certain level of payroll. And generally, when economic development incentives are received, those markers have to be met for the incentives to hold true.
Yeah, I generally, but we're not talking general, we're talking specifically here. What sort of guarantees have you received from Velvet that they're going to employ 50 or 75 people?
So they have a Chapter 100 agreement with the city of Kansas City.
What guarantees have you received from Velvet that they're going to employ 50 or 75?
Jeff, I think she was trying to answer.
Yep, Mr. Keeble, I do agree that that was the forthcoming answer. Ms. McCarthy, could you go ahead and continue, please?
Yes, thank you. The Chapter 100 agreement with the city of Kansas City, Missouri also specifies the minimum amounts related to jobs, capital investment, and payroll. And those incentives are tied to meeting those markers. That is the contract. My agency does not make contracts. We don't have incentives. That comes from the city, the state, and the utility on a project such as this.
Okay, so you don't grant incentives from your agency, you don't make contracts with your agency, is that accurate?
That would be accurate.
Okay. So you would not be the one, your agency would not be the proper party to be in any position to enforce any guarantees or rescind any economic development incentives which might have been granted in the event that that Velvet did not meet their quote unquote commitment. Is that correct?
That's correct.
Okay. What's your what experience do you have in utility rate making or rate setting?
I have no experience.
All right, thanks. I think that's all I have, Judge.
Thank you, Mr. Keeble. Before we turn to Mr. Kleiser, I just want to note it is 11:56. I'd like to make my intentions known to everyone on WebEx and listening and in the room. I do intend to allow Ms. McCarthy to finish her testimony, and then we will break for lunch. I would also expect I would expect a request that Ms. McCarthy might be excused for the rest of the day. So just be prepared for that. Mr. Kleiser.
Thanks to the two gentlemen who came before me, I have no further questions.
Thank you, sir. That will turn to commissioner questions. Again, we do have commissioners on the line. If you're on a phone, it is *6 to unmute. Are there any commissioner questions for Ms. McCarthy? Hearing none, the bench also has no questions. I believe that takes us back to recross. So that goes to...
Your Honor, without bench questions, there would be nothing to read.
Thank you. I always trip up on that. Thank you. Anything further for Ms. McCarthy before we move on?
I have the opportunity for redirect, Judge.
Oh, yes. Yes, Mr. Steiner, you are correct. I'm sorry. Go ahead.
Do you recall being asked by Mr. Keevil about members in your organization?
Yes, sir.
And are there, how many members are there first?
There are about 250.
And do you know how many of those are regulated by the Missouri Public Service Commission?
I do
Besides Evergy?
not. There are other utilities that are investors, but I don't know.
Okay. I think that's all I have. Thank you.
Judge, what was her exhibit number again? I'm sorry.
4.
4, thank you.
And Mr. Steiner, did I may not have heard you request Ms. McCarthy to be excused. Was that your request?
It is my request, so may she be excused.
Thank you. Ms. McCarthy, if you would so choose, you are excused from appearing for the rest of the hearing. Thank you very much, ma'am, for your patience and participation today. You are welcome to remain on the WebEx and observe.
Thank you.
With that, thank you, Ms. McCarthy. With that, we will adjourn for lunch. It is 11:59. Let's come back at 1 o'clock, and we will continue with our witnesses. On my schedule, I believe we will be going to the staff witnesses and then OPC witnesses, and then circling back to see if Ms. Hadaway is available.
I appreciate that, Judge, and I think she will be available, but we'll see what happens at 1 o'clock.
Excellent. Thank you, Mr. Steiner. We are at recess for lunch, and we are off the record.
1 o'clock, you said.
1 o'clock. 1 o'clock, everyone.
What happened to the month?
Just a quick announcement for everyone listening online on the WebEx or in the courtroom. We will begin in 5 minutes. In 5 minutes. Lisa, we got 1 minute.
Jeff, have you been to that new place, Gotham Grill, that's formerly Rick's? It's right around the corner up here. Remember Rick's
I
Cafe?
was gonna say, is the guy that used to run the Gotham Grill here?
Yes. Well, was it called Gotham Grill here?
Yeah.
Okay. Yeah, he just moved around the corner.
And which corner?
Wow.
On High?
Yeah,
let's go on the record. The hour of recess having expired, let's return to our evidentiary hearing in file number EO-2022-0061. I note for the record that Michelle Hadaway, the scheduled witness for Evergy, is showing on the WebEx. Mr. Steiner, are we to assume that we're going to proceed with Ms. Hadaway next?
Yes, that makes sense to me.
Okay, Ms. Hadaway, if you would speak up to bring you to the front of everyone's screen. Thank you, ma'am. I'll swear you in.
Oh, I'm sorry.
No, you're fine. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you. You're now sworn. If you would state and spell your name for the record, and then you are Evergy's witness.
Okay. Michelle, Michelle, Hadaway, Hataway.
And Mr. Steiner or Mr. Fisher, go ahead.
All right. Would you tell us where you work and what is your position there?
So I work for the Missouri Department of Economic Development, and I'm the division director for the regional engagement team.
And what are your responsibilities in that job?
So I manage 6 different regions and teams within each region to work with existing companies. I also work with Missouri Partnership on attracting new businesses to Missouri.
Are you adopting the direct testimony of Mark Stombaugh, which was previously marked as Exhibit 5?
Yes.
And are the answers contained in that testimony true and correct to the best of your knowledge?
They are.
Your Honor, at this time would tender the witness for cross-examination. Also move for admission of Exhibit 5.
Thank you, sir. You've heard the motion. Are there any objections to the admission of Mr. Stombaugh's testimony being sponsored by Ms. Hadaway? See, no shaking of heads, no objections. The exhibit number 5 is so admitted onto the hearing record. And you have tendered the witness. That takes us to cross-examination. And Ms. Bell for Velvet. Counselor, go ahead.
No questions, Your Honor.
Judge, can you turn, I'm having trouble hearing the witness and Ms. Bell.
No questions, Your Honor.
Thank you, ma'am. And Mr. Mills.
No questions, Your Honor. Thank you.
Thank you. Mr. Witzmall.
Thank you, Your Honor. Ma'am, can you hear me?
Let's try. You're kind of far away, but let's try it.
Can you hear me better now?
I can, thank you.
Great, thank you. Good afternoon. How long have you been with the Department of Economic Development?
6 years.
6 years. And how long have you been in your current position?
Almost 30 days.
Okay. Is that a permanent title or just pending interim?
No, it is permanent.
Gotcha. Congratulations.
Thank you.
Does the Department of Economic Development in its various roles consider the competitiveness of electric rates to other regions, states?
We don't. We rely on our partners, the utility companies and co-ops out in the field to determine that.
Okay. You don't ever try to independently verify what they tell you then as to the competitiveness of their rates?
No.
Okay. Do you independently know how Evergy's rates compare to any other utilities?
I don't, no.
Do you agree that high uncompetitive electric rates threaten the viability of certain customers in Missouri?
I'm going to object as facts not being in evidence to the question.
I'll rephrase, Your Honor.
Thank you.
Would you agree that if Evergy's electric rates are not competitive, that it may threaten the viability of energy-intensive customers in the service area?
Just in general, for their ability to do business, is that what you're asking?
Correct.
Well, I think having stable energy is important for them to be able to do business.
And I'm not talking about when you use the word stable. I agree with you, reliable electric is important, but I'm just talking now about electric rates. Would you agree that if Evergy's electric rates are uncompetitive with other areas, that it may threaten the viability of certain customers in the service area?
I don't know if I would be an expert to be able to answer on that. I think what we focus on when we talk to existing companies and attraction pieces to some extent is the reliability. So the cost perspective, I don't know if I would be able to accurately answer.
Okay. How do you know then that Evergy's rates as they exist right now aren't low enough to attract data centers on their own?
Well, so we rely particularly on the companies and consultants in general who educate us about those. And then again, our partners who are the co-ops and the utility pieces to continue to educate us about those with perspective to cost of energy.
Okay, so in regard to cost of energy, you're simply repeating the things that Evergy has told you.
Well, I don't speak to cost of energy. What I'm saying is I let our partners speak to the cost of energy. And that's who we bring to the table whenever energy pieces do come up.
If it has been shown that the addition of an MKT customer would cause costs to be shifted to other customers, would that concern you?
I'm going to object. I think she's already said she doesn't look at that, David.
Well, I'm asking her, independent of that, if it was shown, whether that would cause her a concern.
Independent of what? She's here as a witness as a part of economic development.
And that energy costs are part of economic development. I'm just asking her if it has been shown, regardless of what Evergy's told them, that the MKT customers will cause costs to be shifted on non-MKT customers, if that would concern her. Just asking if it concerns her.
I'll allow him.
I think it could concern, but again, what I would do is if a customer or company drew that to our attention, we would bring in our local utility partners to come speak to it.
Okay, you would bring in the utility partners. You wouldn't attempt to in any way verify that concern yourself.
Correct. We would bring in the utility partners.
You know of independent data sources that show the competitiveness of Missouri rates?
I do not off the top of my head, but I believe if I needed to, I could always go to the Public Service Commission for information.
But you don't know, you've never consulted any sources to compare Evergy's rates to Ameren rates to utilities outside of Missouri?
No.
Okay. So you don't know yourself if Evergy's rates are uncompetitive with any other service area?
No, I do not. But I do believe that we need to be competitive in order to be able to attract and retain businesses in Missouri.
Okay. With that in mind, are you aware that Evergy has a pending rate case right now at the Public Service Commission?
I would say no. I don't know if I understand no.
Okay. do you understand that a utility must file a rate case in order to increase their rates?
Yes,
Okay, and are you aware that Evergy has filed such a case seeking to increase its rates in Missouri?
no, I don't think I was aware of that.
Okay. Would you, to your knowledge, has DED ever intervened in such a rate case to determine whether a certain utility's rates are competitive with other areas?
Not to my knowledge.
Okay. Did you read any of the rebuttal testimony in this case?
No.
So if I told you that the commission staff and the Office of Public Counsel being responsible for representing customers, if I told you that they raised concerns that this was harmful to other customers, you weren't made aware of that because you didn't read the testimony.
I was made aware of that, but I did not read the testimony.
Okay, you didn't independently attempt to determine whether what staff and public counsel said was accurate or not.
Mr. Woodsmall, if she didn't read the testimony, I don't know how she could come to any conclusion.
She said she was told about it, but she didn't read.
Okay,
So
my
I'm
apologies.
asking you, given that you were told about it, did you ever attempt to independently verify whether there was some credibility to staff or public counsel's concerns?
No.
Okay. Would you agree that in your testimony, I believe you state that Velvet, on page 3, line 13, you state that the project plan calls for more than 50 new full-time positions. Is that your testimony?
Correct.
And if it was shown that the addition of Velvet shifted costs onto other customers such that, let's say, a customer with 500 employees left the state, would that concern you?
Objection. I think she's already testified she doesn't look at that, David.
I'm just asking if it concerns her under that hypothetical.
Concerns her as a personal matter? I mean, what? It's not her job.
Her job is economic development. That's the entity she works for.
I'll allow it. Go ahead.
Do you recall
Could you repeat the question? No, could you repeat it, please?
If it was shown that the addition of Velvet with 50 jobs caused costs to shift such that a different company with 500 jobs left the state, would that concern you?
I've never heard of a company leaving because of a rate increase or a cost and utility piece.
Have you heard of Noranda?
Yes, I have.
Do you recall their situation?
A little bit correct, yes, but feel free to remind me.
Now, tell me your understanding of Noranda relative to their cost of electricity.
I don't know, again, I'm not the expert when it comes to the cost of electricity. I do know that was a piece in deciding. I don't know if that was the only reason in them closing, was my understanding.
Okay.
It wasn't an area of the state at the time that I covered. At that time, I was covering a different area of the state.
Okay. I'm sorry I was walking over you while you attempted to answer. So when you said you're not aware of any company that may leave because of high electric rates, you're not saying it doesn't happen. You're just saying you're not aware of it.
I'm not aware of it.
Okay. And do you dispute at all that that could happen?
I'm going to object.
Again, it's not something.
What's that? David?
Yeah, I'm gonna uphold the objection.
Okay.
We're getting pretty, I'm gonna go uphold the objection.
Okay.
Go ahead.
And I'll clarify that question, and then I think I'm done. Well, never mind, I don't even need to clarify that. I think I'm done. Thank you, ma'am.
Thank you, Mr. Woodsmall. Let's move to Mr. Keevil.
Yeah, excuse me, I'll try to be brief, Judge. Can you hear me, Ms. Hathaway?
I can, thank you.
Thank you. I apologize when you first took the stand. I missed your job title. What is your job title?
Yep, I'm the division director for the regional engagement team.
Division Director of the region. Is that the same thing that Mr. Stombaugh was?
Correct.
Okay, so you've taken his former position.
Correct.
All right, thank you. Looking at the testimony itself, he makes a statement there on page 2, lines 10 through 12, that he provided direct testimony in case for EO-2019-0244 on behalf of KCP&L. Is that also true of you? Did you file testimony in case number?
I was aware that he had done that. I have not.
You have not filed testimony. Is this the first time that you've testified in a PSC proceeding?
Is it obvious?
No, no, I just wanted to get this clear here. So then you have no experience with utility rate setting or rate making, is that correct?
Correct.
Right. Were you personally involved in the effort to get Velvet Tech to located in Missouri?
I was not.
You were not. Okay, so from where does your knowledge of what Velvet Tech represented come? How do you know what they claimed or anything about their project?
So the department has worked with them, but we did not actively recruit them. Missouri Partnership was a part of that, and they are a part of DED, right? So when we looked at the application and them applying and using the data center program, that all goes through DED. So that's where we come in.
Okay, that was the data center program trying to determine whether they qualify for incentives, or what's that do?
Correct. So the data center program was actually created in 2015. And it's a program that is really the legislators put forward to attract data centers to Missouri. So it's another tool in our toolbox that we use for economic development.
Okay. In the testimony on page 3, lines or 15 through 17, says, please describe Golden Plains Technology Park, and then there's a reference to a website, and it said diodeventures.com projects. Would you agree that Diode Ventures, I mean, that's a basically a Velvet website, correct? Rephrase that. Do you know whose website is shown on line 17, page 3 of the testimony?
You know, I went there several weeks back, but I don't recall at this point. I'm sorry.
Okay. So if I could have you look over at lines 3 and 4 of page 4 of the testimony, it says a pivotal component to success in, I assume that means in recruiting companies to Missouri, is the availability of highly reliable and redundant electrical power. Do you see that, ma'am?
Yes.
Why is Ms. Bell on the screen instead of Ms. Hathaway? Oh, well, never mind. Ms. Hathaway, I see that makes no reference to rates, and does that go back to the statement you made in regard to in response to Mr. Woodsmall, that you don't really look at utility rates?
Correct.
Okay. I think that's all the questions I have, Judge. Thank you, Ms. Hathaway.
Thank you.
Thank you, and that will bring us to cross-examination by Office of the Public Counsel. Mr. Kleiser.
I have no questions. Thank you, Your Honor.
Thank you, and that will bring us to commissioner questions. Again, we do have the commissioners on the WebEx. If you're on a phone, it is *6 to unmute. Do we have any commissioner questions for Ms. Hadaway? All right, hearing none, we don't have any bench questions, so that will take us back to redirect. For Evergy, go ahead.
Thanks, Your Honor. Just briefly, Mr. Keevil mentioned, or you mentioned in response to Mr. Keevil, the data center program. Do you recall that?
Yes.
And did Velvet qualify for incentives under that program?
Correct. So they're according to the statute that, again, that was set forth in 2015 by the legislators, the program, as long as you meet the requirements of the program, you're eligible for the benefits.
Okay. That's all I needed. Thank you.
Thank you, guys.
Thank you. And Ms. Hadaway, you are excused from our virtual witness stand. You are free to stay around in the WebEx. And I'm sorry, Mr. Steiner, were you going to request Ms. Hadaway to be excused?
I was, Your Honor.
Thank you. Ms. Hadaway, you are so excused if you wish. Let's move on to staff witnesses. Mr. Fortson? Yes.
Your Honor, one other preliminary matter I'd like to address.
Yes, Ms. Bell. Can you speak up?
Yes, I can. I was just wanting to ask the commission and the judge to go ahead and take notice of Schedule SIL and the special contract schedule and Schedule SSP. I also have 3 other agency records I would like the commission to take notice of and enter into the record.
Okay. Let me back up.
Okay.
You want to submit Evergy tariffs, SIL and SSP.
And the special contract tariff.
I think they should be separate exhibits, Judge.
I have them. They would be 301, 302, and 303.
Will you circulate those so we all understand what's being requested?
Ms. Bell, did you hear? Is your mic on?
Oh, I'm sorry.
Yes. Yeah, I can circulate them this afternoon.
Once I look at them, I can make a quick decision, but
Okay, I'll take care of that. And we're going to jump just a little bit ahead to what we would have discussed at the end of the hearing, and that is the submission of exhibits. All of the pre-filed exhibits, the regulatory law judge will take responsibility for making sure they are filed with the transcript. For the newly submitted exhibits, that will be an option, or the parties can email that. I'm setting a date of Friday for the submission of those exhibits. And Ms. Bell, I will set the same date for yours, and I will allow objections through Monday. Monday is also the due date of our expedited transcript. So let me state that again and make sure that we have enough time. Friday, parties will turn in any exhibits that have not already been received, specifically these 3.
And Your Honor, I
Yeah.
have 3 more as well. The staff brief and the stipulation in the Nucor case, as well as the stipulation in EO 2014-0151. I believe the commission can take notice or accept them as agency records under 536-070.
Thank you, that is correct.
Yeah, and so I believe the only objection, would be that for some reason the document isn't a true and accurate version of what it purported to be. But I would like the commission to at least rule today that it will accept notice of those documents, assuming they are the correct copies.
Okay, we'll go ahead and ask the other attorneys also. But let's go ahead and first deal with the three that Ms. Bell has offered. These are three tariffs that Evergy is in control of. Is that correct? What I'm trying to get to, Ms. Bell, is the commission is going to not take administrative notice of these. The commission is going to prefer that they be submitted as standalone exhibits so that they're a little bit easier to review, just for these three. So I'm just trying to find out do you have possession of the official copies, Ms. Bell, that you want to submit? Or is Evergy going to be submitting?
I have the copies that are available in commission records online.
Okay. And you are going to, 301 will be the SIL tariff.
Correct, Your Honor.
302 will be the SSP. And remind me, that's the solar?
Subscription program.
Thank you.
Pilot, sorry.
Pilot rider.
And
that was 302, Judge?
yes, sir. And 303 will be the special contract. Can you give me a little bit more on that, Ms. Bell?
Sure, I can give you the number off of it. It's the special contract rate, and it's revised sheet 141, 142, and 143.
Okay.
Judge, may I inquire of Ms. Bell regarding the special, the solar subscription?
Yes.
Pilot tariff. Ms. Bell, excuse me, on your version of the SSP tariff, Exhibit 302, are you showing that as revised sheet number 109 through 109.5?
Just confirming, beginning on 109 and yes, to 109.5. You're right.
109.5. All right. Thank you.
Okay. Okay. Ms. Bell, yes, please submit those three, 301, 302, and 303. If you have those, the commission would appreciate those being submitted today, but the deadline will be Friday. I will set a deadline of Monday for objections to 301, 302, and 303. Yes. And you had, you requested notice. Let me remember, it was the staff brief, the commission decision, and what was the third one?
It
Ms.
was,
Bell?
so the staff brief in EO 2019-0244, that's the Nucor case.
Mm-hmm.
In the non-unanimous stipulation and agreement in the same case. And then the non-unanimous stipulation in EO 2014-0151.
What's that?
0151. Can you give us a little description of that case, please?
Sure, that case, I believe, is the, let me just grab it here. Oh, I apologize. I think I had the case number wrong. It's the stipulation in ER 2018-0145. And that is the case, the stipulation that ultimately resulted in a commission order approving Schedule SSP.
ER what?
2018
Yeah,
0145.
145. That's not the case that 146 approved SSP.
Okay,
Ms.
they
Bell?
were, the non-unanimous stipulation states both case numbers. And again, I'm happy to email copies of this out to everyone today.
This one I can probably ask here presently. You said you want the staff brief from the Nucor case, is that correct?
Correct?
Okay, so let's call that one 304.
Okay.
Does anybody have any objections?
Your Honor.
Or does anybody have a request to think about it until Monday with, okay,
Regardless, can I ask for a motion, just clarification?
sure.
So is this a request to take notice, or are we introducing an exhibit?
That's right, I just did state an exhibit number. I apologize, this is why I'm much better in writing.
No, Your Honor, on these, under 536070, the commission can receive agency records as evidence. So I would prefer all of these, the tariffs and the records of the commission be accepted into evidence as exhibits. I just think it makes it easier on the commission because they've been referenced and it's allowed under the statute.
Ms. Bell, I appreciate your suggestion, but I'm going to let the commission make that decision. Let's get back to, you're asking to take notice, not for the exhibits. Are you asking to take notice of the staff brief in the Nucor case, correct?
No, I'm asking for these to be admitted into evidence. And yes, the staff brief.
For what purpose? I mean, that you can't just, I mean, that was a brief in that case. And pursuant to a stipulation, as she's indicated, there was a stipulation in that case. It's completely improper, I think, to introduce a brief from that case in here, unless she just wants to say, yes, staff filed a brief. I mean,
No, Ms. Bell has stated that she wants these admitted as exhibits. Therefore, we will follow that procedure and we will give her until Friday, the 28th, to submit these as proposed exhibits, and we will give all of the other parties until Monday, the 31st, end of the day, which is the same due date as the expedited transcripts. And I will take up her motion with the report and order if not addressed earlier.
and just to be clear, going back to Mr. Kleiser's point, you're having Ms. Bell submit them as exhibits, not taking official notice of them.
Ms. Bell strongly requested that is how I would phrase it. Ms. Bell, do you disagree?
No, I agree, Your Honor, and I can just, it might make it easier if I reference 536070 and under subsections.
That does not make it easier. I appreciate that you're citing the statute that gives the commission the permission to cite its own records, but that's permissible. So we're at the point where I'm just simply asking, is your request that the commission take notice or introduced as exhibits? And I thought I heard you state strongly that you wanted them as exhibits. Is that correct?
Yes, and in the alternative, if the commission were to deny that, then I would alternatively ask that the commission take notice of them.
Okay, thank you. So Ms. Bell, let's get the numbers then. 304 will be the staff brief from the Nucor case, which is EO 2019-0244. 305 will be the non-unanimous stipulation in the Nucor case, the same case citation. And Exhibit 306 will be the stipulation from ER-2018-0145, and I'll add 0146, as I would guess that those cases were likely consolidated in some regard. Have I summarized those? Go ahead.
They were, Your Honor, and I would just add that I believe there were multiple stipulations in that case, so I will clarify it was the one dated September 25th, 2018.
Did you have a specific date for the new court case, or is that just one stip?
It was just one stip, Your Honor.
Okay. All right. Thank you. That will take care of our exhibit discussion.
Your Honor, I was going to ask later to take official notice of some documents as well. Without trying to rehash all this, do I just simply send them around by Friday and follow the same procedure?
If you were going to ask to take notice, and I would assume that the documents were already in EFIS, my inclination would just be to ask the parties now.
Okay.
And if everyone agrees, then we'll take notice. If you want it, as Ms. Bell does, in an exhibit, then we'll follow that.
Okay, want me to do it now or at some other point?
Your call.
In the same new court case that Ms. Bell is discussing, that case was appealed, and there were 3 briefs filed in the state court's filing system. It's readily available to everybody. There was Evergy's brief, there was the commission's brief, and there was new court brief. For similar reasons as Ms. Bell wants to take notice of certain new court things, I would ask to take notice of those briefs, and I will circulate those by Friday.
Yes, thank you. I'd like to follow that procedure.
Okay? You want me to mark them as exhibits now? Or I could do them all as one exhibit? Your preference, Your Honor.
Let's go ahead and separate them.
Okay? Honestly, I don't know what my exhibit numbers are. Do you want to?
I don't think you have any.
There you go.
All right.
Can I just make them 900, 901, and
No, you
900?
have the signed them.
Oh, yeah, yeah. But I don't think you have any exhibits yet. What were your
But
numbers?
I don't know what my block is. Almost certainly.
300 is Velvet.
900 is going to
Or-
be safe.
900 it is.
Okay. So 900 would be the commission's brief in the new court appeal. 901 would be Evergy's brief in the same appeal, and 902 would be new court's brief in that appeal. And I already have them gathered, and I will have them to parties certainly by Friday, if not tomorrow.
Thank you, sir. Appreciate that.
Your Honor.
Mr. Fleiss.
I pose a question to the bench. I recognize you may not be able to answer this now, but I'm going to pose it anyways. Does the bench believe that it's necessary to take administrative notice of the tariffs that are currently effective for Evergy West in order for the bench to cite to those tariffs in its order, or for parties to cite to them? To be very clear, if I cite to Evergy West current tariff and say the residential service rate is X, does that need to be administratively noticed, or can we all just agree that it's there, it has the force and effect of law, and the commission has the authority to cite to it under the statute that Ms. Bell suggests?
I would think that's reasonable.
Then I don't need to take any administrative notice.
Okay, let's get back to witnesses. Mr. Fortson, thank you for your patience. Come on in, and I will swear you in. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth? Thank you, sir. Please have a seat. Mr. Keevil, your witness.
Thank you, Judge. Mr. Fortson, would you please, state and spell your name for the record?
Brad, B-R-A-D, Fortson, F-O-R-T-S-O-N.
Thank you. And are you the same Brad J. Fortson, actually, the testimony says, same Brad Fortson who, filed rebuttal testimony in this case?
Yes.
Do you have any changes or, corrections or additions you need to make to that testimony?
Not to my knowledge.
If I were to ask you the questions contained in that testimony, would your answer be the same as contained therein?
Yes.
Judge, I believe Mr. Fortson's testimony is exhibit number 100, and I would offer exhibit 100 into the record.
Are there any objections to the submission of exhibit 100, the rebuttal testimony of Mr. Fortson? Hearing none, it is so admitted.
Thank you, Judge. I would tender the witness for cross-examination.
Thank you, sir. And that goes to Mr. Kleiser.
Good morning. Good afternoon. Apologies. You would have to have a copy of the tariff submitted by Evergy and Belgium stipulation tariff. You turn to, I want to say, I believe it's paragraph 8 under additional provisions. The paragraph that starts, service under this tariff shall be excluded from. Apologies. There's a sentence that reads, the company will remove all identifiable costs of service under this tariff from the FAC charge recovered from all customers, and the company will track those costs and identify those costs separately from other costs specifically identified in the FAC monthly report submitted to the commission. Do you agree with that?
Yes.
Does that sentence address concerns that you had raised in your testimony regarding the FAC?
As far as my testimony went into a little bit more detail, as far as the tariff goes, this would cover the concern generally.
All right. Are there any additional language you would ask the commission put into a tariff to address the concerns you raised with regard to the FAC in your testimony?
I wouldn't say I would recommend or suggest any additional language, but I think the additional detail and attachments that I included with my testimony should be noted as guidance for what staff had in mind for separately tracking those costs.
All right, thanks. I have no further questions.
Thank you, Mr. Witzmal.
Very briefly, Your Honor. Good afternoon, sir.
Good afternoon.
Can you tell me what your title is with the PSC?
I'm the Regulatory Compliance Manager in the Energy Resources Department.
And in that role, you're responsible for fuel adjustment clause filings?
Yes.
Okay. And given that role, are you familiar with SPP charges, Southwest Power Pool charges?
Yes.
Would you agree that certain Southwest Power Pool charges are captured on an energy basis per kWh?
Yes.
And that other charges are captured on a demand basis per kW?
Yes, it can be, correct.
Okay. And costs may be incurred by Evergy associated with an MKT customer on either a per kW basis or a per kW basis. Is that correct?
That is correct.
Okay. And it is your belief that any incremental costs incurred, whether incurred per kWh, per kW, attributable to an MKT customer should be identified and separated out for that customer. Is that correct?
Correct.
Okay. let's take a situation where there are costs incurred by legacy customers, non-MKT customers. And an MKT customer comes on and there's no incremental cost. They are just free riding, if you will. Are you comfortable with that concept?
Yes.
Would you agree that some amount of those costs should be allocated and attributed to the MKT customer?
I would agree with that.
Okay. No further questions. Thank you, sir.
Thank you. And Mr. Mills?
Thank you, Judge. Mr. Fortson, in your pre-filed testimony, do you offer any reasons arguing that the commission should reject the MKT tariff?
I simply state for the reasons stated in Ms. Cleathermos's testimony, which has been adopted by Mr. Bush.
I understand. My question is, do you offer any of your own reasons in your testimony?
No.
That's all I have. Thank you.
Thank you, Mr. Mills. And Ms. Bell?
No questions, Your Honor.
Thank you. And Evergy?
No, thank you, Your Honor.
Thank you. Are there any commissioner questions? It is *6 to unmute. Any commissioner questions for staff witness Fortson? The bench does have a couple questions. I'm going to limit mine to the dueling Schedule 1s. And this is going to be the exact same questions I've asked the other witnesses. Let's take the Evergy and Velvet Schedule 1.
Okay.
Would you tell me which portions of this you oppose and why you find them not to be appropriate?
I can. I would like to make clear, maybe caveat that in my testimony, I only spoke to the FAC, so I can speak or answer what I can. What I can't, I will likely defer to Ms. Eubanks and Mr. Bush.
Thank you.
So most of this first page, I would suggest likely referring to, or deferring to Mr. Bush for first couple of these bullet points. For the substation voltage customer, I would offer that I believe in staff's testimony, or Ms. Cleathermos's testimony, which has been adopted by Mr. Bush, the concern with the substation voltage was that the
I'm gonna.
Sorry, go ahead.
I think you were right at the beginning. Your testimony was on the FAC, and I'm gonna just try and focus on that.
Perfectly fine.
The first time I see the FAC in the Evergy Velvet Schedule 1 is on page 5 of 7.
Mm-hmm.
Can you discuss their paragraph 5?
Yeah, so
Okay.
with that all being said, that makes this much simpler. So their paragraph 5 is, the language they have included is the exact same language that we have staff, OPC, and MECG have included as it pertains to the new sentence that starts, the company will remove, and ends with submitted to the commission.
Okay, so in some,
If I may.
yes, thank you.
I believe, as far as staff and I think staff, OPC, MECG, and the company go as far as the FAC, we are on the same page as far as the language that is included in the tariff and the idea that it will be the costs will be separated and tracked separately and identified similar to how it is in the SIL tariff.
Thank you. That made that clear. I have no further questions. Let's move back to cross-examination. Mr. Kleiser.
No question, thank you, Your Honor.
Mr. Woodsmall.
No questions, thank you.
Mr. Mills.
Sorry, I was on mute. No questions.
No, you're fine. And Ms. Bell?
No questions, Your Honor.
Thank you. And Evergy? I didn't quite catch that, Mr. Fisher.
I'm sorry, I have no questions.
Okay, thank you. And that will take us to redirect. Mr. Keevil.
Yeah, very briefly. Mr. Fortson, in response to Mr. Kleiser and the judge, I believe you mentioned separating and tracking the various costs that would otherwise flow through the FAC. And in response to Mr. Kleiser, you referred to certain conditions and parameters or something attached to your testimony. Could you turn to those, I believe it's Schedule BJF dash R3 and BJF dash R4 to your rebuttal testimony?
Yeah, I'm there.
Are those the separation and tracking conditions to which you're referring?
Yes. BJF R3 sort of details what is recommended to be separated and how to be separated. BJF R4 would be more of an illustration of how that would be separated.
And the Schedule BJF R3, where does that come from? Is that from, obviously it's just a few pages of another document. Is that from a stipulation or what's that from?
Yes, that was, give me just a moment. That's from the non-unanimous stipend agreement filed in case number EO 2019-0244.
244, that's, okay. Are you asking that the commission in its order approving the tariff include these conditions on Schedule BJF R3?
It would be my recommendation that in approving, along with approving the tariff, it would be noted that it should be ordered to be tracked the way I have suggested and identified the way I've suggested.
And when you say approving the tariff, are you referring to the tariff attached to the OPC, MECG, and staff stipulation?
I am.
All right. That's all I have, Judge. Thank you.
Thank you, Mr. Fortson. You are excused. Engineer Eubanks, please come to the witness stand.
Where's the test? Yeah. Judge, before you, sorry, turn my mic on. Before you swear Ms. Eubanks in, this may short circuit part of what Ms. Bell was talking about earlier. I would like to introduce as a demonstrative, at least at first, well, no, I wouldn't say it. Just introduce as an exhibit. I think my next exhibit's 104. This is the SSP tariff that Ms. Bell was referring to earlier.
Thank you, sir. You're welcome. Okay. Exhibit 104 of appears to be a solar subscription pilot rider. It is marked KCP&L, Greater Missouri Operations Company, and it is PSC Mo number 1, second revised sheet number 109, and then that continues point 1, point 2, point 3, point 4, and point 5. Are there any objections to the admission of Exhibit 104, which is the solar subscription pilot rider, onto the hearing record? Hearing none, it is so admitted.
Thank you, Judge. All right, oh, I'm sorry, you still have to swear.
I sure do.
Myself. I'm sorry, Judge.
Thank you. Ms. Eubanks, do you solemnly swear or affirm the testimony you give in this hearing will be the truth?
I do.
Thank you. Mr. Keevil, your witness?
Yes, ma'am, would you please, state your name and spell it for the record?
Claire Eubanks, CLAIRE EUBANKS.
Thank you. And have you caused to be prepared for this case, what's been marked as exhibit number 101, the surrebuttal / cross surrebuttal testimony of Claire M. Eubanks?
I have.
Right. And, if I were to ask you the questions contain, well, first of all, do you have any changes or corrections you need to make to the testimony?
No.
Okay. If I were to ask you the questions contained in Exhibit 101, would your answers be the same as contained therein?
Yes.
Judge, with that, I would offer Exhibit 101 into the record.
You have heard the motion of counsel. Are there any objections to the admission of Exhibit 101, the testimony of Claire M. Banks, professional engineer? Eubanks, sorry. Hearing no objections, it is so admitted.
Thank you, Judge. I would tender the witness for cross-examination.
Thank you, and that goes to Mr. Kleiser.
Good afternoon, Ms. Eubanks.
Good afternoon.
All right, yesterday I had a conversation with, Evergy witness Brad Lutz, and I tried to walk through how the ResRAM was going to work as it's proposed in Evergy / Delta's tariff. I don't know if you recall that.
I do recall.
I'm going to go through the same exercise with you, just for the sake of the record, so it's very clear how the OPC MECG staff proposal will work, okay?
Okay.
We're going to do it as a hypothetical. I've asked you to live in the world of Evergy. I'm going to be a customer who takes under the MKG tariff, all right? I have a 100 megawatt load requirement. I'm buying 100 megawatts from you. You have 100 megawatts of retail sales. Do you agree with that?
I do. I do have one clarifying question.
Go for it.
You mentioned ResRAM. Did you mean to say renewable energy standard requirements? Are we talking about the RES requirements or the adjustment mechanism?
We'll get to that in a second.
Okay, sorry.
All right, so, just to repeat, I have 100 megawatts load, I'm buying 100 megawatts from you, you have 100 megawatts of retail sale, correct?
Correct.
All right, under the RES statute, which is the renewable energy standard, 15% of that has to be renewables. Or it either has to come from renewable energy, which means they can either build or you can buy RECs, correct?
That's correct.
All right, if I, as customer, purchase 100 megawatts of renewable energy credits and retire them, I can claim all of my energy was renewable, correct?
The customer is retiring all the renewable energy credits,
Yes.
which is, it's measured in megawatt hours, but for 100 megawatts of load,
Yes.
yes.
But that doesn't change the fact that Evergy still has to meet its RES requirement, correct?
That is my position, yes.
All right, so that's the problem. The solution that's been put forward in the OPC MECG staff tariff, I'm going to attempt to paraphrase it, and I'd like you to tell me if you think my paraphrasing is correct. Effectively, there's going to be a charge placed in the contract, and if that charge covers the cost that Evergy incurs to meet the renewable standard, the customer will not have to pay a ResRAM.
If it covers the incremental cost attributable to that customer that is not being provided for in another way through some other kind of support charge, then yes.
Okay. And just to piggyback on what you just said right there. If, under our scenario, you as Evergy already had 30 megawatts of renewables, there would be no incremental cost charge to serve me under the res, right?
That's correct.
In which case, me as customer would have to pay nothing under the tariff for the res ramp.
Correct.
All right, I think I've nailed that one down. So one other thing really quick. Were you here yesterday during the testimony of Mr. Darren I from Path Energy?
I was,
And do you recall,
most of it.
do you recall Mr. Ives testifying effectively that if the commission is to order the OPC staff MECG tariff, the company will either not offer contracts or not move forward with the tariff?
I recall that conversation.
Were you involved in case ET 2021-001, 0151, the Evergy electrification docket?
Yes,
Did you read the testimony of one Chuck Casely filed on behalf of Evergy in that docket?
I did.
Do you recall Mr. Casely making a very nearly similar statement in that docket, arguing that if the commission did not grant the application as put forward by Evergy, Evergy would cease pursuing electrification in the state of Missouri?
I do recall testimony very similar to what you just said.
Did the commission just grant the application put forward by Evergy, or did they make modifications to that application?
I believe they made some modifications to the application. That's my recollection.
I have no further questions. Thank you.
Thank you, Mr. Kleiser. That brings us to Mr. Witzmo.
Taking off of that last question, do you ever get involved in MIA cases, or are you familiar at all with MIA cases?
Generally, but I'm, actually, Mr. Fortson was probably the better witness
Okay.
for MIA cases.
Do you recall if Evergy made a similar threat in a MIA case, that if the commission didn't approve their MIA case, the commission or Evergy wouldn't do any energy efficiency?
Personally, I don't recall.
Okay. Were you here earlier when well, let me start with laying some foundation. What is your role at the PSC?
I'm the manager of the engineering analysis department.
And in that role, are you responsible for RESRAM matters, solar subscription matters?
Renewable energy standard compliance, I have worked on the RESRAM for prudence reviews. Those duties are shared between different departments. Solar subscription riders, yes. Renewable energy purchase schedules, yes. Net metering, informal complaints related to solar and net metering and like, yes.
Okay, previously, Mr. Keeble marked Exhibit 104 regarding Evergy Solar Subscription Pilot Rider. Do you have that?
I do.
Were you here earlier when Mr. Brubaker testified?
I was.
And did you hear him talk, to some extent about the Solar Subscription Pilot Rider?
Yes.
Do you agree with what he was saying about that?
Not entirely. I think he mentioned that Evergy would potentially procure a PPA under the solar subscription rider. That's not accurate to my knowledge. They're intending to construct either a solar resource source in Evergy, Missouri West or Evergy, Missouri Metro, those service territories. And then also, I think it's really important to note that the customers under that tariff are subject to the RESRAM charge.
So are you saying, even though they make a separate payment to be sourced from a solar subscription, the solar facilities, they pay extra for that and they pay the RESRAM?
They pay the RESRAM charge based on the sales under that subscription rider, yes.
Okay. And is that also true with, I believe Mr. Lutz called it a renewable energy program? Are you familiar with that?
I am familiar with that. I haven't reviewed that specific tariff, but yes, to my knowledge, the only tariff that is not subject to the RESRAM is the SIL tariff.
Okay, so under the renewable energy program, those customers pay extra to be sourced from a renewable facility, and they still pay the RESRAM as well.
Yes, and those recs under the renewable energy purchase schedule are retired on those customers' behalf. So they are getting the renewal attributes associated with the program also.
Gotcha. I have no further questions. Thank you.
You're welcome.
Thank you, Mr. Woodsmall. Let's move to Mr. Mills. Any questions?
I have no questions. Thank you, Your Honor.
Thank you. And Ms. Bell, any questions?
Yes, Your Honor. Ms. Eubanks, with respect to the SSP program,
Ms. Bell, can you speak up just a little bit, please?
I can, Your Honor. With respect to the SSP program, the customer, let's do a hypothetical. If the customer's energy usage is 50 kilowatts, and if the customer also has 50 kilowatts of solar energy under the tariff, are those two items netted? Those two items are netted, correct?
Your Honor, as an initial matter, and I don't want to be a pain in the ass here, she's talking in terms of kilowatts, which are demand. And I believe the relevant unit is energy kilowatt hours. So if she could rephrase just for the clarity of the record.
Yes, thank you. So if you'll turn to revise sheet 39, or if you'll turn to monthly billing,
I'm there.
okay, and under 2, the participants' kilowatt hours, which are for solar resource energy, are subtracted from the energy consumed, correct?
That's correct. It's very similar to net metering in that the usage is netted with the generation. The difference between net metering and this program is that Evergy will have its own resource, whereas in net metering, it's, you know, on a customer's home or business.
Okay, so in a hypothetical, if a customer has 50 kilowatt hours of solar resource production and their usage is 50 kilowatt hours, then their energy use is 0, correct?
In that hypothetical, off the top of my head, I don't recall that they can fully subscribe 100% of their usage, but yes, in that scenario.
Okay, if you if you look again under monthly billing, under number 2, in the second sentence, you'll agree it states, should the solar resource energy production amount for a given month be larger than the participant's metered energy consumption, the net energy will be 0 for that month, correct?
So the retail electric sales to that customer in respect to energy would be 0 for that month.
And you would agree that any sort of RESRAM charge times by 0 would be 0, correct?
If you're asking if the RESRAM charge is KWH charge,
Yes.
that is correct.
No further questions, Your Honor.
Thank you, Ms. Bell. And that moves us to Evergy.
Thank you, Judge. Good afternoon, Ms. Eubanks. Can you hear me okay?
I can.
Okay, great. I just have one or two little areas I'd like to clarify. In discussions with public councils, you were talking about the recent transportation electrification case and Chuck Caisley's testimony. Do you recall that?
I do.
Did you happen to attend the hearings in that case and hear Mr. Caisley testify from the stand?
I participated virtually as much as I possibly could. And
Okay.
I didn't catch his testimony.
do you recall, I'm sorry, what did you say about his testimony?
I do recall his testimony. I don't know if I saw all of it or not.
Okay, great. That's fair. Do you recall that he was crossed and also had a conversation with several commissioners where he clarified those statements that public counsel was asking about?
I do recall there being testimony during the hearing on that.
Do you recall that he indicated that Evergy was looking to obtain the Public Service Commission's view of how they should proceed with transportation electrification, and particularly what role should the utility play in that marketplace?
That sounds like a fair summary of his clarification.
Do you also recall that Chairman Sylvie made a statement? He was glad to hear that testimony because he had interpreted his pre-filed as more of a demand or threat.
I don't recall that specific statement.
Okay, thank you very much. I appreciate your testimony.
Thank you.
Thank you, Mr. Fisher. Now we come to any commissioner questions for Ms. Eubanks. Are there any commissioner questions for Ms. Eubanks? All right, hearing none, the bench does have a couple questions. These are going to be the same tariff questions I've asked. So if you would please pull out the Evergy Velvet Schedule 1 from their non-unanimous stipulation filed Monday.
Judge, if I could just jump in here, similar to Mr. Fortson, who was just on the FAC, Ms. Eubanks is really, I think it's fair to say, just on res ram related matters. If either one of you can disagree with me on that, but I just wanted to point that out.
My first question is, Mr. Bush, the better person to ask my standard questions of why staff disagrees with the Evergy Schedule 1 and what staff likes about theirs?
Yeah, I'm happy to attempt, but I can focus on the res ram too.
Yeah, let's stick with the res ram, and we will let Mr. Bush delve into the others. Yes, please discuss, let me find it. Paragraph 6 under additional provisions in the Evergy Velvet Schedule 1.
So staff's concern with the res ram tariff language is the concept of subtracting renewable attributes from the calculation of total retail electric sales under the Renewable Energy Standard compliance. So that's 20 CSR 4240 20.100. So, and then just generally, all customers pay the res ram charge. The only customer tariff out there that is not subject to the res ram charge is the special incremental load, which is Nucor. We've talked about quite a bit today and yesterday. The one major difference in my mind between the special incremental load tariff and this arrangement is that Evergy is contracting the PPA for Nucor under that tariff, but is retaining all renewable energy credits. And my understanding from that case is that Evergy is retiring those on behalf of the Renewable Energy Standard compliance, not on behalf of Nucor.
You mentioned in your testimony when you were talking about the private company in the early hypothetical, a private company would be retiring the credits, and you said that they would accrue whatever benefits there were for that?
So in my discussion with Mr. Klein.
Yes, but my question is, can you fill me in on that? I don't know what a private entity, I get where the utility is going to be using that, but I don't know what the benefits are for the company.
So a lot of large customers and even small customers are interested in encouraging renewable energy development locally and on different scales. So there is a market for renewable energy credits that is both voluntary and for state compliance like our renewable energy standards.
Okay, so the utility turns it in to meet a statutory requirement. So let's take a hypothetical company, shelve it, and they want to retire it on their own. Is it the proverbial gold star that they're after, or is there some other benefit, either economic or regulatory?
So just speaking of renewable energy credits, and not
Yes.
maybe the benefits of entering into a PPA on the market.
I get that, because then Evergy gets to keep it and they can turn in the credits. My question is, I don't understand why Velvet wants it. I just don't get it. Can you, and I don't want to put too fine of a point on it, but I don't know what those benefits are. Are they goodwill for the company, or is it a more tangible, there's some economics underlying this?
I believe it's probably more, their corporate standards that they, and I don't know what those are, to be fair. A lot of large companies are interested in being, some percentage renewable. And so one way to demonstrate that is having renewable energy credits that they're, retiring on their own behalf, or having someone else retire for them.
So having the retired credit makes it verifiable?
Yes.
Okay.
And that is, really gets to staff's concern with this tariff language, because Evergy is asking the commission from a variance from the existing renewable energy standard requirements that Evergy needs to make based upon renewable energy credits that Velvet, intends to acquire somehow, and use for their own voluntary purposes. So they're adjusting the requirement, not the actual, they're not double counting a single renewable energy credit, but they're both claiming the same megawatt hours of electricity in a way, in my opinion, if that helps.
But only one entity is, what did we call it, retiring the credit?
Only one entity is retiring the credit under what they're proposing, and that is Velvet.
Can you distinguish the new core allowance variation for RESRAM versus the current
Yes.
case?
Yeah, like I mentioned before, under the SIL tariff, and it's not in the tariff or the stipulation to my recollection, but having participated in some of the technical discussions and reviewing data request responses, Evergy represented to staff that the PPA that they will acquire under the new core tariff, any renewable attributes, I guess I should back up. The renewable attributes needed for RES compliance would be retired by Evergy. So Nucor is not, to my knowledge, retaining all renewable attributes related to that one PPA. I'm not sure that they're retaining any of them, but I know Evergy represented they would retire credits.
Credits from their existing stockpile of credits, or credits from the energy that they are getting to the PPA to service Nucor? The latter.
The latter.
Thank you. Help me understand the difference, because both credits are being retired. Help me understand why staff is okay or accepting of the new core RESRAM variance.
Evergy will be retiring renewable energy credits from the PPA being used to serve Nucor for its Missouri res compliance. The difference in this case is that Velvet is doing whatever they're gonna do. You know, I think
Get their own power.
they're getting their own power. It's gonna be somewhere in SPP, we don't know where. We don't know if they're constructing, we don't know if it's a PPA, but it's going to be renewable energy. They will get renewable attributes, renewable energy credits. My understanding is they intend to retire 100% of those for their corporate reasons.
And so, in the normal course of business, Evergy would be buying the electricity, and then it would go through the RESRAM calculations for credits, increasing their usage, which increases the credits that they need.
So the RESRAM is the adjustment mechanism, which
Yep.
is really related to the cost side. It's a little bit more complicated.
Yes, thank you.
But for the standard, yes. And, you know, they report on that annually. We review, the rec balances and how many recs they retire. That is part of my department's responsibility.
So, maybe re-explain what the variance is in the new core.
So the variance in, the stipulation and agreement is they want to change how the res requirements are calculated. So, per the statute, they need to supply 15% of their sales through renewable energy, which means the more energy they sell to customers, their requirements will go up.
So the variance that they got in the new core case is they don't have to count.
There is no variance in the new court case. That's what they're requesting in this case.
Okay. Sorry
For not being clear on that.
I think that was my fault on not being clear. I'm gonna stop there.
Okay.
That brings us to recross examination. That goes to Mr. Kleiser. Thank you, sir.
Well, it's funny you say that because I'm gonna pick up from there. I think I can bring it down really quick though, if we're gonna go back to my hypothetical. In this case though, I'm now Nucor, and I'm taking service under SIL,
Okay.
and I still need 100 megawatts of load.
Yes.
And you're still Evergy. So in order to supply the 100 megawatts I need, you're going to enter into a purchase power agreement, right?
That's correct.
And the purchase power agreement that you, Evergy, enter into to serve me is gonna have some renewable components to it.
That's correct.
Now, I'm paying you for that PPA,
Correct.
and you are gonna retire the RECs that come from that PPA yourself.
That's right.
So I pay for the energy, you retire the RECs.
Correct.
Now we switch over back to MKT. In that situation, if I'm taking under MKT, I'm paying you for the energy and I'm retiring my RECs.
You are, yes, correct.
That's the difference. Who retires the RECs?
Correct.
If I was a customer of MKT and I bought my RECs and gave them to you to retire them, would that also solve the problem?
That would.
But then I wouldn't be able to claim that all my energy was renewable.
Correct.
And as to that point, I think this got out, but let's make sure it's very clear. Velvet Tech does not have a legal obligation, to your knowledge, to be 100% renewable.
Not to my knowledge, no.
They might have a good internal reason, but that's on them.
Correct.
As one last thing, the difference between the OPC MECG staff tariff proposal and the Velvet Tech Evergy proposal. On the very end of the OPC MECG staff proposal, it states that I want to find the exact language here, so give me 1 second, I'm sorry. You would agree that the last sentence reads, and this is again from OPC MECG staff, in such an event, all monies collected to the Renewable Energy Contribution Charge shall be used to offset Evergy Missouri West's RESRAM revenue requirement. Is that correct?
That's correct.
And the reason for that is to prevent Evergy from effectively double dipping if it both gets a payment from MKT customers and customers of the RESRAM.
So my understanding is it would apply those collections to the RESRAM revenue requirement. Yes,
You would agree that's an important provision to have in there?
I agree.
Well, I'll leave it to your counsel to clean that up if necessary. I have no further recall. Thank you.
Thank you, Mr. Kleiser. Mr. Witzmal.
Very, very briefly. Currently, Evergy West has a number of customers. And let's say a hypothetical, their sales to all their customers, including Nucor, is 100 kilowatt hours.
Okay.
Evergy retires all the RECs necessary for compliance for all those sales, including Nucor. Is that correct?
That's correct.
Okay. Under the SIL, what the company wants to do is exempt all the sales to the MKT customers so that Evergy doesn't retire them. Those customers somehow retire those on their own. Is that correct?
So my understanding is they're just lowering the requirement.
Does that?
There is some, in the stipulation, I think there's some, documentation considered. Is that what you're asking?
Well, I'll go to the next question. Does that affect your department's ability to verify these RECs in compliance with the REC statute?
So we do have access to all the electric utilities, electronic tracking of their renewable energy credits, anything that's in the North American Renewables Registry for our utilities we have access to. I think there was some attempt in the stipulation to provide information. It's not necessarily what, I'll have to look at it. I think they acknowledged, needing some sort of documentation. But really it's that they're changing what the requirement is, regardless of, whether they're retiring RECs or not.
Gotcha. Thank you so much.
Sure.
Thank you, Mr. Witzmal. That takes us to Mr. Mills. Any questions?
No questions. Thank you.
Thank you, Counselor. That takes us to Ms. Bell.
Thank you. Would you agree that the purpose of the renewable energy standard is to ensure that 15% of energy is renewable?
% of energy, 15%. I would agree that the sales made by our investor-owned utilities must demonstrate that 15% of those sales are sourced from renewable energy.
And why? Okay, okay. And would you agree if Evergy was currently sitting at 15% renewables and Velvet documents in the NAR system that it is bringing 100% renewables to the SPP, which cover its load from Evergy, that following Velvet being added to the system, there will be more renewable energy than less.
That was a very long question. I will tell you the part that I agree with, and that is that Velvet has represented in the hearing today that they intend to procure renewable energy resources at 100% of their load.
And you would, so turning to the Evergy Velvet stipulation, if you look at the RESRAM provision in paragraph 6, if Velvet, for any kilowatt hours not supported by renewable energy, then those kilowatt hours would be subject to the RESRAM.
I'm sorry, can you rephrase the question?
Sure. In reading paragraph 6, if Velvet fails on its commitment to make 100% renewables, if it comes in at 50%, then the kilowatt hours not supported by renewables would be subject to the RESRAM. Or not meeting the, okay, strike that question. Okay. You would agree with me that if a Schedule MKT customer does not have renewable attributes equal to the existing renewable energy standard, then the customer would be subject to the RESRAM.
I'm sorry, can you repeat the question?
No further questions.
Thank you, Ms. Bell. That takes us to Evergy. Any questions from Evergy?
Yes, just briefly, Judge. Ms. Eubanks, you had some questions regarding the Nucor situation, and that is under the SIL tariff, correct?
That's correct.
Now, service under that tariff, are you familiar with a provision that says that service under this tariff shall be excluded from projected energy calculations used to establish charges under riders FAC and RESRAM?
I don't have the SIL tariff in front of me, if you could somehow.
Yeah, well, I think your counsel has maybe put that into the record, but rather than take time to find it, are you familiar with that basically the service from the Nucor service is used as it's excluded from the FAC and the RESRAM?
Off the top of my head, I believe they are excluded from the RESRAM, but I don't have the tariff language in front of me.
Okay, well, I think we could just quote that in the brief, but I think there's a provision that says service under this tariff shall be excluded from projected energy calculations used to establish charges under riders FAC and RESRAM. Would that surprise you?
To my recollection, that sounds familiar.
Okay, great. The other area, in your role at the commission, you'd be quite familiar with the RES and RESRAM's rules that the commission has. Is that right?
Yes.
Is it correct that under those rules, the RES portfolio requirements are based on total retail electric sales of the electric utility?
Yes.
And then there's a definition in the rule, is that right, of total electric sales?
There is a definition in the rule.
And is it correct, there's not a definition of that term in the statute, but it refers to the commission shall establish rules, is that right?
Judge, I'm going to object that because I don't think the statute even uses that term.
So it's not defined in the statute, correct, Ms. Eubanks?
It uses the term electric utility sales.
Right, and that total retail, excuse me, I think the term in the Res Ram rule says that total electric retail sales or total retail electric energy usage means the megawatt hours of electricity delivered in a specified time period by an electric utility to its Missouri retail customers as reflected in the retail customer's monthly billing statement. That's a definition in the Res Ram statute. And is it your understanding that that's one of the areas the company is asking for a variance?
Judge, I'm going to object. If Mr. Fisher is testifying, he can take the stand, but I don't think what he read, he claimed it first to be a rule, then he claimed it to be a statute. And whatever is in the rule or in the statute speaks for itself, and he can cite that in his brief.
If I misspoke, I was referring to the rule, but I'll withdraw that question. I'll just ask you this one. Ms. Eubanks, is it your understanding the company's asking for a variance from the Res Ram or the Res rule itself?
It is my understanding that the company is asking for a variance from the Renewable Energy Standard rule. Yes.
Thank you. That's all I have. Thank you.
Thank you, Mr. Fisher. Ms. Eubanks, you are excused from the witness stand.
Going to do a little redirect.
Oh, thank you.
Thank you.
Gosh darn it, we're recording this thing, everyone's gonna know. Yes, Mr. Keevil, let's go back to redirect.
All right. First, let's start out with, let's work backwards here. You've been receiving a lot of questions about the Res Ram charge and the Res requirement. Now, explain, is there a difference between the Res Ram charge and the Res requirement?
Yes.
Would you please explain the difference between those two and what those two represent?
Sure. So when we're talking about res requirements, it's the Renewable Energy Standard, which is a statute that requires the utilities to provide electricity from renewable energy resources. And that's based on their sales that they make. The highest level of the standard is 15%, and it starts in 2021 at 15%. There were stair steps before then, and continually, continues at 15% annually. When we're talking about the Renewable Energy Standard rate adjustment mechanism, that's intended to represent all costs and all benefits related to compliance with the Renewable Energy Standard. And that's a charge that per Evergy's tariff is assessed to all customers.
So getting a variance from a charge wouldn't necessarily mean a variance from the res requirement, correct?
That's correct.
All right. Now, there's also been a lot of talk here about the rule regarding the res. Is there also a statute that talks about the res?
There is.
And to your knowledge, I know you're not a lawyer, but to your knowledge, does the statute and the rule, let me back up. Does the statute use the phrase total retail electric sales, which Mr. Fisher was referring to?
It uses the phrase electric utilities sales. The rule uses the phrase retail electric sales.
So
Total retail electric sales.
So there's different rules, different references, different terms.
To me, they mean the same, but the words are different.
Okay. when you, going back to one of the examples that Mr. Kleiser, I think it was, or maybe it was the judge, Velvet is my understanding of, is it, who's going to be doing the contracting here? Velvet is going to somehow execute, is buying its own energy through, SPP?
So my understanding is for renewable energy, is that your question?
Yes.
For renewable energy, my understanding is they will do something, whether it's procuring a wind PPA somewhere in SPP. But I think Mr. Brubaker indicated it could potentially be construction of a resource.
Okay. Now, getting away from Velvet specifically, and the MKT customer, will an MKT customer cause Evergy's RES requirement to go up?
Yes.
Okay. And that's true regardless of whether, of where, how do I say this? I'm trying to distinguish this from the Nucor. The Nucor situation, Evergy got the PPA for Nucor and got the RECs itself, correct?
Yes.
Okay. That's not necessarily what's happening here.
Correct.
So even though Evergy and the MKT customer have a different relationship than under the SIL tariff, the Evergy RES requirements are still going up because of these MKT customers.
Exactly.
All right. And do you see a distinction there between the SIL tariff and the MKT tariff in that regard?
So I don't think renewable energy standard compliance or RES-RAM is specifically in the SIL tariff. I don't know that those phrases exist in the SIL tariff.
Well,
but I don't have it in front of me, unfortunately.
The only language I am aware of in the SIL tariff regarding the RESRAM is that which Mr. Fisher read to you just a moment ago. The service under this tariff shall be excluded from projected energy calculations used to establish charges under riders FAC and RESRAM and NEO programs. Now.
Yeah, so that is not the same as RES requirements for the renewable energy standard. That's for the RESRAM charge.
Okay.
Yeah.
So this, okay, I'll just leave that. Going back to the SST tariff, which I think is Exhibit 104. Ms. Bell had you refer to paragraph 2 under monthly billing. Can you explain to me your understanding of the relationship of that paragraph to either the RESRAM or the RES requirements?
Yeah, so similar to net metered customers, their net energy usage is what they're being billed on. So to the extent the renewable energy standard applies to what those customers are using, it is a net amount. So the solar subscription pilot rider is similar in a way to virtual net metering. So what's different under the solar subscription pilot rider and the schedule SKT, the one that was the market rate. MKT, I'm sorry. The MKT schedule is that the energy usage is being netted within that solar subscription pilot rider. So all the other components that go into sales and also, you know, I should also note that the cost of the resource is, you know, incorporated into other portions of that rate. I don't know if that answers your question.
Okay, no, I think it is. Ms. Bell was asking you about if the energy, the net energy for a month was zero, then would that make your RESRAM charge zero?
So if there was no energy usage, there would be no sales to the utility company, and then there would be no res compliance requirement.
Okay. If there were no sales?
Yes.
Okay. And can I have you flip over to the last page, the 109.5 sheet? And, you see a section there that's called adjustments and surcharges?
I do.
Could you read me that, it's a fairly short section, read that to me?
The rates here under are subject to adjustment as provided in the following schedules: fuel adjustment clause, Fuel Energy Standard Rate Adjustment Mechanism Rider, RESRAM, Demand Side Investment Mechanism Rider, DSIM, Tax and License Rider.
So what does that mean to you? What does that section mean to you?
It means customers using the solar subscription pilot rider will pay RESRAM charges based on their usage.
I think that's all I have, Judge. Thank you.
Thank you, Ms. Eubanks. You're excused. Mr. Bush, hold on just a moment. We are going to go ahead and take a break to stretch our legs. Everyone come back at 3 p.m., 3 o'clock sharp. That is 13 minutes from now. We're at recess and off the record. The hour of recess having expired, let's go back on the record. Mr. Bush, let me go ahead and swear you in. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you. Please have a seat. We are continuing the hearing in EO-2022-0061. We are beginning with the testimony of Mr. Jim Bush, who is adopting the testimony of Robin Clethermes. Mr. Keevil, your witness.
Thank you, Judge. Sir, would you please state your name and spell it for the record?
My name is James Bush. Bush is spelled B-U-S-C-H.
Thank you. Now, are you adopting in this proceeding the previously pre-filed testimony of Robin Clethermes?
Yes, both the rebuttal and surrebuttal testimony.
Thank you. And when Ms. Clethermes filed this testimony, were you her supervisor?
Yes.
All right. Now, have you read both pieces of testimony?
Yes, I reviewed it before it was filed, and then I have read it again.
Okay, thank you. Are there any changes or corrections you need to make to either Exhibit 102 or 103?
Not to my knowledge.
All right. And I should have said earlier, I apologize, the rebuttal testimony has been marked as Exhibit 102, and the surrebuttal/cross surrebuttal has been marked Exhibit 103. Mr. Bush, if I were to ask you the questions contained in Exhibits 102 and 103, would your answers be the same as contained therein? Substantially the same?
Substantially the same, yes.
Judge, with that, I would offer Exhibits 102 and 103.
Thank you. You've heard the motion by counsel. Does anyone have any objections to the admission of Exhibit 102 and 103, the rebuttal and surrebuttal of Robin Clethermes, adopted by James Bush? I'll take both questions in one motion. Does anyone have any objections? Thank you. Let's not parse my question. Hearing no objections, Exhibit 102 and 103 are admitted onto the record.
Thank you, Judge. With that, I would tender the witness for cross-examination.
Thank you. That takes us to Mr. Kleiser.
Good afternoon.
Good afternoon.
Mr. Bush, would you happen to have a copy of the stipulation tariff that was attached to Schedule 1 to the Evergy and Velvet Tech IAM and stipulation agreement?
Yes, the one filed a couple nights ago?
Yep.
Yes.
Can you turn to page 5 of 7 of Schedule 1?
I don't see that mine has pages 5 of 7.
All right, I'm under additional provision.
Yes.
Continue. Okay. I'm looking at paragraph 4, second paragraph beginning, not participating customers.
I was looking at ours. My apologies. Okay, yes, I'm there.
All right, okay. So I'm gonna ask you a couple of questions kind of related to this paragraph. So I just want to read the first sentence and make sure that it's accurate. Non-participating customers shall be held harmless for any deficiency in revenues from the cost to serve for which the rates were designed to recover by any customer served under this tariff. Did I read that answer correct?
You did.
All right, now let's just take that sentence alone in isolation. In your opinion, as a regulator, if there is a deficiency in revenue between the cost to serve a customer who takes under this tariff and what's recovered in rates, or rather through the contract under this tariff, that deficiency cannot be recovered from non-participating customers. Is that how you would interpret that?
I'm sorry, could you repeat that one more time?
Sure thing. In your opinion, as a regulator, if there is a deficiency between the cost to serve a customer who takes under this rate and the contract revenues provided under this rate, that deficiency cannot be passed on to non-participating customers.
That's how I read that sentence, yes.
That sentence, okay. Now, we add in the next sentence, which reads, it is expressly recognized the company and Schedule MKT customers shall have the right to present evidence for the commission's consideration of other economic benefits as a result of scheduled MKT customers taking service from the company. Would you agree with me that that sentence modifies the prior one and changes the answer slightly?
Yes, it is, the way I read that sentence, it is allowing, further evidence to be put forward by the company, in this case, Evergy, to, explain why other customers may not be held harmless.
So you would agree with me, if that sentence is included, it is possible that non-participants may be required to pay for part of the cost of serving MKT customers in the result of a revenue deficiency.
That is my understanding, yes.
All right. Would you agree with me that the inclusion of that language will make it marginally more likely that contract reviews under this tariff would become more contentious?
Yes, I would imagine that that would, include further review and further discovery and further, it would make it much more difficult, yeah.
If you were in charge of a utility and you were operating under a contract like the one that, sorry, not the contract, let me back that up and start. If you were in charge of a utility and you were operating under a tariff like what Evergy and Velvetech have put forward, and it has this language in here, would you agree that you'd be slightly, I'm going to start over again. I apologize. If you were a utility and you were operating a tariff that did not have this language, so it was just the hold harmless, would you agree that you would be slightly more cautious about entering into a contract with a prospective customer?
Yes,
You would put more effort into making sure that the contract you signed recovered all costs, correct?
yes,
And that's because if it doesn't, it's you who are on the line for making up the deficiency.
depending upon how, a subsequent contract was written with a customer, but for the most part, yes.
All right. Now, you're familiar with the schedule SIL that's currently in effect in Evergy West.
I have become familiar with it over the last couple of days, yes.
Fair enough. Would you agree with me that the language included in the OPC MECG staff tariff related to the hold harmless provision is primarily adopted from the language found in Schedule SIL?
I believe that was a part of the testimony that, that Ms. Cleathermos wrote that I'm adopting, and that the intent of what we were, writing and, that we came to an agreement with MECG and OPC is substantially the same or similar to that language.
Are you aware of any significant differences between the Schedule SIL and the MKT tariff and the facts surrounding them that would make it uneconomic to include the same hold harmless language in SIL in MKT?
I am not aware of any.
You do not know of any differences between the SIL tariff and the facts surrounding that, and the MKT tariff and the facts surrounding that would mean it's uneconomic to use the exact same language from the SIL tariff and MKT?
Nothing has been brought to my attention.
There's one last question. While other parties will be able to review any contract that is filed, it is only Evergy and the customer who are originally negotiating the contract to be filed pursuant to this tariff, correct?
Yeah, the only negotiations I know before the contract will be between Evergy and any customer that they might want to allow to be on the MKT tariff.
All right. Thank you very much for your time. I have no further questions.
Thank you, Mr. Kleiser. That takes us to Mr. Woodsmall.
No questions, thank you.
Thank you, Mr. Woodsmall. That takes us to Mr. Mills.
Yes, Judge, just briefly. Mr. Bush, can you turn to page 5 of Ms. Cleathermos's rebuttal testimony?
Page 5 of rebuttal, sir?
Yes.
I am there.
Lines 5 through line 17, Ms. Cleathermas gives 4 reasons why the commission should reject the tariff. Do you agree with all of those reasons?
Starting on line 5, where it says equal to or in excess of a monthly demand of 100 megawatts.
I can help here, Mr. Bush. It's page 5. Start at line 13.
Okay.
He's citing the 4 that Ms. Cleathermes put in her testimony.
I said 3.
That's not it, yeah, that's.
Or I'm sorry, the 4. The next page? No?
He's talking about the previous page, thing,
No, I'm sorry, it is page 4.
yeah.
Oh, yeah, at the top. Page, line 5 through 17 is page 4?
Correct, I'm sorry.
Okay.
Okay. So you said, for the reasons explained in more detail, staff recommends the commission reject the company's application because of.
Yes, my question is whether
outside of the-
all those are reasons.
So these 4, the reasons why we're given,
What was the question? Was there a question other than terms of?
Does he agree with them?
What?
Does Mr. Bush agree with the 4? The question, as I understood it, is, Mr. Bush, do you agree with the 4 reasons presented in the testimony you're adopting, specifically page 4, lines 5 through 17?
That
Question
is
is,
the
do you
question.
agree?
That is the
Okay.
question. Thank you, Judge.
right, I got it. We good? All right. So, at the time that this was filed, yes, I agreed with those. I think subsequently, because of of a recent commission order in the Evergy's electrification case, I think number 1, may not apply anymore. About establishing outside of a rate schedule, outside of a general rate proceeding.
Is that your whole answer?
Yeah, I think the rest of it, I still agree with what you wrote at the time.
Okay, well, let's look at reason number 4. The tariff is not necessary because other tariffs may apply.
Mm-hmm.
Would a customer who qualifies for the SIL tariff also qualify for the large power service rate?
What if a customer can be both the SIL tariff and the LPS tariff rate?
No, my question is, wouldn't any customer that qualifies for SIL also qualify for LP?
I think that's correct.
Okay. So if you were to follow the reasoning given in reason number 4, there would have been no reason to adopt the SIL tariffs, correct?
Could you repeat that, please?
If the commission were to have followed this reason in the case in which they approved the SIL tariff, they would never have done so because there was already a tariff that would have been, that Nucor could have taken service under, correct?
Since I'm not as familiar with the SIL tariff or the Nucor, I don't know that I can answer that question.
Right. Well, let's go about this another way. Aren't there quite a few residential service classifications? Some for all electric some for all electric customers, some for space heating customers, things like that.
There are various classes of customers, yes.
But within classes, aren't there various tariffs that have distinctions?
I think so, yes.
Okay. So if you were to follow the reasoning there, why would the commission have ever approved more than one tariff to serve residential customers, assuming that all residential customers could be served under a single tariff?
I'm sorry, I'm trying to read that number 4 while you were speaking at the same time, Mr. Mills. Could you repeat that?
Yes. If you follow the reasoning that assuming that one tariff will serve any particular customer, why would there ever be more than one schedule to serve residential customers?
I'm not familiar with the reason why some of the customer classes have different characteristics. But generally speaking, you might have a situation where, like on a space heating, the customer may be only using it for space heating, may not be using it for any other activity. So there could be situations where the MKT tariff could have been fit underneath the SIL tariff or the large power tariff. It wasn't necessary to create a new tariff, whereas in those other cases, there was a reasoning why it would be necessary, such that it's only for specific use.
Okay, I think that's somewhat of a circular argument. So let's try to pull that apart. If a space heating customer could be served under a generally applicable residential tariff, why would you ever adopt a specific space heating tariff under this reasoning?
No, I wasn't around when we created a new tariff like that. I wasn't around. I don't remember splitting off something like that into the residential rate, so I don't know. I can't speak to exactly what the reasoning for was at that time, but if there were specific factors that would cause it not to make sense for those type of customers to be included in the general applicable rate, then you would do that.
And isn't that sort of the exact argument that Velvet and Evergy have made here, that there are reasons to have a different tariff than the LP tariff to serve this kind of a load?
I would agree that's the argument that they're making.
Okay. And because of the existence of things like multiple residential tariffs, isn't it clear that the commission has agreed with those arguments in other situations?
I would agree with that.
Okay. That's all I have. Thank you, Judge.
Thank you, Mr. Mills. That takes us to Counselor Bell.
No questions, Your Honor.
Thank you, and that takes us to Evergy.
Thank you, Judge. Mr. Bush, can you hear me okay?
Yes, sir, I can.
Okay. During your cross-examination from public counsel, he was talking to you about the hold harmless provision that was included in the SIL tariff. Do you recall that?
Yes.
Is it correct that in that Nucor case, the company staff and public counsel submitted a stipulation and agreement that recommended the language that's included in that tariff?
I know that the staff was a part of the stipulation. I know that Evergy was as well. I do not know if public counsel was or not.
Yeah, they may have not been they may have taken a non-opposition position, if I recall. But anyway, that was a negotiated compromise that was submitted by company and staff. Is that right? That
is my understanding.
Okay. He asked you a couple questions as a regulator. You've been in the commission a long time. Is it your understanding that the Public Service Commission tries to take into account all relevant factors whenever it looks at adjustments in rate cases or other cases in front of the commission?
Generally speaking, when we talk about rate case, that is the phrase that is used to look at all relevant factors.
Do you understand that to mean that the parties could basically present all sides of the question and the commission will look at the competent and substantial evidence and make a decision based upon that evidence?
I think it means that yes, all any information that needs to be evaluated by the commission can be brought forth by the parties.
And that could happen under the company's proposed, company in Velvet's proposed hold harmless language, where the commission could look at other evidence besides just revenues and costs. They could look at economic benefits or other things, correct?
I think that is a accurate statement, but the rate that that is being contemplated under MKT is slightly different than those other rates that we're looking at in the normal general rate case.
But if all relevant factors were taken into account when deciding whether a deficiency adjustment was appropriate, the commission would look at all the evidence, all the sides of the question, right?
I think they would, you know, at any opportunity for the hold harmless, I think there'd be a lot of factors that would be looked at as well.
Okay, great. I also would like to go to page 4 of your, of Robin Cleathermos's rebuttal testimony and ask you a question about the second reason that staff lists there for opposing the company's proposal in this case. Do you see that?
On line 9?
Yeah, line 9, where it says the requested tariff gives undue authority to EMW to determine appropriate SPP costs without commission approval. You see that?
Correct.
Is it your understanding under both your non-unanimous stipulation with the staff and MECG, as well as the stipulation that's being proposed by Evergy and Velvet, that Evergy would intend to submit its market rate contract for approval by the commission in a future proceeding?
I think it's fair to say that a lot of that concern has been alleviated through the 2 tariffs.
Okay, great. Thank you. Then looking at the third reason that you have listed there for opposing the company's position, you say that the requested tariff is discriminatory in that it is only available to customers who fall under NAICS code 518210 or 541511. Do you see that?
Yes, sir.
Is it your understanding that both of the non-unanimous stipulations that have tariffs attached, the one that staff submitted as well as the one that Evergy and Velvet submitted, no longer have a reference to those codes?
You are correct.
So is that concern also alleviated?
Yes.
I think that's all the questions I have. Thank you, Judge.
Thank you, Mr. Fisher. We'll go now to commissioner questions. Again, we do have the commissioners on WebEx. Are there any commissioner questions for Mr. Bush? All right, hearing none. I do have a couple of bench questions. Would you characterize Evergy as easily complying with or struggling to comply with the renewable energy standard?
Ms. Eubanks may have been a better person to answer that.
Yeah.
But it's my understanding, and I could be corrected, but I think they are meeting their standards. They have more, it's my understanding they have more rights than they need.
I know I've read that in testimony, and I thought it was in Ms. Cleathermos, but I couldn't locate it immediately while I was up here.
That's my understanding.
Mine as well. Is there a threshold level? This is the same line of thought. Is there a threshold level of new load whereby Evergy would have to secure additional RES compliance recs?
Yeah, I don't know how many they have that could utilize, so, sorry.
Nope, you're fine. That's my fault. Let's switch gears, and I'm going to ask you the questions about the Evergy and Velvet Schedule 1 from their stipulation. So the same question as to the other witnesses. Please tell me what staff's issues are and why.
Well, I think that, as Mr. Lutz and Mr. Ives stated yesterday, the concerns they have with ours are basically the same concerns that we have with theirs. Kind of going down, kind of wrote them out too. I think the first one is, they don't include, the language about the economic development rider, the PED tariff. That seems to be an issue where, the customer is getting a very substantial discount in order to take service, and then they're getting another benefit by going it directly after that into the MKT tariff. There's, in my opinion, we use economic development riders in various aspects to attract new load, to attract new customers, to get existing customers to expand in Missouri and the service territories of those entities for obvious reasons. So in my opinion, the reason to do it is because there's benefits, and there's benefits to the company, the utility, there's benefits to the region and to the state, as has been discussed. But if one of those benefits is going to be lower electric rates, that means that the rest of the customer base for a short period of time is going to be paying for those benefits. They're going to get that. And a reason why for an electric company or a utility at any level, in my opinion, to get more load is because then you can take a lot of those massive fixed costs and you can spread them out to a larger customer base. So you give them a break to come into the system to get them on, but at some point in time, they have to then start paying their fair share. Otherwise, they're constantly getting these benefits given to them when there are other customers who are not getting those benefits. So to me, it's when you do an economic development rider, it's to get a customer there and then to get them onto a regular rate with all the other customers. To me, it's not supposed to be transitory to go from, here's a great rate we're going to give you for 2 or 3, 5 years, and oh, by the way, once that's over with, here's a better rate that keeps the rest of the customers from benefiting from getting on the system. So that's why I don't think that, I think we need to put that economic development rider prohibition into the tariff.
So I just want to summarize, make sure that we've hit all of the issues. On my notepad, I have noted that the 393-1640 language, that's been called the PED and the...
Schedule PED?
Yeah. So that language, but we have competing versions. And I'm basing that off of this morning's offering from Evergy, that they had offered, not offered, yes.
Exhibit 7. So I don't know if they have made an offer of this.
I'm not asking you to comment. I'm just pointing out for my understanding and to make it clear for the record, that is a concern. And the two sides have two differing versions of language that would go into a tariff. That's one issue. Two is the substation voltage, which is
I'll get there. Yeah.
just a yes or no, in or out. Evergy wants it in.
We would like it out.
We have the hold harmless language, which we have competing versions of the verbiage. And I understand everyone would have comments on how far language goes. Securitization, we do not have competing versions. It's just an in or out. Mm-hmm. And with the RESRAM paragraph, we have two competing verbiage offerings.
I think those are the major issues. I think there's some language parsing, but generally the rest of it's all pretty much acceptable. Those are the 2, 4, 5 big issues, yes.
Okay. Please go ahead if I interrupted you.
Oh, that's fine. So, just wrapping up my EDR, you know, I think Mr. Ives, you know, this morning and last night, has given an exhibit that, is an attempt to, bridge the differences in the PED, the whole economic development rider issue. I think it's a good start. Appreciate the willingness to talk about it, but, it's not quite, I don't think it gets us quite to where we need to go, but it is a good start, and we appreciate that. The next issue, as you pointed out, Your Honor, is the substation voltage issue, which we, have excluded in our tariff filing. You know, one of the big issues that we've been discussing over these last 2 days is the hold harmless, the incremental cost, make sure that these customers are paying the exact cost that they have incurred. And when you do rate design, when you do class cost of service, the best way to ensure that the appropriate class or the appropriate customer is paying for it is to do a direct assignment. And the best way to direct assignment is that the customer owns that system. So if they own their substation, we don't have to worry about making sure that those costs are assigned. It might be easy to allocate the capital costs, but there are other costs, maintenance and stuff like that, that would be more difficult to parse out to just that customer than to the other classes. So to make it easier, just to make it cleaner, keeping that substation voltage customer out would be better. And in fact, you know, the tariff that Evergy and Velvet have submitted, you know, does have transmission voltage where the customer can own that system, so they are okay with that. So I think, you know, it would just be cleaner going forward as the person who's going to be responsible for the department that has to allocate these costs down into the future. The next one, and I think Mr. Advisor, Mr. Fisher and I all were discussing the hold harmless aspects of it. And, you know, I think the difference, and I understand where Evergy's coming from, but the hold harmless, you know, we want to have economic development, but we want to make sure that the economic development is sustainable and that it doesn't harm the current customers. And so I think it's important to have those type of hold harmless provisions into when you have a special contract, when you are, you know, contemplating a new tariff in a new situation like we are contemplating with the MKT tariff. You know, to start bringing in a lot of those other factors, the benefits, you know, are we going to start bringing in the fact that the reason why the company, Velvet, or any of these large data centers or whatever other companies may be able to take advantage of this MKT tariff, the reason they're coming and getting hooked up to a utility system is because they need to have power all the time. We don't have a situation yet where renewable energy is 100% on 100% of the time, cost effectively. That's a huge benefit that those customers are getting by being hooked up to just by having that access to that. So that's a benefit that they should be paying for, but realistically, through these special contracts, they're not paying for that. They're just paying the incremental cost to be added to the system. So then to come back, looking at the hold harmless, to say, well, look at the economic benefits to the area. Well, what's the benefit to Velvet? Do we get to look at their profitability for simply having access to energy 100% of the time? If we can get access to all that information, then maybe we could have a discussion about that. But I bet we're going to be told we can't look at any of their information because the commission does not have jurisdiction over Velvet or Google or anybody else. So we're not going to be able to get into all the benefits that they're receiving by simply being a part of that system. So the best way to do that is we put a harmless in there so that we can look at the costs as contemplated by our tariff language. I won't talk about all the RESRAM changes. I think Ms. Eubanks has done an excellent job, and I'll just butcher that. So we'll leave that one alone. And then we include the securitization language. you know, that's a relatively new, tool that has been, passed by the legislature, and, you know, I'm not an attorney, but it seems that that is something that I've heard that, all customers should have to pay for it, and considering they are gonna be benefiting from those types of, generating facilities, that if they are retired and securitized, I can't imagine why we shouldn't have to pay their fair share. And I think that hits all the major, differences between the two.
I just want to give you a second. I'm going to ask if there's anything else in the tariffs, either one that you would like to comment on.
No, I think all the parties, have worked extremely hard over a very condensed period of time to come to a situation where we boiled it down to two competing tariffs, that are, you know, some substantial differences, but are substantially the same in a lot of other ways, and I think that is, a testament to all the parties' willingness to sit at the table and talk with each other.
Thank you, Mr. Bush. That will take us to re-cross-examination. Mr. Kleiser.
Part of your discussion regarding the hold harmless agreement, or hold harmless provision, I should say, with the judge, you were talking about, are we going to get a chance to look at some of the economic benefits to Velvet Tech or any other customer who takes under this schedule? Do you recall that?
I do.
Does that include, for example, the economic benefits of being allowed to be on the EDR, or Economic Development Rider, for some period of time before switching over?
I would hope so.
And you would agree with me that one of the principal differences between a customer who takes under this kind of tariff and a customer who takes under a general rate are the general rates are set in general rate cases where the parties aren't negotiating so much as they're presenting evidence as to what the rate should be. And in this circumstance, there's a strict negotiation between the parties.
Right, yeah, the customers within most of the customers, if not all the customers, in the general rate case are paying, which we argue about a lot, their fully distributed costs, the cost of providing service. These types of customers are only paying an incremental cost, so they are not paying necessarily the exact type of cost that other legacy customers would be paying.
No further questions. Thank you.
Thank you. And Mr. Witzmal.
Briefly, Your Honor, you talked a little bit, in questions from the judge about whether Evergy has enough recs. Do you recall that?
I do recall not answering that question, yes.
Well, I think you did say you believe that they did.
I believe they do, yes.
And I'm not going to get far afield on this. But would you agree that those recs, that Evergy possesses are paid for by legacy customers in either paying for a solar farm or a wind PPA or something like that?
That would be my understanding.
Okay. And if there are excessive recs, is it your understanding that those recs can be monetized in a secondary market?
I believe I've had a conversation with Ms. Eubanks about that.
Okay. And so since these can be monetized, they have some value. So to the extent that these are used to serve an MKT customer, that MKT customer should pay in some regard legacy customers for providing those recs. Would you agree?
That sounds like a fair situation.
Okay. Otherwise, are you familiar with the concept of free ridership?
A little bit.
Okay. Otherwise, if they don't pay, they're being a free rider on the assets being provided by the legacy customers. Would you agree?
Yes.
Okay. You talked a little bit with the judge about the EDR concept. Do you recall that?
Yes.
Would you agree that the EDR, would you agree with the characterization that it's a loss leader, that it's designed to attract customers to get them on the system, at which point in the future they'll start paying full tariff rates?
Yeah, I think that's what I was saying.
Okay. And the idea being that at some point in the future, they'll pay full tariff rates, and then the other customers will see the benefit of their existence on the system.
Yes.
Okay. And if an MKT customer is allowed to migrate off of the full tariff rate before paying that, the other customers lose their quid pro quo, if you will.
Yes.
Let's talk about the requirement that the customer, the MKT customer, provide its own substation. Do you recall that question?
Yes.
And is it your understanding that if the substation is provided by Evergy, that substation is dedicated solely to the MKT customer? Is that correct?
I think that is that's the intent.
Okay. And so if an MKT customer left, went bankrupt, what have you, would you agree with the characterization that that substation investment is now stranded?
If there was no other customer to take service off of that substation, then yes.
Okay. And so to the extent that there is a requirement that this customer, the MKT customer, has to provide its own substation, we reduce, in fact, eliminate the risk of a stranded utility asset there. Is that correct?
That's correct.
Okay. Is that one of the benefits of your
Yes.
provision?
Yes.
Okay. Now, very briefly on securitization. Is it your understanding that Evergy intends to initially serve these customers off the LP tariff with a discount?
It's my understanding, yes, using the PED economic development rider in conjunction with the LP tariff, yeah.
So while they're on the LP tariff, they are relying upon Evergy legacy assets, generating plants, what have you. Is that correct?
While on that and while they go to the MKT, yes. So
Okay. And so then, if they have relied on those legacy assets, do you see any reason why they should then subsequently be exempted from the securitization costs for that very legacy asset that they utilize?
I do not.
Okay. I have no further questions. Thank you, sir.
Thank you, Mr. Woodsmall. That takes us to Counselor Mills.
No questions. Thank you.
Mr. Mills, I think you might be muted.
Oh, can you hear me now?
I can hear you. I can
Okay.
hear you, Louis.
I have no questions. Thank you.
Mr. Mills, we're not hearing you, but I am seeing on my WebEx that you appear to be speaking.
Judge?
Star 6.
Questions.
Judge, this is Jim Fisher. I can hear Louis Mills.
So Jim, will you let them know that I have no questions?
I'm trying to tell. They're not hearing me either, I don't think. Judge, are you hearing Jim Fisher?
And we will move to Ms. Bell. I'm sure Mr. Mills will contact me in some way if I am mistaken. Ms. Bell, your witness.
Can you hear me, Judge?
Yes, ma'am.
Okay, great. Mr. Bush, good afternoon.
Good afternoon.
When did you identify or become aware of this PED issue?
Objection. I don't believe that's in response to anything from the bench.
Ms. Bell, do you have a response to Mr. Keeble?
He was describing the EDR issue in response to your question.
Yeah, I'm going to allow it.
I do not remember exactly when it first dawned on me that it was an issue.
Was it before rebuttal testimony was due in this case? Did you respond, Mr. Bush? I'm sorry. Judge, we aren't getting any sound from Mr. Bush.
Judge, can you hear me, Jim Fisher?
I think they've
Stephanie, I
tuned
don't
some
think
of us
they're
out.
hearing us.
Yeah. I wonder how they chose who to tune out.
The hearing room is muted. I'm gonna try to put that in the chat. Mr. Bush, can you hear me? Okay, I'm gonna start my video. We can't hear you.
Sign language.
Hold on. Oh, timeout, yeah. Hold.
Jim Bush, can you hear me? We can't read that.
I think that says you too. They can't hear us and we can't hear them right now, I think is what that said.
Roger Steiner, can you hear me?
Jim, I can hear you, but I can't hear the PSC.
Okay, that's our problem, I think. They're muted.
I think this is what happened yesterday during my opening, where we couldn't hear the judge.
You think we should reboot our system or?
Hey, Jim, this is Sherilyn. I'm online at the commission in my office and I can hear you guys, but not the hearing room too. So
Is there a way you can let them know what our problem is? I don't
I
know how to.
emailed the judge because initially I could hear him and I could hear you, but you guys couldn't hear each other. Now I can't hear him either. So I don't know what's going on.
Okay, thanks for your help.
Mr.
I don't know if
Fisher,
I'm
this is Lloyd
helpful.
Wilson.
Just
I believe the judge is aware and is trying to address the problem.
Oh, okay, thank you. Is this
you.
Lloyd Wilson?
Yes, it is.
Oh, thank you.
I do have to say it's pretty impressive the way people are thinking outside the box with sign language and notes to try to overcome technical difficulties.
Yeah,
We've
It's a
learned
new
a lot
world.
in the last 2 years.
yeah, that's for sure.
The last couple months, I mean, when hearings have started.
If you can hear me in the hearing room, will you give me a thumbs up?
Jackie, we can hear you,
Okay.
but I don't know what the hearing room does.
Okay. Jim Bush. Jim. No, he's not responding. Oh,
Hello, can you hear me on the WebEx?
yes.
Excellent. We have discovered the problem. If everyone can now hear me on the WebEx, the hearing room phone was disconnected. We have reconnected now. Let's go back on the record. We have reconnected our phone system and WebEx. We are in the middle of the testimony of Jim Bush, and just for giggles, I would like to go back to Mr. Mills. That was the beginning of our technical problems, I believe.
We heard,
I saw him shake his head, and I'd just like to confirm if he has any questions. Mr. Mills, did you have any questions for Mr. Bush?
I do not. Thank you, Your Honor.
Thank you, sir. Ms. Bell, you are up next, your witness.
Yes, Your Honor. Mr. Bush, did you talk with anyone over the brief break that we had?
I did not.
Okay, so when did you first identify or become aware of the PED issue?
I don't know. I don't remember.
Was it before Sir rebuttal testimony was due in this case?
I do not remember.
No further question.
Thank you. And that takes us to Evergy.
Thank you, Judge. Just briefly, Mr. Bush, is it correct that staff did not address what's called the PED issue or the Economic Development Rider issue in its rebuttal testimony or Sir rebuttal testimony?
That is correct.
Is it also correct that you didn't mention that in your position statement?
That specifically, I don't believe that was mentioned in the position statement.
Okay. As I understand it, or is it your understanding that the General Assembly passed a statute 393-1640 that gives the authority to authorize economic development riders?
Well, it's a statute, so I'm positive the General Assembly had to have approved it and passed it.
To your knowledge, does that statute say anything about a lost leader?
I think it's silent on all this stuff.
Is it your understanding that the General Assembly establishes the public policy and authority for economic development riders?
I don't know. I don't know that every economic development rider is based on some general authority from the General Assembly, maybe in the whole broad context that the PSC is a creature of the legislature, but I don't know if it has to have specific statutory language or not.
Okay. Do you know whether there's any restriction from going from the PED to the SIL tariff?
I don't know about any restrictions or any express written or something expressly that says that they can do that. I think it's silent on it.
So there's no restriction that you know of in the SIL tariff that would say if you've been on a PED, you can't come to the SIL, correct?
I'm not aware of any of that, no.
On the substation voltage issue, is it your understanding that the company is trying to establish a tariff that would apply to other customers besides Velvet?
I mean, the MKT is a tariff that will apply to any customer who meets the availability requirements.
So it could be that other customers that are not necessarily wanting to take at the transmission level might want to use the tariff language to establish service?
Well, they could, but it's kind of, similar to the OPPD tariff that this MKT was based upon, and that was, a requirement there. So if that's the part of the availability, I think that's a part of the tariff.
I'm not sure you answered my question. Is it true that some customer that might like to take the service under the MKT tariff might not want to be a transmission customer, but might need a substation?
It is true that a customer may want to be on a tariff and they may not qualify. That is correct.
And is it possible that in the contract, the market rate contract, you could recover the cost of that substation?
I'm sorry, Mr. Fisher, what do you mean? Could you just rephrase that a little bit, please?
Would it be possible to use the market rate contract to cover the cost of a substation if that was needed by the customer?
Are you referring to the contract, the tariff that Evergy has proposed?
Yeah, I'm suggesting that under the concept the company is proposing, that if you did have to build a substation for a customer, you could recover that through some other contractual means rather than just rolling it into other folks' rates, couldn't you?
Theoretically, yes.
And I believe you said that the securitization concept was a relatively new tool. Is that right?
I believe it was just passed this last legislative session.
Has the commission approved any securitization program yet in this state?
We only have one currently pending securitization case.
Would you expect that do you expect that there'll be probably several issues that'll have to be decided in that case?
I'm looking forward to a very complex case that we're going to have to deal with over these next few months, yes.
And one of the issues could be, how do we pay for it?
Objection. Now he's starting to ask for legal opinions and everything. The statute that they're talking about speaks for itself. If Mr. Fisher wants to cite the statute, he's brief, he's certainly free to do so.
I'll withdraw the question, Judge. Mr. Bush, you would expect many issues to have to be decided though, correct? In the future?
Yes, I would agree with that, sir.
I think that's all the questions I have, Judge. Thank you for your cooperation and getting over these technical issues.
Thank you, Mr. Fisher. That leads us back to redirect. Mr. Keeble.
Very briefly, Judge, Mr. Bush, a lot of talk about the inclusion or exclusion of substation voltage customers from the MKT tariff. And I think you touched on this with Mr. Fisher, but I just want to make it clear. So your understanding that the MKT tariff was originally, supposedly at least, patterned after the OPPD tariff?
That is correct.
And does the OPPD tariff, what provision does the OPPD tariff make regarding ownership of facilities?
It's my understanding that tariff requires the customer to own the facilities.
I apologize for interrupting. What is the OPPD tariff?
It's
Omaha Public Power District.
Yeah, thank you. I apologize for interrupting again.
Okay, now that we've done that, let's think where we were. With Mr. Bush, when we're talking about facilities, we're talking about owning the substation and related facilities. Is that correct?
Yes.
Okay. There's also been discussion regarding, from Mr. Fisher, in regard to the quote-unquote hold harmless provision, discussion concerning all relevant factors. What's your understanding of the all relevant factors generally?
Whenever I always heard that term in my years of involved with rate cases and cost of service, class cost of service studies, rate design. I always looked at it as we would look at the overall costs, that a company, that was a part of the company's cost of service. The whole idea is to determine what the revenue requirement is, and you have to look at the cost, which is the plant minus any accumulated depreciation, the return on that. You want to look at the factors that would allow, an appropriate return on equity to be built in conjunction then with, cost of debt for the rate of return, the overall net plant, when everything was built, put into service. And then you look at, you normalize costs through a test year process. Maybe it's updated through, known and measurable through a true up. So that gives you an idea of what the actual, operating maintenance expenses, depreciation expense. So you look at all those factors to determine the overall revenue requirement. And those are the factors that are really looked at. And then you get into, dividing up those costs to the various classes. And, that's where a little bit more of the sausage making comes in, because as various parties here have different opinions upon what the appropriate way to allocate costs and determining how those, which class should pay what, if there is a quote unquote subsidy maybe out there, what the appropriate customer charge should be. That's when you might start looking at maybe some other impacts. But I've been involved in a lot of cases, especially in my time, last 13 years in the small water and sewer world, where we as the staff and have gone up to the commission has approved some pretty substantial rates. And there are other factors that are out there, but the bottom line is whatever the cost of service is, that's what the cost should be passed along to the customers. And that's what we're talking. So when we look at all relevant factors, we're looking at the relevant factors of providing, utility service to the customers.
And when you say cost of service, you're referring to fully distributed cost or incremental cost?
The fully distributed costs.
Yeah, all right, which is not what this tariff is based upon, is that correct?
Yeah, this tariff is based on more on the incremental cost of providing service to any customer that might be able to take service off of this.
Thank you. I think that's all the questions I have, Judge.
Thank you, Mr. Keevil. Mr. Bush, you are excused. Let's move on to Dr. Mark. Thank you for making your way up.
Just while he's doing that, I've got exhibits number 100 through 104 were all received. Is that comport with your?
Yes.
Thank you.
Dr. Mark, do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
Yes.
Thank you. Please have a seat. Mr. Kleiser, your witness.
Good afternoon, Dr. Mark.
Good afternoon.
For the record, can you please state by whom you are employed and what capacity?
I'm the Chief Economist with the Missouri Office of Public Counsel.
And have you prepared or caused to be prepared rebuttal testimony that has been pre-filed in this case and marked as Exhibit 200?
Yes.
And the answers contained in that rebuttal testimony true and correct to the best of your knowledge and belief?
They are.
If I asked you the same questions today that are posed to you in that rebuttal testimony, would your answers be the same or substantially similar?
Yes.
I would move to introduce OPC Exhibit 200, the rebuttal testimony of Dr. Jeff Mark, public and confidential.
You have heard the motion by Councilor Kleiser. Are there any objections to the admission of the public and confidential versions of Exhibit 200? Hearing none, so admitted.
It occurs to me, I didn't ask. Do you have any changes?
I do not.
Okay. Okay, that was on the record. I tender the witness for cross.
Thank you, Mr. Kleiser. According to my sheet, cross-exam goes to Mr. Keevil.
Thank you, Judge. Just very quickly, Dr. Mark, I'd like to have you turn to page 3 of your rebuttal testimony. You begin talking about the transparency and uncertainty regarding Velvet Tech. Is that correct?
That's correct.
I know in your testimony you go into this in more detail, but summarize why it's important, to know something about Velvet Tech?
Sure. This is a departure from how we typically set rates. I mean, quite frankly, the market tariff that we're putting up is a big departure. It's a very generous departure if you combine that with the EDR. As a sanity check for myself, what I like to do is to see where are applicable rates like this being held. So what other states, what other data centers, as a sanity check, just as a course of business action, the DRs that I send try to inform that knowledge. So at a base level, it was, who is Velvet Tech? Where have you operated before? A lot of affirmations were put in testimony about their economic development, their success. Based off of my cursory, research, I couldn't find anything to substantiate that. The DRs and the discovery, provided, additional hurdles over that. All of that, again, is important because on one level, when we give out a discount, when we give out an economic development rider, we want to minimize free riders. We don't want just somebody that was going to operate here regardless. If they had made an announcement, for example, that they were going to build a data center there, and then came back, a month later and said, now we want to take advantage of this. They might not be eligible for one. The other one is to determine whether or not it's a viable option. Will they be able to operate? Have they done this in other places? Again, are they a free rider or not? So at the end of the day, this was a frustration on my end that the discovery responses I got back from the company didn't really shed any additional light on this, or whether that was a competitive rate or compared to what. Are you operating compared to what others say?
Would you also, or would you agree that it would be helpful to know more about Velvet Tech in order to know whether the long-term feasibility of this, or if this project is actually going to be feasible long-term?
We're representing the public here, as OPC, and I think one of the things that I try to do is feel like in a way I'm getting paid to be, reasonably skeptical, and this is a huge, huge endeavor that's being put forward. A huge endeavor that's being put forward. So to the extent that we don't know anything about them, that raises concerns.
I'm not saying this is going to happen, but could it happen that after Velvet Tech begins operations, for whatever reason, they, let's say they just go bankrupt, and then what would that do to the other customers if that were to happen?
But it would be critical that the tariff was, and this is why we put forward the tariff that we did, was to hold the customers harmless. Absent that, customers could be exposed to an enormous amount of risk. And at the end of the day, really what we're talking about is a risk-reward option here. There's all reward, it seems, from my angle, from the utility perspective, and very little risk.
In the event of my hypothetical there where Velvet went bankrupt, would there be, or could there be stranded costs of Evergy's that would then need to be either absorbed by Evergy or passed on to other customers?
That's exactly what the situation would align. It would be a huge stranded asset issue as to who would be paying this that outstanding balance.
And if you knew more about Velvet, would you be more comfortable, not saying totally comfortable, but more comfortable agreeing to the proposal?
Anything would help.
Okay, but nothing further.
Thank you, Mr. Keeler. That takes us to Mr. Woodsmall.
Thank you, Your Honor. Just so my questioning is clear with the record, did we mark the, how should I call it, the EDR issue that the document that they initially
Yeah.
brought up, what was it, Mark?
Exhibit 7.
Exhibit 7, okay.
I think it's been admitted, too.
Okay, then that'll inform my questioning, make it more clear. Good evening, sir.
Good evening.
Have you been here throughout this hearing?
In and out, yes.
Okay, and do you recall late yesterday evening, the company saying that they had attempted to, quote, meet in the middle on the EDR issue?
Yes, I do.
And towards that end, do you recall and did you receive a copy of what has now been marked Exhibit 7?
Yes, I did.
Okay, earlier, Mr. Bush said while he appreciated the company doing that, he didn't think it bridged the gap and fell short. Would you agree with that characterization?
I would.
Okay. Let me mark an exhibit, Your Honor. Am I up to? 904.
904.
Okay. Mark what, exhibit 904. And this has been distributed to the parties that aren't in the hearing room, Your Honor.
Thank you.
Sir, do you have what has been marked as exhibit 904?
I do.
And were you involved in the preparation of this document?
I was.
And is this document prepared in response to Exhibit 7 that was discussed earlier and designed to bridge the gap on the EDR issue?
It is.
Okay. Tell me which works better for you. Do you want to talk about the changes? Well, first off, is this a red line of the Exhibit 7?
Yes, it is.
Okay. And those red lines are shown there in underline and scratch out. Is that true?
That's correct.
Let's just walk through them, change by change. First line, it scratches out economic development rider and in several other places and replaces it with Schedule PED. Can you tell me what the rationale is for that?
For clarity,
Okay, and by clarity,
that we're specifically talking about the Schedule PED, the economic development, offering, tariff offering.
okay. Then it scratches out the word make such requests and replaces it to migrate to Schedule MKT. Can you tell me what the reasoning is for that? And I believe it probably has something to do with the 2 years, but go ahead.
Sure. So, as it was drafted yesterday, they could make such a request, within 2 years. The request can take, considerably long time, whether or not you file something with the commission, it could, be dormant for quite a while. This provides some real, clarity in terms of, as soon as certain thresholds are met, they mitigate into that MKT, schedule.
Okay, so let me just run a hypothetical and see if I'm tracking the language right. You have ABC company come in that wants to be served eventually off of MKT. And for a period of time, they start taking service off of the large power tariff with the PED discount. Is that correct?
That's correct.
And what this says is that within 2 years, they must be migrated to Schedule MKT.
Yes, it does.
Okay. And 2 years is the maximum. It could be earlier depending on whether they meet this 50 megawatt average monthly peak load threshold as well.
That's correct.
It's the lesser of the two.
That's correct.
And that is consistent with the company's Exhibit 7.
Yes, it is.
Okay. Then we get down to line 6. Yeah, line 6. It replaces allowed to request service under and changes it to migrated to. Is that consistent with your previous change to the word migrate?
Yes, it is.
Okay. I believe that takes us out of that first paragraph. Did you have anything else on that you wish to note?
No.
Okay, otherwise, the 50 megawatt threshold is the same as the company offered, is that correct?
That's correct.
The 2 years is the same as the company offered, except for it's made more definitive by they must be migrated in 2 years.
That is correct.
Okay, then we have a second I'll call it a paragraph. It's a paragraph, it's one sentence. Do you see that?
I do.
Can you tell me what the reason is for that? And first tell me, what does it do?
Right, so I'll just read it here. For a period of 5 years from the effective date of the first special high load factor market rate contract. I'll just take that line for 5 years there. Not an indefinite amount of time. We're putting it out there, enough of an opportunity to go ahead and get some legitimate data back. All right, next line, schedule MKT shall be limited to the lesser of 3 customers or 500 megawatts, at which point the impact of the schedule MKT or non-MKT customers, including the scheduled PED discounts, shall be analyzed before any additional customers can be included. So the sentence there is describing some parameters. It's putting some parameters around this tariff so they don't get out of hand. To piggyback off of Mr. Keeble's earlier, questions to me, I don't know who I'm dealing with. There's a lot of uncertainty surrounding this departure from how we typically set rates. What this allows is some confidence that what we're being asked and tasked to do here on a fairly expedited schedule. I mean, keep in mind, the number of the large rate case that we've got going on, but also the Christmas holidays and the COVID flu that's taking place has really stressed resources in trying to come up with a path forward. This allows a sanity check. Over the next 5 years, we can sit back and say whether or not, non-participants have been harmed, whether or not the company's been harmed, whether or not the rate itself has been designed in a way that we expected. Has it produced what we expected? 3 customers or 500 megawatts. And I can't stress this enough that this isn't just a typical economic development rate for, like a mom and pop store. These are huge, huge customers. So, I think Mr. Witzman, you gave the example of a Walmart effectively as a 1 megawatt. Having 500 Walmarts go up in northern Kansas City over the course of a limited amount of time is going to place an enormous strain and will require lots and lots of investment. So this is, right now we're dealing with Velvet Tech. What customer in the future could be, be included on this, I don't know. So again, the parameters provide some assurance that we can revisit it in the future.
Okay, you mentioned one reason is that there's uncertainty with who you're dealing with, and you talked about that. Would you also agree and explain why there's uncertainty as to how this will affect non-MKT customers?
There is absolutely a lot of uncertainty. I mean, there's a lot of uncertainty right now taking place in the case. Right now, I don't know whether or not, there's a potential legality issue over the RES statute and how that works with the mechanisms, the RES-RAM mechanism, how that's going to work with future surcharges that might appear. We've alluded to or talked explicitly about securitization, but the idea that there could be a future surcharge coming down the pipeline seems more than reasonable to me given recent events. So all of those things expose non-participants to risk and a fair amount of risk. So this is trying to keep it reasonable, and if it works, great. Let's move from there.
You said we reviewed this. Would you agree that Missouri has never seen anything like the MKT? Cameron doesn't have it. Evergy Metro doesn't have it. Empire doesn't have it. This is a new beast to Missouri.
Very much so. And, again, this goes back to what I was saying earlier. When I was asking Velvet Tech for examples of where has this been done before, I couldn't find any examples. The Omaha Power District's been, alluded to a lot. It's a municipal utility. It's different conditions. It's not a for-profit investor-owned utility. It's a city. And economic development that is beneficial to a city and how they're tied to their local utility is very different than talking about an investor-owned utility spanned over, in this case, hundreds of thousands of customers.
And let's delve into that a little bit. Would you agree with the notion that generally cities are nonprofit? So Omaha has no incentive to try to take steps to harm its customers to benefit its bottom line.
Yeah, absolutely.
And is Evergy nonprofit?
They are not.
So they have an inherent incentive. They have an inherent duty to their shareholders, even over any duty they may have to their ratepayers.
That is correct.
Okay. You tried to talk about the magnitude, the size of these type of customers. Would you agree with Mr. Brubaker's statement earlier that as the size of these customers increases, as they use more electricity, the PED discounts in nominal dollars increases as well?
Absolutely. I'll just real quick, I'd like to pause here and say there's one electric utility in the state of Missouri that's not at full capacity to meet its load. That's Evergy West. That's where this is going. All right. We've thrown out Noranda a lot. Ameren was very long on capacity. Then Noranda was able to meet that load, because they had so much capacity. Evergy West cannot say that. So that is a big concern.
So following up on that, the concern being that there may be some obligation to serve this MKT customer, and Evergy may be on the hook to build generating facilities because they don't have enough generation, may be on the hook to build generating facilities to meet that capacity requirement?
My concern is compounded by the fact that in today's operating environment, it's increasingly more difficult to meet that capacity through traditional resources. And as we venture more into, a more fossil fuel, world, by necessity, as it stands right now, that's meaning more money and a lot more uncertainty in terms of reliability.
So the risk to non-MKT customers would be lessened if this was Evergy Metro or Ameren itself?
It would be, yes.
Because they are so long in capacity?
They're longer, yes.
Okay. Did you get an opportunity to explain this, or did I cut you off at any point?
I think I'm good.
Okay.
Thank you.
I have no further questions, Your Honor. Move for the admission of Exhibit 904.
You've heard the motion on Exhibit 904. Are there any objections to the admission onto the record of Exhibit 904?
Judge, this is Lewis Mills on behalf of Google. I object to the admission of this exhibit. I'm not sure exactly what this is, who's proposing it, what issue it's designed to solve, but it's a whole brand new proposal coming in in the last hour of the hearing on the last witness. We have no meaningful opportunity to explore this whole concept. Nobody until this very moment has raised the idea of limiting the number of participants allowed under this tariff. It wasn't raised in testimony. It wasn't raised in the list of issues. I'm not going to talk about whether it might have been raised in some other context, but it certainly has never come up to me. And as I said, I have no meaningful opportunity to present evidence or even make an argument about this. So I object to its admission.
Your Honor, these are the exact arguments that I made last night in response to Exhibit 7.
Your Honor.
And those arguments fell on deaf ears. In fact, I believe the comment was, I have a duty to inform the commission. And so that exhibit was allowed in with the opportunity for cross-examination. Now, we at the top it says OPC, MECG staff, have tried to be more forward by doing it before the other parties have done cross-examination. We didn't attempt to do it in redirect. So we put it out there in response to the document that Velvet and Evergy put out and would welcome cross-examination on it.
Your Honor, I would register.
This document was sent to the other parties before now.
And go ahead, Ms. Bell.
Your Honor, Velvet would also register an objection to this language. While Mr. Woodsmall is correct that the language was issued yesterday, for the other proposal, where he is incorrect is it was put in at a time where everyone's witnesses were allowed to discuss the language. At this point, all of our witnesses have already presented testimony. And I believe, and I would join and reiterate what Mr. Mills said, is we are not in a position at this time to make a comment on language that was received in the last hour of the hearing.
Your Honor, that's the nature of burden of proof. You know, the witnesses are simply scheduled in this case to recognize the statutory burden of proof. It is not any way a contrived procedure on our part to take advantage of anything. You know, our witnesses who explain this in response to their Exhibit 7 just simply were scheduled pursuant to the burden of proof.
I was gonna say, Judge, what Ms. Bell said would apply to any exhibit which was attempted to be offered by any party after the first part. And I can't believe that's grounds for excluding an exhibit.
The objections are noted and overruled. Submitted onto the record.
I have no further questions, Your Honor.
Thank you, sir. That moves to Mr. Mills.
Dr. Mark, is there anything in a, Judge, was this exhibit marked as Exhibit 7, is that correct?
I thought it was 904.
Correct.
Exhibit 7 was the competing language that was introduced last night.
Okay, and excuse me, yeah, and part of my questioning, I think, is going to go to the notion of whether or not this is competing or not. Is there anything in the first paragraph that of Exhibit 904 that attempts to limit the number of customers under Schedule MKT?
No.
Is there anything in any of the testimony in this case that talks about limiting the number of customers under MKT?
Not that I'm aware of.
Is there anything in the position statements of any of the parties that talk about limiting the number of customers under Schedule MKT?
Not that I'm aware of.
Judge, that's all I've got. No further questions.
Thank you, Mr. Mills. And Ms. Bell, any questions?
Yes, Your Honor. We'll start with Exhibit 7. Just for clarity's sake, Mr. Mark, what is meant by the effective date in the first sentence of your language?
You mean Exhibit 904?
Correct.
Okay. And you're talking about the second paragraph, which is all new language, beginning for a period of 5 years from the effective date. Is that your question?
Yes.
Okay.
When the tariffs are approved and go into effect, the contract is approved, sorry, by the commission. There'll be a separate proceeding for the contract.
So
my
for a
understanding.
period, so your language means for a period of 5 years from the effective date of service
That's correct,
or the effective date of the contract?
of the service.
And is that the service under MKT?
Yes.
And how would your language affect potential, as the tariff's written, you would agree that there's an opportunity for renewals?
As the Evergy tariff is written,
As Schedule MKT is written, there is an opportunity for MKT customers to renew contracts beyond the 5 years, correct?
that sounds right. If you could point me to that, I could verify. maybe a word search.
I am looking on page 4 of 7 of the Evergy Velvet Schedule 1 under term.
Return, okay.
And the second sentence, customers may receive service for additional 5-year terms subject to updated pricing.
Yes, I see it now.
Ms. Bell, is that the phrase you were wanting,
Yes, thank
Dr.
you.
Mark? Okay.
Thank you, Your Honor. So Mr. Mark, you would agree that there is the potential for renewals for this contract service?
As this tariff is drafted, that's the way I would read it. So we would need to make an addition to that.
So.
We would need to update the term.
So, Mr. Mark, can you explain to me how your drafted language affects contract renewals?
The contract would be for 5 years.
Then does your proposal mean that customers who had an existing contract would not be able to renew as a result of this limitation?
I don't believe so. And what this is saying is that no new customers.
Now, you've heard I think you mentioned the expedited nature of this review.
I did.
Would this language incentivize a race by customers to come in and have contracts approved?
I don't know. Maybe. I haven't dealt with a contract or an economic development tariff that's large like this under these conditions.
But you would agree that the language as written is a first come, first serve tariff?
I would agree that it limits it to a certain threshold, yes, for 5 years until we can examine it.
Would you agree your language is ambiguous about renewal of a contract?
I'm going to object that it calls for a legal conclusion regarding MPE2.
Objection is overruled. We've been allowing those. Go ahead, Dr. Mark.
As I read the inclusion of our language, it is silent on renewal.
So it is ambiguous, correct?
I don't believe so. I mean, the provision applies to future customers, not current customers.
Can you point to the word future in the language?
Additional customers, that's the operative language that we've used, shall be analyzed before any additional customers may be included.
So if there was language in this paragraph that expressly said customers served, expressly said that customers with approved contracts would continue to be allowed to be served under the MKT on renewal, you would have no objection to that?
I wouldn't. That's presupposing that they're meeting all the other thresholds that would otherwise qualify them for that tariff.
Okay. You had indicated that you were dissatisfied with Velvet and with Evergy's data request responses. Is that
Yes.
correct?
That's correct.
Do you know if your counsel sought to confer with the judge over your dissatisfaction with the responses?
I don't know. I honestly don't know. We've been very busy, Ms. Bell.
Did OPC file a motion to compel regarding the DR responses it was dissatisfied with?
I don't believe so.
Okay, were you in the room when your counsel said in openings that the two schedules proposed, the two competing schedules were very close?
I was.
These Schedule 1 attached to the OPC stipulation, it does not have a requirement for any disclosures about Velvet for the commission to approve it, correct?
Correct.
In this case, you would agree that Velvet will only be served if two steps happen. First, that the tariff is approved, and second, that the market rate contract is approved as well. Correct?
Correct.
Is it your understanding from the testimony that at the time the market rate contract is approved, the customer will be, that the identity of Velvet will be made known?
I don't know. I think you're probably in a better position to opine on that.
At the time that the market rate contract is filed, will OPC have the opportunity to submit data requests about any particular customer?
Sure.
And are you aware of any customers other than Velvet that are interested in Schedule MKT?
The presence of Google implies that they might be of interest.
And Google is an intervener in this case, correct?
That's correct.
And did OPC issue any DRs to Google regarding the concerns you had about future customers?
I'm sorry, did I issue DRs to Google as to Velvet Tech's identity? Did I,
You testified that the identity of the customer is important, correct?
I did.
And you know the identity of Google, correct?
I do.
Is there anything prohibiting, if the MKT contract is approved, is there anything prohibiting Google from being the first customer served under MKT?
No. Yep.
Okay.
If Google's contract gets approved first, then they would be the first. I'll ask the same questions of Google that I'll ask of Velvet Tech, what other market rates have they entered into? What other data centers have they operated in other states? What's the economic development, if any, that they're receiving, to ascertain the reasonableness of what we're giving here in Missouri?
So if the parties in this case came together on a unanimous stipulation.
Ms. Bell,
Yes,
I'm going to interrupt here.
okay.
We've been talking a lot about what I see as proposed conditions, suggested language. I am very uncomfortable talking about settlement, offer. The Public Service Commission has a rule that says that those discussions are confidential from the commissioners.
Actually, it says privileged.
I'm sorry, privileged from the commissioners themselves. So that's where my concern is coming about. Maybe this is a good time for me to also make just a slight observation that this case would remain open until the filing of briefs, which is, again, by PSC rule, which would allow the parties away from the courtroom to discuss any further conclusions that they might have, and would be able to then make filings and follow that path if they wanted to. But please, let's be careful with our next question in that regard.
Yes, Your Honor.
Judge, this is Lewis Mills. I would also note that this sort of process essentially where there are what I would consider to be settlement proposals being made by various parties in the case essentially freezes out those parties that don't have witnesses. If the witnesses are advancing proposals to settle and I don't have any witnesses, it makes it very difficult for me to participate in this sort of settlement discussion that's ongoing at the very end of the hearing. So
Mr. Mills?
Yes, sir.
I think you might have misunderstood. I stated very plainly, there are not any settlement discussions going on in this courtroom at all, today or yesterday. There has been some language that the commission may or may not be persuaded by, but I am interpreting that language to be suggested conditions. I don't think that your having a witness or not having a witness is going to preclude you from participating in actual settlement discussions that, again, will not occur in the courtroom, and they are not occurring now. And I would also mention that if there would be some type of settlement, Google is a party, and they would be able to sign off or file objections or simply make no statement at all.
Yes, Your Honor, I understand. My point was that I am limited in my ability to put forward these kinds of proposals by not having a witness on the stand. But I understand.
I apologize for that.
Thank you.
Please go ahead with your questions.
Yes, so Mr. Mark, my question is not about any past settlement agreements, but if the parties agreed to Schedule 1, all parties agreed to the Schedule 1 OPC proposed, would you then reject the agreement because you did not know who Velvet was?
No. I mean, Ms. Bell is operating under the premise that our hold harmless language is there as well. And I'll expound on that, later with commission questions. But there's a reason why we want that there.
No further questions.
Thank you, Ms. Bell. That takes us to Evergy.
No questions, Your Honor.
Thank you, Mr. Fisher. That takes us back to redirect. I'm sorry, hold on just a minute. Let's go to commissioner questions first. We do have the commissioners on the WebEx. It is *6 to unmute. Are there any commissioner questions for Dr. Mark? All right, hearing none. We do have a couple of bench questions. Dr. Mark, are you the witness to talk about ResRam, or is that Ms. Mantle?
It's Ms. Mantle.
Okay, that's fine.
I'll say that, yeah.
I do recall in your testimony you had discussed this a little bit. Would you please, I don't want to recite your testimony, but I do want you to discuss the differences between the Omaha Public Power District rate and the one that's being proposed.
Yeah, the big thing being the no ramp-up period for Omaha. And again, this is where the EDR becomes a critical issue for us and why the hold harmless language is important for our office. Again, it's risk-reward, and we've been throwing the term hold harmless out a lot. I would make the observation that non-participants would already be on the hook for 40% of that discount, whether that's the 5 years or the 2 years that's been offered up. I mean, there's going to be some dollar amount that non-participants are going to be asked to bear, period. So right off the bat, non-participants are paying a cost. If they switch over at that point, if we accept what the company's putting forward, then customers are then exposed to the risk of that company going under or any number of other factors that they're not meeting that revenue. So the hold harmless is really designed as a risk reward. Now, the company's being rewarded, the risk should be minimal. Every reason to believe it should be, but you know, given the order of magnitude that we're talking about here, I would be negligent not to go ahead and advocate for customers to have some sort of protection.
Okay, let's turn to our two competing tariffs, the two Schedule 1s from the non-unanimous stipulations. This is the same question I've been asking all the witnesses. So we're going to start with the Evergy Velvet tariff. And please tell me your concerns and why.
So I'm going to echo a lot of the same sentiments that you heard from Mr. Bush. He identified, I believe, 5 issues. The voltage is definitely more, I understand his rationale. We didn't opine on that, but I understand the rationale behind that. Would say it's really the same concern. As far as I read the language in terms of securitization and future surcharges, that's at the.
Haley, go throw the Frisbee to him, please.
What?
If we could make sure and have everyone on WebEx please mute their phones. Thank you.
Okay. I'll get from the first page. I got additional provisions. Our language that we, included here, and Judge, I'm operating from the document that Mr. Kleiser made that tried to merge both documents. So under additional provisions in number 3, and what I'm going to try to do here is knock out both the company and the OPC one simultaneously.
I appreciate the efficiency.
All right. So under number 3, it says the special high load market factor. We've included language in there. This is the hold harmless language. The words non-market customers should be held harmless from any deficiency in revenues provided by any customer served under this tariff. Language adopted from the SIL tariff. The additional language that says or from any stranded investment or cost associated with serving customers under this rate schedule covers capacity cost concerns. On the 4th number under additional provisions, there's largely, we've got any rate proceeding at the time of, this is the 3rd line. Says at the time, before it said of any general rate proceeding, we've got any rate proceeding, so this would include FAC, RESRAM, possibly securitization, another future surcharge. The language that is included thereafter in section 4 is language again taken from that SIL tariff. The next paragraph in section 4, we omitted the non-participating customer shall be harmless from any deficiency in revenues and cost of service. We've added, we've effectively written double down language on the hold harmless. Okay. Moving on to rates and conditions. This is just clarifying language that's in here.
Tell me what page rates and conditions are. I seem to have gotten lost. We were on page 5 of 7, right? I'm sorry, 6 of 7 with paragraph.
It's kind of cut off on that page.
Okay.
I believe he's at 3 of 7.
3 of 7.
Oh, I see.
Okay. So the key thing there is that we effectively changed 90 days. It was 60, we put in 90, we spelled that out. You'll notice under terms, we added 60. So it's effectively the same amount of days, We've just added more on the front end as opposed on the back end. Moving on to the next page. After that, under availability, we added the phrase availability is subject to commission review. And again, this is just to make sure that a customer wouldn't arbitrarily be kicked off by the company if they didn't like them. So under availability, I guess this would be page 1. I'm sorry, when this was handed to me, I was obviously out of numerical order. The language that was added there was just to make sure customers are big enough. Under this is number 5 on, this is page 507. It says customers at the end of numerical 5, the last sentence has been added. Customers will be subject to any other charge or surcharge, including without limitation, any charge related to securitization of company assets. Again, that's just covering what could happen in the future and making sure that the tariff is legal. Under additional provisions, this is the RESRAM section. Effectively, our language has been added there to make sure that the company is in compliance with the law. And again, you know, Ms. Mantle is going to expound on, you know, I definitely encourage you to ask her questions on this because this can, given the size of the customer, this is not necessarily a trivial amount of money that could be at stake here. The other thing, you know, that I would add as to the importance of this is just the precedential value. We know that there's a customer interested that's interested in moving forward with a data center. We don't know anything about that customer or that they've operated anywhere else in the United States at this point, but there's a customer interested in opening up a data center in the greater Kansas City area. But as this is defined, I mean, this can include any number of different types of customers. We'll just give the example of Bitcoin, for example. We could have a customer that wanted to open up a Bitcoin mining and take advantage of this rate. Very speculative business at the moment. You know, last Monday, Bitcoin hit a 6-month low in terms of overall cost. They could take advantage of this. The company could go ahead and build out everything that they needed to do on the transmission, distribution, get the generation, and that company could easily go under. And I use that as a hypothetical. There's a huge amount of risk that's associated with that. And again, it's all the more important why customers who are already being asked to pay on the front end of this with that EDR get some sort of level of protection on the back end. I think that's the last thing I'd say on that is, you know, we do have statutory language down the street, you know, that offers up, you know, that's been alluded to in the openings. I think it was even the company's opening. But it effectively said that, you know, the company would remain neutral, you know, at the end of the day. If that's the lodestar, you know, that's effectively, you know, that we're looking at here. While we are clearly deviating from that. So, you know, in terms of a workaround, which is effectively what we're doing with this tariff, we are on board with that workaround as long as customers are held harmless.
Thank you, Dr. Mark. that will end all the questions I have. Let's go to re-cross-examination. That will go first to Mr. Keevil.
No questions.
Thank you. Mr. Witzmal.
No questions.
Thank you. Mr. Mills.
No questions.
Thank you. Ms. Bell.
Yes, Mr. Mark, you had mentioned a potential Bitcoin customer. You would agree that approval of this tariff would not automatically allow the commission, allow a Bitcoin customer to take service under NKT. It would also require a contract, correct?
That's correct.
And the commission would have to approve that contract, correct?
Yes,
Do you agree that Velvet will pay upfront for the transmission, switching station, the line extensions, and line relocation costs?
that's my understanding.
Who will put up the 800 million investment in the data center facilities?
That Velvet, who will put up Velvet Tech's capital?
Okay. And where would there be stranded investment if Velvet has paid upfront for the added investment already?
I'm sorry, Judge, did you ask questions about stranded investment?
Mr. Mark suggested that the Bitcoin customer could go away and that would
We've kind
potentially.
of been touching on that. I'm going to go ahead and allow it, Ms. Bell.
Sure. This goes, you need the example of ResRam. Again, if Velvet Tech paid for their, distribution, transmission, let's just say hypothetically they covered all of their costs, to be met there. As the tariff that's being proposed up to us, the res requirement based off of the generation that Velvet Tech would be bringing onto Evergy West load would be high enough where customers would then be asked to go ahead and procure more RECs or renewables in some fashion.
Just power agreement.
Is
This
that
is a
true?
good time, Ms. Bell.
Is that
Let me,
true?
sorry. This is a good time to mention, again, anyone on the WebEx, the computer microphones these days are pretty powerful. So if there is someone else in the room with you, specifically counselors, that microphone might pick up the other person. With that said, Ms. Bell, please go ahead. I'm sorry to interrupt.
Would that be true with the purchase power agreement, Mr. Mark, on stranded investment?
Yes. It wouldn't be true under the SIL tariff because, again, that's a customer that is retiring their RECs through the company. Effectively, the company's retiring the RECs for that power purchase agreement, like Newport. It's not the case here.
You would agree under the SIL tariff that it is company-owned renewables, that it's the company PPA, correct?
Yes.
No further questions.
Thank you, Ms. Bell. That takes us to Evergy.
Just briefly, Judge. Dr. Mark, is there any restriction for a customer to go from the PED or the EDR, and then go to the SIL tariff that you know of?
Not that I'm aware of.
Do you know if there's any limitation for the number of customers that may be served by the SIL under the SIL tariff?
No, I don't believe there are.
That's all the questions I have, Judge. Thanks.
Thank you, Mr. Fisher. That takes us to redirect.
Let's start by clarifying a few points. Dr. Mark, when you were going through the tariff, well, first of all, can you find the page that has availability at the front?
Mr. Kleiser, let's clarify, which one are we looking at?
Sorry, I was doing the, since he was using it, I was going to do the combined version.
Thank you.
On there? You had said something on this page.
I'm not there. I'm on availability continued. I gotta point out, you're the one that saved it. All right.
I wondered how you went from page 1 to page 5, but.
Go ahead.
All right, you had mentioned something about how language included here was to make sure customers were big enough. Can you just identify what language in particular you're referring to?
Okay, here we go. Provided and this is the last line, it says, provided the new customer's current load reaches a monthly demand minimum of 50,000 kilowatts.
All right, thank you. Can you find, I'm not even asking for a page, can you just find the part that talks about the whole harmless agreement?
Yes.
Okay. Now, when you were talking about what was put in and what was cut out, you mentioned the fact that we were cutting language that said it was hold harmless and adding new effective hold harmless language. Do you recall that?
Yes, I do.
What is our problem? Well, as you see it, what is the problem with the company's proposed hold harmless language?
The company has effectively a clause at the end of their hold harmless language that they, it's the all relevant factors related to economic development. So the problem that I have with it is twofold. One, that it's not really hold harmless if there's a clause immediately saying that, oh, by the way, we can go ahead and, argue it, that we're not being held harmless, that customers can still bear all these costs. The second part is the nature of the specific item that the company wants to argue, which is economic development benefits, which can be, arbitrarily could be just about anything. We could, Mr. Bush was asked this before, whether or not this would be a contentious hearing. It would be a contentious hearing. The modeling that would go into something like that, the assumptions behind that, the double counting that could exist out of it, it would be a regulatory nightmare.
Why exactly do you think it's so important for that hold harmless language that that the OPC, MECG, and staff proposed? Why is it important to have that in there?
I can't stress this enough, but customers are effectively already being exposed on the front end of this. Non-participants are already ponying up and going to be contributing that 40% discount for a period of time. The hold harmless language really is designed to go ahead and ensure that the non-participants, the rates aren't raised just randomly, that we're just throwing around money to attract clientele that may or may not be stable, or we don't necessarily know, the terms behind them.
Do you believe that kind of hold harmless language would be important to making sure that Evergy negotiates its contract in a manner that will ensure all costs are recovered?
Absolutely. Then I would double down and say that there's existing tariff language that already has the hold harmless. So when Mr. Fisher asked me about that SIL tariff and whether or not anybody could switch through it, or that's the tariff we want, that language, that hold harmless language. We are comfortable with it. I don't know if we were signatory or if we didn't object, but we didn't object, in part because there's language there that ensures that customers are not going to be, penalized for this.
All right, I'm going to move on. You were asked a question originally from the bench regarding the Omaha rate, and in the response to that question, you had said something about non-participants are already paying a cost. You actually just said something very similar again. Just to be clear, how?
On the Omaha rate?
How are customers already going to be paying a cost, non-participating customers?
they're going to be paying the cost of the economic development rider. That, those first few years, that could, I mean, depending on the size of this customer, you know, the period we're talking about, that's about tens of millions of dollars, $50 million. It, you know, 100 Walmarts, I mean, that could be, you know, at full load, until it hits that level, I mean, that could be significant.
Thank you. Okay, I'm gonna move on. Very last questions, I think, are gonna involve this Exhibit 904.
Can I real just quick? The EDR is designed, again, you know, and this has been hit home, but I want to reiterate this. We've got that economic development rider out there that customers take advantage of for, you know, a set number of years, and then they're on the system. They're paying back. Like, that's the give and take that's taking place with customers here. The non-participants are being made whole because we've got that load coming on and they're a viable customer. That's not happening here.
My next question involves Exhibit 904. This is the OPC-MECG staff proposal regarding EDR availability provision.
Yes.
I'm not going to spend very long on here. I want to clear up a bit of confusion regarding renewals. As you would understand it, if customer A renews a contract, are they a new customer at that point?
No.
All right, so when you say 3 customers, you mean 3 customers that how many times you renew?
That's correct.
Okay. And to be clear as to how this second paragraph works, there's a 5-year limitation that gets kicked off when the first contract is approved.
That's correct.
Okay. That's all the clarifying I need to do there. I don't think I have any further questions.
Thank you, Dr. Mark. You are excused. Ms. Mantle, please make your way up to the witness stand. I'll make an announcement to all parties. I intend to go forward with taking Ms. Mantle's testimony tonight. My best guess is that this will not take too long. I've already notified the commissioners and inquired of our court reporter. So we're going to move forward. Ms. Mantle.
I need to move my car, at some point. You know, we're out of here, but in time to allow me to limp to the, parking garage before the elevator closes, that will be adequate, but,
6.
What?
That's 6.
The elevator closes at 6, yes.
We're good.
Okay.
Ms. Mantle, do you solemnly swear or affirm the testimony you give in this hearing will be the truth?
Yes.
Thank you. Please have a seat. Mr. Kleiser, your witness?
All right, I'm going to try to do this on the speed run.
No.
Fair enough.
Please do.
By whom are you employed?
Office of the Public Counsel.
And what is your position?
I'm a senior analyst.
And did you prepare, cause to be prepared testimony, rebuttal testimony for this case that has been pre-marked as OPC Exhibit 201?
Yes.
And if I were to ask you the same questions that were posed to you in that testimony, would your answers today be the same or substantially similar?
Yes.
And are those answers true and correct to the best of your knowledge and belief?
Yes.
And do you have any corrections?
No.
All right, I would like to offer OPC Exhibit 201.
You've heard the motion by counsel. Are there any objections to the admission of Exhibit 201 onto the hearing record? Hearing no objections, so admitted. Go ahead.
I turn to the witness for cross.
And we are going to cross-examination of Ms. Mantle. First, that'll go to Mr. Keeble.
See Mr. Keeble waving?
Is that a no?
That means, yeah, waving cross.
Okay. We move to Mr. Woodsmall.
No questions.
Next, we move to Mr. Mills.
I have no questions. Thank you, Your Honor.
And Ms. Bell.
Yes, Ms. Mantle, good evening. You would agree that the policy of the renewable energy standard is to encourage renewables and ensure at least enough renewables are used to cover some percentage of the load?
I'm not sure what the legislature's intent was, in drafting the statute that created the renewable energy standard. I do know that it asks, or it requires, renewable energy to provide 15% of the electric sales for the electric, investor-owned utilities in Missouri.
So just to clarify, it's at least 15%, correct?
Beginning in 2021 and continuing thereon, yes.
And you would agree that in Missouri, electric utilities have increased their renewable energy percentage of load since the adoption of the statute, correct?
Yes.
You would also agree that the commission has adopted a regulation that governs both the renewable energy standard and RESRAM, correct?
Yes, they have rules.
And you would agree that their rule contains an authorization for them to provide a variance from the rule, correct?
I have not looked at that rule recently. I do not know that for sure, but it is likely.
Are you aware if any electric utilities have applied for a variance from the RES rule?
I'm not aware of any.
And you're not aware of, are you aware that the commission has granted any variances from the RES rule?
Now that I've had a second pause, I do believe in the last RES report, and I'm not for sure for which electric utility, one of the utilities did ask for and receive a variance having to do with
Thank you.
small customers. So yes, electric utilities have requested and been granted variances.
Can you take a look at the Evergy Velvet stipulation, paragraph, Schedule 1, paragraph 6?
I'm there.
Have you reviewed that provision in preparation for today?
Yes, I have.
Did you also review the stipulation that was filed?
I did read it, yes.
So let's assume a hypothetical where the variances as described in the Evergy and Velvet stipulation were granted. Okay?
Okay.
And the paragraph 6 in the tariff is granted, correct? Okay?
Did
Are
you
you
say
with me?
paragraph 6 of the tariff?
Of the Schedule 1 stipulation, the paragraph 6 you're looking at now. Paragraph 6 of the Evergy and Velvet Schedule 1.
Yes, I was just confused because variance is also paragraph 6. So I want to make sure I was clear.
Okay.
Okay.
So we're assuming a hypothetical where the variances requested in the stipulation are granted, and the tariff language attached in paragraph 6 is also adopted. We're also going to assume the MKT customer documents that RECs have been retired sufficient to cover more than the RES renewable requirement, currently 15%. Under that hypothetical, would you agree there would be no additional costs under the renewable energy standard?
I paused because there is also a 2% solar requirement in the renewable energy standard. If you assume that RECs are retired for at least 2% of the renewable standard is from the solar REC, and you make the assumptions that the variances were granted and the language was legal, then there would be no cost then, additional costs for the customers.
Thank you. No further questions.
Thank you, Ms. Bell. That takes us to Evergy.
No, thank you, no, thank you, Judge.
Okay, Evergy had no questions. That'll take it to commissioner questions. Again, we do have commissioners on the WebEx. It is *6 to unmute if you're on a phone. Are there any commissioner questions for Ms. Mantle? Hearing none, the bench does have one question. Would you clarify or elaborate on your concerns with the MKT tariff customers exclusion from the RESRAM?
And again, as staff witness Eubanks said, there's a difference between exclusion from the RES and exclusion from the RESRAM. And an exclusion from the RESRAM means they just don't pay the cost. And my biggest concern with their language is I'm not an attorney, but I believe it's illegal. I believe the statute says sales, and it means the retail sales. It doesn't say sales except for customers who got some type of renewable source or some way to retire RECs, and they don't count as sales. They still do. So, and when you're talking about a net metering customer or something, they don't have the sales aren't there because that's been covered. So, you know, I have a concern that it's not legal. And, you know, a few other things that I've heard is it's been kind of concerning to me. One of them is, well, or I don't know that I've heard, but the thought is, well, it's just 15%, it's not that much. And so I did a little bit of calculating this morning. If you have one customer, 115 megawatt customer, which is the smallest customer that can be on this MKT schedule, at an 85% load factor, that means at 85% of the year, they're at 85% of the load. If it's 100 load, then that would be 85 megawatts every hour, at least. Okay. The annual megawatt hours for that customer would be 1,116,900 megawatt hours. And that's just simply 150 times 8,760 hours of the year, 85%. And I went to Evergy West RES plan that was filed in EO-2021-0348. That was their RES plan that they filed this last summer. And from that, I got their projected load for 2023, and that was 8,347,727 megawatt hours. So this one customer would be over 13% increase in load over that projected load. So that means that the RES standard, the RES requirement goes up 13%. Now, if the MKT customer is exempted from paying for any of that, that's 13% of the and that other customers have to pay. Of that, you know, and that would be 167,535 megawatt hours. Of that, 3,351 are solar megawatt hours, and then the rest can be generated from any renewable source. So, you know, the idea, well, it's just 15%. 15% of my load isn't much. 15% of one MKT customer is a lot. So, and, you know, and we're talking just one load at the minimum level. So it shouldn't be just, well, this isn't going to be very much. It's not going to be much harm to customers. Another thing is, I've heard is, well, Evergy West has a surplus of RECs, doesn't it? So what's the big deal? Well, the RECs are currently, the generation for those those RECs is currently paid for by customers through the FAC. And guess what? This customer won't have to pay the FAC charge. So, and it's not like these, what they are is purchase power agreements. Evergy West pays a set amount per megawatt hour. Now that's offset by revenue from the SPP, but 98% of the months that I've looked at, and I've looked at all of them since 2008, that has been a loss for customers. We're talking about hundreds of millions of dollars customers have paid through these PPAs for wind power. And this MKT customer will not be paying for any of that. So that's another one. And there's also a renewable energy contribution charge that's in the contract, the sample contract. And it's so like, oh, that sounds good. But there's nothing that says how that money is to be used. Evergy West can pocket that money. It doesn't say that it's going to offset these costs that these other customers have. Now, that is one thing that the OPC and staff and MECG tariffs is. It requires that money to go to offset rest cost. So, I mean, that's a lot, and that's some of the things that have really concerned me, listening in on the hearing in the last 2 or 3 days. And I sit here and I'm not even for sure I answered your question.
You did great, thank you. I'm going to stop there. I'm very satisfied with that. Thank you very much. Where are we at? We're at recross, and that goes to Mr. Keevil.
No question.
Thank you, Mr. Woodsmall. And that goes to Mr. Mills.
No questions. Thank you.
Thank you, and Ms. Bell.
No questions, Your Honor.
Thank you, and Evergy.
No questions, Your Honor.
Redirect.
Real quick. So just to make sure I understood your point regarding the FAC that you explained in response to the judge's question. Evergy is currently receiving RECs that's using to meet its RES requirement that are actually losing money. They're receiving RECs through PPAs to meet their RES requirement. Is that accurate?
I'm not sure exactly which PPAs because I have not been able to get that from Evergy, but all of their PPAs are losing money, are costing customers money. So, and they supposedly retire some of those RECs to meet the RES.
Okay, and the loss of that money is being flown through to customers through the FAC?
Yes.
So, all the other customers are paying for these RECs that will meet this requirement that MKT customers won't have to pay for?
If the company's tariff is adopted, that's correct.
I'm going to leave it at that. I have no further questions. Thank you.
Thank you. Ms. Mantley, you are excused. Mr. Fisher.
Yes, sir.
I am prepared to receive a motion from you for Exhibit 5 to be adopted onto the hearing record. I do not recall if you made that motion, and I failed to write it down, but I don't have on my sheet that it was made. So would you please make that motion?
What was it?
Direct testimony of Mark Stombaugh.
Yes, Judge, we would move that be received into the record and any other, the pre-filed testimony that we did not have introduced.
No, just that one. You've heard the motion. I'm seeing shaking of heads. Any objections? No objections. It is so admitted. And staff, I can confirm I have all of your exhibits, 100 to 104. Velvet, Ms. Bell, I just want to restate where we're at. You will have Exhibit 301, the SIL tariff. 302, I think you can probably skip. That was the solar that was introduced.
Yeah, that's 104.
As 104 by staff. Ms. Bell, your next number is 303. That is the special contract rate from 141, 142, and 143. Exhibit 304 is the staff brief from case number EO-2019-0244. Exhibit 305 is the non-unanimous stipulation from that same case number ending 0244. And Exhibit 306 is the stipulation that is dated September 25th, 2018 from case is ER-2018-0145 and 0146. And you have until Friday to submit those, and the other parties have until Monday to file objections. Ms. Bell, can you confirm that I'm correct?
Yes, and Your Honor, I have one more addition,
Okay, go ahead.
and that's the non-unanimous partial stipulation and agreement in EO 2014-0151.
Any date, or is that the singular stipulation?
We'll date it just to be sure. It is dated October 20th, 2014.
What case is that?
It's case EO.
No, I mean, what,
Ms. Bell, can you give us one sentence synopsis of what this case is?
Sure. That is a non-unanimous stipulation where parties proposed various variances to the res requirements, and the commission approved that stipulation.
Okay, Ms. Bell, we will add that to the list for you to submit it by Friday, subject to objections due by Monday. That is also, just to reiterate, our due date for the expedited transcript. Mr. Kleiser, I can confirm I have all three of your exhibits. Was that a question?
Yes.
Yes, you have a rebuttal testimony of Dr. Mark. You have the surrebuttal of Ms. Mantle. Did you move for the demonstrative 202?
I was going to bring that up. We had talked about it yesterday. I would offer it up tentatively, and then if the parties would like to propose a cleaner version in the interim, they can, but I would like to offer it now tentatively, be submitted by Friday.
I'm just going to do it now.
Fair enough.
202 is OPC's comparison version showing the two different versions married together, for lack of a better description. Any objections to Exhibit 202 being admitted onto the hearing record? Hearing none, so admitted.
Your Honor,
Yes,
one
go
more
ahead.
thing.
Uh-huh.
I believe I would also like to offer the stipulation and the attached schedule into the evidentiary record.
Evergy would join in that.
if we do that, then we're gonna need to put ours in.
Okay, and we will also do the same for the other side. Let me grab that. Okay. Question first, do we have any preferences for the stipulation and tariff to be one exhibit, or the stipulation as one exhibit, tariff as one exhibit?
Judge, this is Roger Steiner, Judge. I think I'll give you one because the tariff's an attachment.
Excellent. Let's go with one. We'll do one. We're going to call this an OPC exhibit. Thank you for volunteering.
203. Go. Yes, 203.
Exhibit 203 is the stipulation and attached Schedule 1 of OPC staff and MECG. Are there any objections to the admission of OPC Exhibit 203? Hearing none, it is so admitted. I'm going to call this an Evergy exhibit. Mr. Fisher, do you agree with that?
Yeah, I think we're up to 8 now.
Yes, 8. Exhibit 8 will be the non-unanimous stipulation and attached Schedule 1 tariff language from Evergy and Velvet marked as Exhibit 8. Are there any objections to the admission of Exhibit 8 onto the hearing record? Hearing none, it is so admitted. Mr. Woodsmall, I've been trying, Ms. Bell, go ahead.
One last exhibit, Your Honor, 307, Schedule PED.
Okay, let me get my paper. No, we did 307 was the non-unanimous stipulation from EO 2014-0151.
Okay.
So
then
this will be 308?
Correct.
Okay, and tell me what it was again?
Schedule PED from the Evergy West tariff.
All right, and Ms. Bell, please, same as with the others, submit that by Friday. The other parties will have until Monday to object to that. Anything else, Ms. Bell?
No, Your Honor.
Thank you. And Mr. Woodsmall, I have 4 exhibits I can confirm, and I see a head nod, and I believe those 4 are coming in on Friday.
No.
No.
901, 902, and 903 will be offered on Friday. 904 was the response to Exhibit 7 that you accepted
Yes,
already.
thank you. 904 is already accepted, and I apologize, I had marked down 900. It's 901, 902, and 903.
Okay. So it's 900, 901, 9, okay. Please state it again, just so I'm clear.
The commission's brief would be 901.
Okay. Correct.
The Evergy brief would be 902, and Nucor brief is 903.
Right. And then the one you accepted was
904, it's in.
Thank you, Your Honor.
That takes care of exhibits. We are within a couple minutes of finishing the hearing. Are there any other matters before we adjourn?
We have a briefing schedule already set.
We do have briefing schedule, and
February 8th and 18th.
yes, there you go,
Thank you.
18th. That's it. Thank you, Mr. Keeble. I don't have anything further. We are adjourned and off the record.
Get your thing.
All of our
Thank you.
users on WebEx, thank you very much, and thank you for your patience through our technology issues. I will be closing the WebEx now.